Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Dati mihi Anglican for his service Latino. Oh, for Trump's sake.
Is that correct?
Good morning, good Tuesday morning to you. Oops, that's louder. This is quieter. Got it figured out. Oh, let's see. Where are we at? Where do we start on a day like today? I've got an idea. Let's start right here. This is our number right now. J Hatch, in case you're curious, in case today is the day to write the check. I think the Kowalskis will be okay with me pausing this at any point and you just filling out that number. So just let us know. Say the word and I'll make it stop. Say the word and I'll make it stop. All right, but here we are. That's the settlement that the Kowalskis are due right now by J Hatch, and it's going up. It's going up by $57,000 a day and change. Welcome to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for being here today. I've got just a few things I have to do, and I have to do them unfortunately in the wrong order. So we're gonna go like
send someone with more experience.
I would do that, but they're expensive. We're gonna go like this. First of all, we're gonna say, and that's not there. So let's try that again. How did I break that at the last minute? Okay, here we go. There we go. Samantha Terry, one of our great mods. Thank you very much for gifting 10 memberships this morning. Followed by Bug Dugger, who gifted another 5. Thank you. That's 15 brand new or old people back in green. That is wonderful. That is amazing. But we have to celebrate Katia, I said it right, Katia Pickerel, who...
Somebody just sent me a video of roaches fighting.
Hang on, Judge Boyd.
I don't know who won.
We have to celebrate Katia Pickerel because she was first in chat today. And being first in chat comes with its own punishment. Katia, I believe this is a first offense for you. If you have done this before and you were not caught, you got off scot-free. Lucky for you. Now this is going on your permanent record. You said it right. Only took two reminders as to how to pronounce your name, but I got it this time. Congratulations, Katia. The internet is all yours, at least until lunchtime when we go live again. And you're just responsible for making sure it works for everybody else in the world as well. So if you can do that in addition to whatever other duties, say like work or homes, responsibilities are on your shoulders, we would appreciate it. Thank you so much for that. Let me tell you what is going on here. Oh my goodness, we have big things. Kim S just gifted 5 memberships as well. Thank you very much, Kim. It's 20 new memberships went out the window this morning. Hopefully you had your settings turned on to receive gifts on this channel because they are flying. They are flying. Let's see. If we have any birthday things, we need to handle that right away. Let's see. If there's a birthday buffer command, that would be great. Let me tell you, because things are happening behind the scenes. There it is right there. Yes, Dodie Sweeney. I forgot your birthday is definitely today for sure. We're going to sing to you as well as Sullivan.
Correct?
The way this works, this is one of the world's largest sing-alongs for birthdays, so you can participate too. You actually have already agreed to participate by being on the channel. It's in the fine print. Just trust me, it's there. So you know the words. It's the happy birthday song. We're singing to Dodie Sweeney and Sullivan. And everyone, remember your parts, just like we practiced. Shoulders back, project to the back of the room. Try to blend your voice with your neighbors. Everybody warm up with me? La 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 la. We're good. Okay, here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Dodie Sweeney and Sullivan. Happy birthday to you. That was pretty good. I was feeling that one. Dodie Sweeney and Sullivan. And I imagine there's a couple other birthdays in here as well that might be filtering in. Happy birthday. Thank you for spending your special birthday here with us. It's not lost on me that you could be a million places, even getting free pancakes at Denny's. Because they do that. I don't just make that up. I think Denny's gives you a free plate of pancakes on your birthday. So, thanks for being here. Thank you. It's a wonderful day to have a birthday. Thanks for letting us celebrate with you. All right, we have to get ready to go to court. I'm sorry, it's a rush. We've got to. You're welcome, Dodie. Thank you very much. Thanks for waiting around for your birthday song. We have to. My daughter says your birthday song sounds great. Dawn's daughter. Thank you. What's Dawn's daughter's name? We need to thank her in person. I mean, like by name. We need to go to court. This is what's going on. Let me show you. It's there. It's just the wall. But let's see. Upstream here. A. Okay. We are when court starts this morning. It's going to be spicy. It's going to be spicy because we initially thought there was going to be a motion filed this morning to disqualify the judge. The Tucker said he's going to file this motion. It's going to be here in the morning. And he's like, and that's going to bring this to a grinding halt. Well, in a way, he's right. Because the way the law is written in Florida, the judge, it ties the judge's hands. He has to do two things. He has to stop, drop, and rule. He has to stop what he's doing immediately. He has to drop everything else and address and read the motion, make sure everything was right. And then he has to rule on the motion. It's him that decides if he disqualifies himself. You might seem that's the fox guarding the hen house, but this is the way the court system works. This will be reviewed by the appellate court if he's convicted. And if it's overturned there, it would look really bad on him. So he has to do a good job here. But I just got word from our good friend Greeners that there is another motion. Let's see. I haven't even opened it yet. There it is. Boom. Email. Let's see. There's the doc. Okay. There may be just one more motion. Need a burglar in the thumbnail. I just added the judge in the back of the truck. Did you see that this morning? I added an angry judge. Let me see if I can get this up on my... let's see, which device should we do this on? Where's camera 7? Why is camera 7 not working, people? We need camera 7 to work. Okay, it's plugged in. Let's see if that helps. Usually it helps when we plug it in. If you tried turning it off and on again. Checking all the cables. There's only one more end to unplug and plug back in again. What is on camera 7? Is my mouse over there? I see nothing. I see nothing at all.
Have them send someone with more experience.
It's just black on my screen. All right. Well, that'll make it a little harder to do this. Let's see if we can send it to the other computer. And we'll run it that way. Let's see, where's our... Oh man, court's already starting. I'm just gonna have to read this as it is. Just on my phone. Here we go. This is a motion from the defendant, Franklin Tyrone Tucker. Comes now, the pro se defendant, Franklin Tyrone Tucker, hereafter Tucker, files this motion for continuance to allow adequate time for the defense to prepare and properly serve a motion for disqualification of the presiding judge in this case, the Honorable Mark H. Jones, on the grounds that the defendant does not believe they can receive a fair trial and impartial trial, and that the deadline for filing such a motion is 20 days from the date of discovery of facts which give rise to the motion. So he has a 20-day window to do this. The date of discovery for this motion will be recorded in both the motion and the required affidavit as January 22nd. So that was the day that he discovered it. The defense would also proffer that because the motion for disqualification is being prepared during the course of trial and in the instant case, that no further action can be taken in the immediate cause without first resolving the issue giving rise to the motion for disqualification. This is not the law. This is what they're saying. We think that this should, because we've told you it's going to be a motion for disqualification, you need to stop. That to continue the trial under these circumstances would only cause the defendant to suffer the exact miscarriage of justice the motion for disqualification is seeking to avoid, resulting in denying Mr. Tucker his constitutional right to a fair and impartial trial by a jury of his peers. Therefore, the defense would move this court to grant this motion for a continuance of 10 days, which is exactly half of what is provided for in Florida Rule 2.3030, when disqualification of the judge occurs during trial. Basically, they ask for 10 days. The judge gets 20. He's asking for a continuance. He's saying stop. He's saying stop. I'm going to file a motion. The law, here's where this is bizarre. It's going to be spicy because this is where I'm going to put my money where my mouth is right here and say, I believe that the judge is going to reject this motion for continuance. And in rejecting the motion for continuance, he's going to say, we're moving on with court. We're progressing as intended. And this can happen a couple ways. Mr. Tucker can say, okay, I'm going to call my first witness, or Mr. Tucker can say, okay, in either case he disagrees, but okay, but I don't have any witnesses ready. And I don't have my motion for disqualification ready either. So
Circuit Court of the 16th Circuit of the State of Florida is now in session. The Honorable Mark H. Jones, Judge presiding.
we might go straight to closings.
Okay, State versus Franklin Tucker, 2017 CF 841. Everyone's here, so are we ready to proceed with the defense evidence?
No, Your Honor. I filed a motion for continuance based on disqualification that I'm filing.
Could you elaborate, please?
Well, I filed a motion for continuance because the was it 2.330 of the Judicial Administration? It gives you 20 days to file the motion for disqualification, and in order for it to be procedurally sufficient, it's going to take a little bit of time because it requires service, etc. So I took and I asked, again, I put in a motion for continuance for 10 days, which is half the time, to get it ready.
State? Judge, we would object to that. We are here. We have a jury waiting for us. The state is prepared to go forward. At this time, that would be, to us, a fabricated delay, and we would object to it.
Yeah, the motion is denied.
No, Your Honor, if I may be,
Sir, I heard what you had to say. Is there some rebuttal argument?
Yes, there is a rebuttal. It actually does say during trial that yes, this still is applicable, and that yes, because I am afraid of not getting a fair trial, it seems like denying the motion and not allowing me the time to file the motion to disqualify would just be a way of circumventing the motion to disqualify.
Denied. So, you ready to present evidence this morning?
No, Your Honor, because again,
okay.
We're going to closings.
I did go ahead and, I got the Chief Justice involved with this, just to make sure that we can get this, cleared up without as little as more. What's the word I'm looking for? But the thing is, Your Honor, the idea that I'm going to get a fair trial at this point when I'm not being allowed to present a defense, you already told me that you're not going to allow me to call Todd O'Quinn because you won't issue an order for me to get him here. I mean, there's no chance of me getting a fair trial.
I'm not going to go and rehash what happened yesterday. There was never a motion submitted nor pending for such relief. So in any event...
Your Honor, you said you wouldn't give it to me.
In any event, sir, so you do not have any of the supposed witnesses that you were instructed to have that you said you were going to have today?
Your Honor,
Sir, I'm just asking you a straight...
I'm giving you an answer here, sir. Mm-hmm. After what you told me yesterday, I called those witnesses and told them no. You don't have to come to court today because, again, Your Honor made it very clear that you weren't interested in my witnesses.
Okay.
Going to closings.
You have some response to Mr. Tucker's defiance of the court's instructions, his lack of preparation?
I think the court's been more than indulgent for his request. The court never denied him anything yesterday. He's got no witnesses to present. The state would request that we keep moving forward.
Okay.
If he's going to rest this morning, Judge, the state does have a rebuttal case that we're prepared to present. Mm-hmm. Want to go ahead and
he won't rest.
You say if he's willing to rest, I
won't rest.
Didn't hear anything to that effect.
Okay, well, at any rate, Judge, depending on where we go today, if we're able to get to it, the state does have a rebuttal case to present, narrowly tailored to the evidence that was presented by the defendant yesterday through Paula Belmont's testimony. And as far as the defense witnesses, I have no, the Your Honor's put them on notice that they should have been here today. And if they're not, we would request that the court continue moving forward with this trial.
So, any response to that, Mr. Tucker? Because
Your Honor, again, you made it very clear yesterday that you even went as far as to say you didn't care what I had to say. So, I mean, the idea that, I was going to have those witnesses here and ready to go in lieu of yesterday, I mean, if you would like to give me a day to get them here, sure, I can get witnesses here. But the thing is you made it very clear to me yesterday that you weren't interested in that. And if you are interested in letting me present the defense, I'm more than happy to.
In any event, I'm looking for any input from the state because he was told to have the witnesses here. He doesn't have them here.
I can even tell the court the witnesses that he wanted to bring in today, I don't believe are even under subpoena.
Mr. Walker and Lieutenant Scavilia, their subpoenas were expired, but they were willing to come in today to testify. The defendant, it's our understanding the defendant called them off. Told him not to.
Okay, so you don't want to present them?
No, I do, Your Honor, but I need to be able to do it, Your Honor.
Sir, you've had opportunity, so
if I may make a judicial notice, then again, I am objecting to moving forward, and I'm being forced to.
Yes, sir. You announced ready for trial. You've been given ample opportunity to present your witnesses.
I don't think so.
And you have apparently decided you didn't want to.
I was told. I was told.
Sir, I know you're going to repeat the same things, and that's fine. But at this particular point in time,
if you're going to force me to go to close, I mean, again, it's a mistrial.
Excuse me, sir?
It would be a mistrial, Your Honor. You're not allowing me to provide a defense.
Sir, you can state and twist and spin whatever you'd like to. The fact of the matter is there's a clear, unequivocal court order that you have your witnesses ready to go, that you refuse to abide by it. So that's the bottom line. And I'm not going to really argue with you anymore, sir, because...
Was it a written order, Your Honor? Because I haven't seen it.
It was verbal, just like...
Maybe I misunderstood then.
No, sir, you didn't misunderstand anything. You said, in fact, I'll have the motion to disqualify. Okay, you don't have the motion to disqualify. I said, have your witnesses here. So in any event, I'm not going to argue with Mr. Tucker. So,
okay. Your Honor, I'm going to have to file an appeal on this decision now.
Sir, file whatever relief you want to see. That's all part of the process. But in the meantime, we're going to go forward with the trial in one fashion or another, so I'm just looking for some input from the state.
Sure, Judge. So just so the record is clear, Your Honor had directed the defendant to have his witnesses here yesterday. We got through Ms. Belmonte. The other witnesses weren't here. Your Honor gave the defendant, he said he'd have them here today. They're not here today. The state would request that we go forward. If the defendant is going to present anything else, then the defense needs to rest, and the state plans a rebuttal case.
Okay. So I'm going to take a moment to reflect on these developments. I believe I told the jurors to be here at 9:15, so I will reflect upon it and be back in a few.
judge is going to go gaze into the reflecting pool for a moment and ponder the developments. I don't want to say I called it, but I think the judge has played his hand and was shown his cards. And so this motion for a continuance was never going to go anywhere. I think Mr. Tucker, the wording of the document that I read, the motion for continuance, although it's worded very appropriately, like it was almost even written by a lawyer. The motion for continuance, it was basically saying, because we're filing a motion for continuance, we believe, and telling you that it's for the purpose of filing this other motion for disqualification, we believe it should have the same effect on the trial as if we had filed the motion for disqualification, which would bind the judge's hands, force him to stop, force him to read it, make sure everything in the motion was correct. So like I said, it's a very difficult motion to write, which is why he's asking for the continuance. It has to have dates and timestamps and screenshots and receipts, and every single bit has to be correct, because that's one of the steps the judge has to do, is make sure it's perfect. And then if it is perfect, the judge then has to stop and respond in written order, meaning he has to go back to his office and type it up and respond and address that, and either rule to disqualify himself or to deny the motion, which I bet he would deny the motion then too. But Tucker thought he was going to get that relief. He should not have canceled his witnesses, in my opinion. It's we need to have the counter on. Sorry, I was so caught up in what was happening here. Just one second. Let's see. That's not it. It's not replay. We need to update the graphic to be counter law 101. There's that. There's that. Okay, so how many times did I miss? We had 75 yesterday. How many times was we instructed today? I'm thinking 3. Did we get 3 right there? Can we have a little vote of how many additional counter ticks we need to add? I'm going to put 3 on because I think that's I think 5 says Katia. 3 from Angelique. 4 from Shih Tzu. I think we've got 5. Got a lot of 5s. 3.5. I can go with 5. It was a lengthy, and even though it was all tied together, the number of times there were assertions back and forth and corrections, I think 5 might be appropriate. 100 is a little high, Lee. A little high. That might be where we're at by the end of the case. But honestly, let's see. Equinox, did he read his motion? Yes, I read his motion. I've got it right here on my burner phone. Thanks to Greeners. I appreciate you sending this to me. The motion, it says, that they discovered that the judge was not going to be fair yesterday, and they have 20 days from when they discover it to file the motion. They've asked for 10 days of a break to get the motion ready, meaning that they've got a 20-day window to file the motion. And so they're saying we ask for half of that to get ready to file it, which would basically be keep them within the window that the trial was supposed to end by February 2nd, right around that period. And they say the defense would also proffer that because the motion for disqualification is being prepared during the course of the trial, in the instant case that no further action can be in the instant case that no further action can be taken in the immediate cause without first resolving the issue giving rise to the motion for disqualification, that the continuant to continue the trial under these circumstances would only cause the defendant to suffer exact miscarriage of justice that the motion for disqualification is seeking to avoid, resulting in denying Mr. Tucker his constitutional right to a fair and impartial trial by a jury of his peers. So they say this is basically, they want the judge to treat it as if they had filed that motion. But that motion is the one that makes this stop. That's where the law is written, where it says, any other motion the judge can just rule on, as he has. But they did not file the motion. If they can rush it and prepare it and file it before the end of court, then he'll get it in. But I don't think rushing it will serve him any good, because it won't have the content that it needs to have the effect he wants. Okay. Little Miss says, based on what I've read, he has grounds for appeal. Appeal has been granted for far less than this. I believe he does. But here's what else I believe, Little Miss. The jury has not seen any of this spiciness. Okay? They've seen Mr. Tucker try to be polite and try to present evidence and try to represent him in court. In the presence of the jury, If you just put on the blinders and say, what has the jury seen? What evidence have they seen? And what do they know? There is a very good chance that Mr. Tucker, even in spite of all the stuff we've seen outside the presence of the jury, will be found not guilty. I would say there's a very good chance he'd be found not guilty when you consider what evidence the jury has heard. So is it terrible that this moves forward? It might not be for Tucker. It might not be terrible. He might get the acquittal that he's looking for. Judge is going to take just a couple minutes, probably be back in just a few, within 2 or 3 minutes. The jury's been there for 1 minute. They're waiting. Let's see. When the judge says he's taking a moment to reflect, do you think he's going to do some quick research, whether he's right or wrong? Yes, and I wonder, actually, Christopher, we heard Mr. Tucker say, I've actually consulted or gotten the Chief Justice in the loop. I wonder if he's going to make a phone call. He's like, Chief Justice, is there something going on here? He's saying that you're involved, just friend to friend. Are you feeling that something's going wrong here? I wonder if he's calling a friend and saying, what's up here? I think Mr. Tucker has. I think the judge used very very poorly worded comments during the course of the trial, which are improper enough to grant an appeal. He did say to Mr. Tucker, I don't care what you have to say, when Mr. Tucker was rightfully making an argument before a ruling. And he cut him off and said, I don't care what you have to say. That's a problem. That's a problem. How many times does a judge get to phone a friend, right? But let's see. He's not prepared for closing. He's not prepared for trial. That's plain. His witnesses. This is one of the difficulties of representing yourself, getting witnesses to trial, scheduling them, subpoenaing them, everything. It's tough. It appears the state hasn't proved anything to the jury. I agree. I believe they have not. I actually thought that there could be a good argument for a judgment of acquittal or a directed verdict, but I can also see the judge's side in not doing that, because by the strictest view of the evidence, yes, or the light most favorable to the state, yes, they have presented something that indicates that he could be guilty of those crimes. Appeals rarely get granted. Yeah, and they take a long time to get heard. So, I mean, if he gets convicted on this, it means several more years before a possible appeal. I am Dave. Thanks for the kind words. Appreciate the likes on there. That does help us out a ton if you're able to click that like button. If you don't like it, just click the like button twice. Let's see. Wait until Tucker's 3-day closing statement. It won't be that. The judge will cut him off. The judge is very set on moving this trial forward. And even though they're way far ahead of schedule, I don't think he will allow even another day of delay. The judge is in his office screaming, I'm not even supposed to be here today. Yeah. It's prolonging the trial. I don't think he's doing it just to prolong the trial. I think Tucker believes in the motions he's making. He believes in the arguments he's making. He's lived it, that he's been there. He's in the middle of it. Unfortunately, he's emotionally invested in all those arguments as well, which I think makes it more difficult for him to make a motion just on the facts and the law and the way the court needs to operate. Instead, it gets tied up with emotions, and he gets very frustrated. Closing arguments. Sometimes there's a lot of times. Sometimes there's not. Usually, I mean, for a case like this, I would be surprised if either side got more than 2 hours. I'm putting jury nullification on my bingo card for Tucker's closing. Oh, greeners. Oh, my goodness. Can you imagine? I don't think he needs to do that. Jury nullification is basically, yes, I'm guilty, but the law is bad. Strike down the law. Let me go because the law is bad. Judges hate this. Most attorneys hate this. It's a very hotly debated concept. It's going to be, it's crazy. 20th Century Foxy, how are you doing? I think you had a Y on your end on the end of your name yesterday, if I'm not mistaken. Let's See, Lulor says, joining in from the dealership, waiting for an oil change. Can't wait to pass the time with y'all. Well, what a thing to watch during an oil change. Let's see. I don't think he believes that. I think he can con people into believing him. Let's see, we've got somebody on the phone right now.
Call from Bree.
Hello, Bree. How are you doing this morning?
Good. Good morning. How are you?
I'm doing great. I just know I might have to cut you off as soon as the judge comes back, so talk fast.
I just have a quick question. His counsel that's helping him, are they allowed to step in? Like, literally, if this dismissal should be something that should be serious, and he's asking for a continuance which is within the law, can his counsel step in and say, no, this is what needs to happen?
No, they can't. They're not like the standby counsel that's sitting on the bench next to him.
In person.
He has, I think, at least one point in the trial before. My hair's like sticking straight up. I just noticed that. That's funny. He has at least one point in the trial talked to the judge and said, Your Honor, can I request a short break so I can confer with counsel? Counsel is sitting behind the bar. So he leaves, goes behind, whispers with them, talks to them, and then comes back. On breaks, he can talk to them, but they can't like pass each other notes and whisper in the ear, this is how you need to word it. You need to say objection. He doesn't have that level.
No,
they're more like
absolutely.
It's more like a phone a friend.
I just didn't know if like this could really be like if the continuance should be granted and maybe he's not getting the full effect of his argument and it could really impact his freedom, let's say. I didn't know if they would have the availability to step in that situation because it could be egregious.
Yeah, it's bad, but this is one of the things that the judge says, if you proceed as a pro se, you're not going to have this at your disposal. You're not going to have a lawyer to walk you through this. That's part of the big warning that they give him at the beginning. So
100%. I just don't know if anybody ever expect to get to a dismissal of a judge request with a pro se.
It's crazy. For a pro se, he is one of the most informed pro se defendants we ever have. And thankfully, he's not also like a soft sit because that would just be a disaster. But he is doing, to get rid of my wallet. Okay, there we go.
Could you imagine if this case was being ran by our guy out of Thurston, if he was the one doing this for himself?
Oh, man. Crazy. So
okay.
All right.
That was my only question. I just didn't know if they could step in for that. So thanks for taking my call this morning. And hi, Chad. See you guys later.
See you. Bye. Thanks. Bye. All right. I think at this point he can't just like switch back to getting a lawyer. It's a decision that once it's made, I think it's final for the court. So unless something drastic happened. Let's see. My kid's personal Uber driver says, not going to lie, I watched some of his YouTube videos last night, and I actually feel more like he's guilty now. I've been avoiding some of those. I think the judge might be coming in. Hang on. I've been avoiding some of those because I want to just view this as the jury sees it. Here we go.
So we're back. Tucker, 2017 CF 841. Court having deliberated upon the latest development in this case, finding that contrary to the court's instruction that the defense does not have any evidence or witnesses to present this morning, despite the fact that knew that the jurors were coming in, knew that the case was underway, despite the fact of not having any witnesses available yesterday afternoon. So, in view of all the developments, the court finds that the defendant's case is complete. And we're going to go to any rebuttal.
Yes, for closing.
Then we will excuse the jurors. We will have a charge conference. And tomorrow we will have closings. So,
very well, Judge. Your Honor, would you like me to proffer to the court what my rebuttal case will be?
Yes.
Okay, so we've got Officer Daniel Malone here, former Officer Daniel Malone, and we intend on playing some excerpts from her interview with Paula Belmont at the hospital the night of the crime. They're on body-worn camera, so I've got the thumb drive here with the excerpts that we intend to play. These excerpts will completely rebut the testimony that the defendant introduced yesterday through Paula Belmont's video deposition testimony. In that video deposition testimony, she talked about how she could tell it wasn't Tyrone Tucker, the second person, et cetera, et cetera. Well, on this video, which was the night of the crime, she completely rebuts that and refutes that with her statements to Danielle Malone. In addition, Judge, Paula Belmont gave a deposition back in May of 2019, and the state also intends to elicit portions or to enter into evidence portions of that deposition, again, that directly contradict or rebut the testimony that she gave yesterday. I've prepared the list of the statements that the state intends on using for the court to review if the court would like. I've also got copies for the defense here too.
Your Honor, I would probably be objecting to hearsay, but, you know, or at least like to know the exception that we're going to use here.
Judge, it's a prior inconsistent statement of the witness, and it's coming in to prove, that she made an inconsistent statement, which is different from the statement she made yesterday in the testimony that the defendant put on. The defendant put the testimony on. It's evidence that he introduced into this trial, and it's the state's right to rebut that evidence with a prior statement made by that witness that is inconsistent, just like with Travis Johnson. Travis Johnson was on the stand, and he was impeached with his prior inconsistent testimony. The defendant put the witness on yesterday. It's evidence that he introduced. The state's rebuttal will be tailored to inconsistent comments or statements made by that witness that rebut what she was trying to testify to yesterday.
Well, if it's an inconsistent statement and not something else, then it's an exception to the hearsay.
Okay.
Yes, sir.
And, Your Honor, since I haven't had a chance to look at what the state's offering, if I remember correctly, did you just say that we are going to be adjourning for the day somewhere in here? I just want to make sure I heard clear, because then I'd have time to take a look at what they're offering.
Judge, when I'm handing the court, when I give the defendant, are the excerpts from the deposition that I intend on eliciting. My plan, Judge, is to simply move them in and then publish them to the jury through reading them, because those are inconsistent statements that would rebut her statements.
Well, and I'd also have to object because you already had your chance to cross Ms. Belmont.
No, the state gets to present a rebuttal case. That's part of the procedure to rebut any evidence that was presented during the defense case, so long as it's genuine rebuttal and not otherwise, you know, like opening up a new avenue. So what I said was that I was going to allow the state to present their rebuttal, that thereafter I was going to excuse the jurors for the day, that we were going to have a charge conference and have closings tomorrow. So I wouldn't expect that we'd be in session all day by any means.
Thank you.
But but this is going to proceed, but if you need a few minutes to review what the state's proposing, and I'm not quite sure, Mr. Mansfield, what your proposed procedure is. I'm not clear. I mean, you gave me this page of excerpts from Paul's first deposition, May 1st, 2019. I'm not sure.
Let me clarify. There's two different pieces of rebuttal evidence I'm going to be moving in today. The first piece of rebuttal evidence, I have the officer here. The officer is going to come in, take the stand, tell us that she went to the hospital to interview the witness, Paula Belmont, that her body worn was on, and that Paula Belmont made statements to her about what had happened the night of the crime. Okay. And I have that video to play. That's the first piece of rebuttal. The second piece of rebuttal are excerpts from her deposition that I provided to the court and to the defense. These excerpts are directly on point with various comments that she made yesterday, and these excerpts rebut what she said yesterday in her testimony for the defense.
Okay, so how do you want to publish that? I mean, you're not moving this piece of paper into evidence.
Judge, I would seek to move the paper in, or if not, I would just seek to be able to publish to the jury. I'd say, ladies and gentlemen, I'm going to read to you the question and the answer that was provided to the witness, and I mean the question was provided to the witness and her answer, and I'll just read it to the jury.
And Your Honor, I would like to, again, I would object to that. I would like to, again, at least know which statements you plan on moving the jury, if you plan on moving this whole thing in here.
Okay, so the way it's done, in my experience, is reading the alleged inconsistency that the written transcript or some excerpts from it in writing are not normally the way it's done. Normally it is deposition, sworn to on such and such a date, line, page, whatever line, question, answer. The attorneys can either, one attorney can be both the questioner and the witness, or I've seen them one be the questioner, one be the witness.
Well, Your Honor, if I may
Yes, sir.
take exception again. The state had all of this prior to Ms. Bellamont taking her perpetuated testimony. They had their chance to cross her then. They had their chance to rebut that.
I believe that doesn't preclude rebuttal evidence. Now, if you need a few minutes to review this, that's fine.
Judgment doesn't preclude. This was evidence. This is why we didn't call Paula Belmont. This is why we let the defense call her.
I understand that. I understand that. This you can certainly present any kind of inconsistent statement if it's in fact inconsistent. So I don't know. Mr. Tucker needs 30 minutes to review some of this stuff, or 10 minutes, or 5, or
I'll tell you. I don't. Looking over this, I'm going to have to take a look at the video, and I'm going to have to take a look at this deposition. Are you planning on putting the video in too?
The video is going to play for the jury, just like testimony.
Okay.
Well, okay. Was provided in discovery?
Yes.
Okay. So, I mean, are we having excerpts from the video? Okay. So,
On behalf of the client.
for the defense, outside the presence of the jury. So just like, okay, so.
Okay.
30 minutes to go through this, and I guess we have all the jurors present. Could you tell them that, we're not going to be with them till about 10:05. They can either stay there or, take a little break if they want to, at 10:05.
The bailiff's just going to go and talk to the jury.
We didn't know there wasn't going to be a defense presentation today, or I would have addressed this yesterday afternoon.
I understand.
And one more thing, Your Honor. I mean, again, they did call her when we did the motion to perpetuate. That was your witness.
Understood. Understand, but it was presented in your case. That's the difference. That's like I was explaining yesterday. The deposition is one thing, but who chooses to use it is an entirely different thing. So anyway,
thank you.
We'll be back at 10:05.
So while the judge is gone, Tucker's going to view. So the lawyers will be there in court, and Tucker's going to view the material. I have concerns with the bailiff being instructed to go and talk to the jury outside the presence of all the lawyers and the judge. This is like I'm not going to say Becky level, but why would you open up that possibility to say we had the jurors getting instructions or updates from a bailiff outside the presence of counsel or the judge? Oh my goodness. That's just me. Of all that just happened, that's what I am mostly concerned about. It's close to Becky level. Shades of Miss Becky, says Fair Chair. Oh man. Oh, we've got to add to the counter. Sorry, I'm falling way behind. So let's see, where are we at? Counter's 82. We're going to 83 now. You guys have to keep me honest on that. Just if I miss, just keep a total until I can, see the comment, and then we'll add those. All right, back to where we are. So we have a half-hour break. Oh man, so here's what we know is going to happen now. Karen, thank you for updating me on the Law 101 counter. I appreciate you guys. What's happening now is the rebuttal case. The way rebuttal works, rebuttal evidence must be confined solely to the subject matter the evidence that's being rebutted. So it's going to be very specific. It's going to be narrow. The evidence that was brought forward in the defense was by Paula, saying that was 100% not Mr. Tucker at the crime, that it was not him. Now, I think a lawyer could do a better job arguing against the admittance of this rebuttal evidence, because there was also in that presentation an admission by Paula that there was a time that she felt it was him briefly, immediately after the crime. That was in there. We heard that in the testimony. So this is not new rebuttal evidence. This is rehashing something. I believe a lawyer could look at this and say, and make an argument, right? And make an argument. Mr. Tucker is not as experienced in the law. I'm not experienced in the law, but it sounds to me like that would be an area that would probably be argued by a lawyer if there was one representing him. So that's interesting how this is going to go. The defense is doing the right thing to bring this in. They're using the witness. They're using the police officer that was there who took the body-worn camera. They're authenticating the video through them, and then they're going to play the body-worn camera. This is how you get evidence into court. And Mr. Tucker has struggled with that. Also, they've struggled with the type of evidence he wants to bring in, which is also hamstrung him a little bit. But did they challenge Paula during the depot with his body cam info? They did not. Not that I know of. At least it wasn't played. If it was that, because they cut it up and played portions. But I have FOIA on bailiff's emails stat. We have water. We're good to go. All right. Yeah, I'm concerned about the bailiff. I would want to know what facial expressions were used, what words were used, how long they spoke, if they've ever spoken before. Is this normal for the bailiff to give instructions to the jury outside the presence of the judge, even at the judge's direction? Typically, when a bailiff communicates with a jury, it's often done during deliberation time, and it's done through a written note that's handed to them, and that's it. But just saying, hey, would you go tell them that we're, working on some stuff? This just opens the door. This is like, whoa. If the bailiff goes in there and rolls his eyes and was like, well, defense is trying, they're still causing problems, still defense delays. Does that prejudice the jury? I don't think the bailiff's going to do that. I think it would. Is it normal for the bailiff to tell them there's a delay? No, I don't think it is. They just sit there, and then when they come in, that's why the judge apologizes and say, sorry, guys, we kept you out there. That's my fault. Don't blame these guys. The judge is the one that falls under the bus every single time. And here you've got who knows what happening to the jury. It's normal, says Renee and Robin. It's normal for the bailiff. Robin says it's normal for the bailiff to tell them scheduling. Is it normal in Canada or normal here? I'm confused. We've got a Canadian flag. That's why I'm asking. Melinda's Law. Say it again. What did I miss? I'm scrolling up to see it. The prior inconsistent statement has to be presented to the witness and given an opportunity to explain the inconsistency. The judge is wrong on this ruling. This just means add it to the appeal pile, right? Which he already has so many things in. The appeal is going to take years to write because of how big it's going to be. The prior inconsistent statement has to be presented to the witness and given an opportunity to explain the inconsistency. Because how then does Tucker then argue his side? Because on the rebuttal case, Tucker gets to cross, right? How does Tucker cross this? I mean, part of the problem is that the evidence was provided via deposition. I don't know. This case is messy. It's dirty. Oh my goodness. Melody says, I suppose I should take a break and wash my breakfast dishes. Body cam footage would be cool to see, though. It's coming up. It's coming up. It's going to be at the hospital. And I believe the whole bit here, this is the point where she thinks it was Tyrone, where she says it was Tyrone Tucker that was the second person. That's my understanding. Two weeks in, I still haven't satiated my craving for key lime pie. It's the courtroom walls that do it. We look at those and we just think, I disagree. The bailiff gave us updates on schedule and the trials. I've been a juror in Illinois, says Donald King. Okay, for me, it sounds, I'm used to a judge. Well, first of all, typically, the communication to the jury is normally done during the deliberation phase. But this trial has had a lot of weird breaks where most trials are they have some breaks, but it's just like, hey, we need to leave for a little bit and then come back. Hey, we need to leave for a little bit and come back. Here they're just sitting there. I can see why this would be normal, but I would also be concerned that the judge just sort of left it up to the bailiff. Can you just tell them we're delayed? Disagree with the concern on the bailiff. I'm in the minority here, but I'm going to stand my ground. Bailiff also gets them lined up into the courtroom, so there's basic interaction. And they are sworn. They're sworn in. They're officers of the court, like that. They're the officers, literally. Nothing wrong with bailiff communicating timing to the jury. I guess my problem with it is the way the judge has intonated his unhappiness with the untimingness. And so as he gives the instruction to the bailiff to tell the jury that, we're going to be there a while, sit tight, don't go anywhere, that tone, I hope it doesn't carry through. I've barely been in the courtroom. Yeah, total time in the courtroom, the jury is, the seats didn't have a chance to get warm. Let's see, I think it's normal so long as the bailiff, et cetera, just says, as asked by the judge. Canada's common law as well. Today is jury selection for Mom and Crumbly trial. Yes, can't wait for the trial. We're looking at that one. Jennifer Crumbly coming up right away. She's first, and then her husband. Did I miss it? They asked him if he wanted to testify in his own defense, and he turned it down. No. Here's what they had. The judge, the issue of him testifying in his own defense has not been raised, to my knowledge, in court. I don't know if this was, talked about before, that they would not do this, and they both just understood. There might have been a stipulation. Just no, I'm not going to testify in my own defense. That seems weird, but it wasn't brought up. But the fact that defense said, I don't have any witnesses prepared, the judge might have taken that to, he's also not prepared to testify. But usually there is a little bit of a little colloquy that goes on, and the judge says, are you going to testify? Do stand your ground. I'm going to stand my ground, state. I'll stand my ground. That's not what it means, but yes. Delays are nothing new to this jury. Bailiff will not say anything other than court is delayed, period. And honestly, yes, this is a delay. There's a lot of sitting and downtime for the jury, but they were told this was going to take till February 2nd. And so they're basically getting out a week early. Think about it, says Barbara. How else would the jury know when and where they should be going without someone telling them? It's not the when and where. I mean, they get called and summoned and say, hey, come to court, come line up, all that. But telling them why there's a delay, that just seems strange for me. And I realize I'm the only person here that thinks that's strange. That's okay. I've been wrong before, and I reserve the right to be wrong again. All right, well, we'll take this moment to catch up on Jay Hatch's mounting debt. $643,802 currently is what is owed. All right. I wonder why they didn't bring him in. It just seems they've it would have been cleaner for me if they brought him in. It's a huge appeal issue if the judge didn't address his right to testify. It'll be interesting, especially if there's jury instructions about it.
Call from
Courtney Meek.
Courtney Meek, how are you doing?
Hey, Ari, what's going on?
Oh, you know, we're just in limbo here, waiting for court to begin again. How about with you?
I know it's driving me insane. I'm trying to work, but the Tucker is driving me insane. I can't not watch.
What is the big issue?
I feel for him. I do. I really wish he hadn't gone pro se, but I don't know what the deal is with his prior attorneys and why they couldn't stay on the case. But it is what it is now, and usually I can put my finger on whether or not he's going to get off about this time in the trial, but I don't have a clue about this one. I don't have a clue.
Before this rebuttal information came in, I'm feeling pretty strongly that he was going to be acquitted. But when the rebuttal information comes in, and now you have the surviving victim in the trial, in the case, in the assault, literally shortly, minutes after, she's in the hospital, and she's saying it was Tucker. If that's what it is, that's a problem. That flips the scales.
Yeah, that's a big problem. It's going to be a real big problem. And I wish he had the knowledge and the words to use, like that comment you highlighted a while ago, that it has to be presented to the witness so they can clarify why there's a discrepancy in their statement. I think it's going to sink him.
Yeah.
I think the rebuttal is going to sink him.
Well, he's got, I think he has fertile grounds for an appeal, which is little consolation, because that means you're spending time in jail or prison. Right. And sometimes that can be years for an appeal to be prepared. You know, we learned from watching the Zachariah Anderson trial and what happens after that. It could be 6 months down the road before even the transcription of the trial is ready, which you need to have in your appeal. So there are long delays, and then there's costs, lawyers, fees, and stuff to prepare the appeal. He probably should not handle that himself. I would say that's something you definitely want a lawyer for. So it's a big expense. It's a lot of times, a lot of hassle, and also just the odds are not in your favor at that point. It's much easier to win in trial than it is to win in an appeal. So. Yeah.
And appeals courts don't usually overturn a jury.
No. But this trial has been a little different. I wish I'm not sure if somebody can find out what the overturn rate is for this judge in Florida. If somebody's able to dig that up, I'd be curious to see what it is. We know that Judge Carroll had a 93% success rate against the appellate court. Courtney, thank you very much. I'm sorry you're frustrated. Hopefully you can get some work done anyway. But
I'm going to try.
Hang in there.
In the meantime, when you're not on the air, I didn't get to watch the Zachariah Anderson trial with you, but I'm rewatching it now.
Oh, there's a surprise day. It surprised me. There's a day that the judge listens to us in court, so that's going to be fun when you get to that point.
Okay, Trace. Yeah. Oh my God, your face will be priceless, I'm sure.
I remember it. Thank you very much, Courtney. We'll catch you later.
All right. All right. Bye-bye.
Call from
Nosy Rosie.
Hey, Nosy Rosie, are you there?
Hey, how are you?
I'm doing great. How about yourself?
Hanging in there. I apologize for all my typos. But
I've been counting them. That's what I do. I have a score sheet, and I track everyone's typos, and you do have quite a few. I'm just kidding. I never even see them.
We need a Nosy Rosie typo.
My brain corrects all the typos.
We need a Nosy Rosie typo left-handed mess counter.
Well, what were you trying to say? What were you trying to say with the typo?
I'm not even sure.
That's all right. All's forgiven.
I did want to say that yesterday I went for my jury summons, and I drove probably about 45 minutes just to get there. and I had to wait to get my excuse. And I'm getting a new perspective from what the actual jury has to do by constantly waiting. And if there is a redo of this whole case, it really was a waste of time because the jury just literally sat that whole time.
They sit and they get paid, although the pay is the least of the state's concerns. It's very little money. But they sit. The bigger concern is the juror members are not able to be with family that day. They're not able to be at work that day. Their lives are on hold for the duration of this court. So you might say, oh, but, it's a half day. Well, they still can't work. They can't be like, oh, I'm back. I got back early. I can get a couple hours of work in. Work's just going to say, look, it's a jury day. Come back when you're off the jury. It's frustrating. It's a big commitment to serve on a jury, and takes a big bite out of people's lives.
Yeah, it really is. And there was a gentleman that was coming out of a room, and he was talking about that the vending machine, that the soda was $2.65. So he can't even afford a soda from the vending machine. It just
they're not even paying minimum wage, and they're ripping you off on soda. That's just
yeah. So, anyways, I got an excuse because I'm on pain meds, and like Paula, I'm on pain meds, and I can't sit there because of this bulky sling. So I was able to leave, and my husband drove my happy little butt over to Walmart, and we located some spicy maple bourbon pickles.
Ooh. So you skipped court and you got pickles. This is getting into a good story. I like this.
I popped open the can right there at the store, and I tried it, and I'm like, I'm not really sure that I'm sold. My husband took he got one of the pickles. He was sold, and he grabbed that last bottle that was there. So we left with 2 of the bottles. Nice. I'm sure we will be back.
You were literally eating the pickles in the aisle, in the pickle aisle.
Yeah, because I wanted to make sure. I would have done the same thing with the Stevens hot chocolate.
You would have brought a little hot water in the cup and a spoon, just made your own. I'm just glad you decided to buy them. You guys, if you're going to Walmart getting the pickles, check the seals. Make sure Nosy Rosie hasn't tasted your jar before you got there. Just put it back on the shelf.
No, we were definitely going to buy them. I just wanted to make sure I needed to buy more, which we did.
Yeah, I will tell you.
But
don't give up on the pickles. They're best consumed after you've refrigerated them overnight. Cold, it's like night and day.
That's what I'm thinking.
So
that's what I'm thinking. So in that, I'm glad we got the 2 jars, because then I might have to fight my husband with my one. Yeah. Good left.
I appreciate you trying them out. You're in the minority if you don't like them after all, but that's all right. It's okay if you don't like them.
My husband likes them.
Good.
Mr. Nosy Rosie likes them. But anyways, thank you so very much for the Stevens hot chocolate recommendation. I'm all in. I bought an extra tub. I won't buy any more so that others can buy it from Sam's.
From Sam's, yes.
For $10.84.
With free shipping.
For the 4-pound tub.
Yeah.
Yes.
It's a steal. It's a steal. Excellent.
It is. So anyways, one last thing. What did I miss with Tucker this morning? I overslept today, and then I'll end your call.
Well,
yes.
Well, as punishment, you have to go back and watch it on replay. Here's what I'll tell you. This morning, Mr. Tucker, or last night, or sometime during the night, between this last night and this morning, Tucker filed a motion of continuance saying we want the court to basically hold everything, break for 10 days, give us time to prepare our motion of disqualification. And because we've told you it's going to be a motion of disqualification, we'd like the rules for motion of disqualification, which require the judge to stop and handle that and nothing else, to be in effect. And the judge is like, denied, like that quick. And he's like, no, you can't. And he's like, nope, denied. And so Mr. Tucker really lost out. And then, anticipating this would be successful, Mr. Tucker took the witnesses he had scheduled for today, who were willing to show up and be there, and told them, you don't need to come. Don't worry. because there will be no court because we're filing this motion. And the judge denied the motion, and now there's no witnesses. And now the judge ruled on it and said, okay, since you have no witnesses, and I ordered you to have witnesses here, now I'm going to say your case is closed. You're done. Let's move on to rebuttal.
Oh,
So it's going like crazy.
oh,
So-
the one day I chose to actually sleep.
Yes, it happens quickly. So watch it on the replay. It's spicy. And then so we're going to have rebuttal. The rebuttal is going to be Paula's the body cam video of Paula in the hospital with an officer talking to her about the assault, about the robbery.
Okay.
And we believe
Okay.
that Paula in that is going to point the finger of blame at Tucker. She mentioned this briefly in her testimony yesterday, even though most of her testimony was she was 100% sure it wasn't Tucker. She did say there was a time when she thought it was him. Well, this is that time. So we're going to watch that. It's interesting. I don't know how Tucker gets to cross that or what he gets to present as cross to that rebuttal. That seems confusing because he basically, what can he do? Call Paula again as a witness, as rebuttal? Maybe play the audio again of her saying there was a time I did that, but immediately after, but I was wrong. I don't know.
I believe now when they say that a person is their own. I don't, what is the saying about
when you have a
fool?
When a person who serves as their own lawyer has a fool for a client or something like that.
That's it, because he had this in the bag, and then his personality makes him kind of unlikable, and so for that alone, I'm like guilty. But honestly, you're right. The blood excluded him. Paula's statements excluded him, but then he got to be smarty pants. Well, I'm going to file the motion for disqualifying.
It was like him showing a trump card, but the process, even filing that motion, it has to be perfect. If you leave a little part out, and it's not perfect, the judge can just dismiss it because it's not perfect. The law requires it to be a perfect motion, and it's difficult to do. That's why he wants the time to do it. Yeah, and now he's not going to have time to get that motion in. I mean, he's got to rush that motion overnight. Yeah. If he wants to try to get this disqualification in, which I think that's his effort. He's not going to try to rush and get more witnesses because the judge has shut that down. He's not going to rush and prepare his closing. I think he's going to wing that, honestly.
What a mess.
I think he'll actually do pretty good on that. There'll be objections. The judge will sustain them because he's going to go all over the place. I think that's the one area, the one part of the court where he has the most free reign to talk about what he wants, because the closing statements are not testimony. He can sort of stray from the facts. He can stray from the law even, it just depends how strict the judge is going to enforce some of those rules. But I think the time limit is going to catch him on that. It's been crazy.
He mumbles.
He does, but he'll have a microphone.
He mumbles.
If he holds the microphone, I think he'll be okay.
No, when I say he mumbles, it means that he wastes time when he's mumbling, and then he's apologizing and he's wasting time is what I mean. So, at the end of the day, I think it's going to be a whole do-over, and hopefully he'll have. I don't know. I think it'll be a do-over. I feel bad for the jury. But maybe the jury will get it right. I don't know. So
here's my 50 cents. I was right this morning on the continuance call on what the judge would do. Here's what I'm going to say. I'm going to continue my right streak, and I'm going to say he's going to rush his motion for disqualification. He's going to get it filed. The judge, even if it's not perfect, the judge will rule on it and deny it. And then it's going to go to closings. And that's going to happen tomorrow. That's my bet.
Wow. Well, thank you for doing such an amazing job.
Yeah, thank you so much. Appreciate it. Thank you for the call. Enjoy the pickles.
I will.
Okay.
You have a wonderful day.
You too. Bye-bye.
Bye-bye.
All right. We Donald King says, Recovery Addict, Judge Mark Jones has a 91.8% appellate success rate. That's high. That is right up there. That's within about a percentage point of Judge Carroll. That's pretty good. I'm wondering if what his how long has he been a judge? Does he have? I mean, is this like a lengthy career, or is this a short term that just hasn't had many go to appeal yet? We're not on closing arguments yet, Michelle. And by the way, I need to answer, I think Selena had a question asking about the Crumbly trial. We are looking at covering that. We are looking at covering the Crumbly trial. We're not covering the jury selection, obviously, but we're watching that. We might have to play catch up a little bit depending on how this trial goes. All right. Also, Ann Coltier, thank you very much for the super sticker. Do you know YouTube's channel name, Tucker's YouTube channel name? I don't think it's his channel name that's the thing. I know Judge Boyd just went live. We'll keep an eye on that. I don't think it's his channel. He was accused of setting up a new YouTube channel. I don't think he did. I think he made a post on Facebook or something, or a video, something he shared went on the one of the pages that's following his channel, his case really closely. Let's see. Dr. SB, glad we can help you enjoy the good life. Thanks for being here. Appreciate that. Covering the Vander Ark sentence. I have not been, Don. Fill me in on the details there. Katia, what is the buffer for? Only mods can make the buffer sound work. No sound? There's no sound? You can't hear me? Oh, these sounds? I had them turned down. I'll turn them back up for a little bit. Doesn't mean you need to make all of them go at once. TC, good morning to Australia. Sydney, hope you're doing great on that side of the world.
Someone with more experience.
Yes, we can hear. It's all good. It sounds fine. Okay, good. I think it meant that the sound effects were down. That Sarah chick. What have you missed? It's been a spicy morning.
All that was terrible. I apologize.
We're not seeing court because court right now is happening right
Somebody
here.
just sent me a video of roaches fighting. I don't know who won.
You don't hear everything? I wonder
When are we going to break for lunch?
I'm not sure why. Let's see. Gifted one membership. Gerda, thank you very much for gifting a membership. That one is going to go to, drumroll, kinda, sorta, in a way. Congratulations. Weezer also gifted a membership. That one went to Melanie Shaney. Is it Shaney? I never would have got Shaney from TSENI. That is a incredible spelling. All right. Dale Mock says, Recovery Addict, what class did you play in WoW? My money is on Paladin. Oh, Dale. Night Elf. I was a Night Elf. I didn't have an I win button. Paladins are, no, just kidding. I did have a Pally. But I was also I was a Night Elf rogue on my main. Rebecca gifted 5 memberships. Selena gifted 1 membership. Holy cow. Misty Harris, Charmed, Laura Olson, Gordon, Holly, and Linda Hubney all gifted memberships. Hannah says, I keep forgetting I have these. Love being part of the community. Congratulations on 3 months. Hannah, that is amazing. Thank you for your support. Wouldn't be the same without you here, Hannah. Thank you. I thought the prosecutor was a baby judge, but shockingly he's had his license since 2002. How do you know which commands work for what? Is there a list? Barbara, there is a list. If you type !commands with an S, it'll give you most of the list. There are a few in there that aren't listed, but this will tell you. Oops, here we go. Let's see, here we go. There's some of them. Somebody just sent me
a video of roaches fighting. I don't know who won.
You just have to know what they are. I think it cut off a page of those or something, one of the lists. But let's see. That reply as to why we aren't watching court was hard to understand. Holly, I'm sorry. We were not watching court correct? Because nothing is happening. Currently in court, there are things happening, but the judge is not on the bench. When the judge is not on the bench, we don't get to see. Right now, the attorneys for the state and Mr. Tucker are watching the video that's going to be played in the rebuttal, the deposition video and the body cam video that's going to be played in rebuttal. And once they're done watching that, then the judge is going to come back. We're going to bring the jury in. The judge will inform the jury that the defense case is rested, has closed and that we're going on to rebuttal. That's going to be an interesting thing, especially if Mr. Tucker makes any comments or gestures. I think the jury will be surprised and probably be glancing at him at that time. So we'll see what happens. They might be done with the watching the video right now because it's going to be pretty short. We've got this rebuttal stuff. I don't know how they're going to handle the cross-examination of rebuttal. What Mr. Tucker can do to present evidence afterwards. I think the only thing he could do is go back and replay the evidence that from the segment where she says there was a brief time where I thought it was Mr. Tucker and I was wrong. But I can't think of anything else he can do. It's the point where he gets out lawyered. We've been at that point for a while. It's been painful. Did anyone catch Paula say there was a glove left at the scene that she told police and they didn't take it to test it? She said that yesterday in the testimony. She found it like under a blanket or something. There was a glove that was left there with blood on it or something. I think it was a bloody glove. Let's see.
Alex stole it as well.
With more experience.
They also said the officer was going to take the stand. Melissa, the officer that's going to take the stand is the officer who's going to authenticate the body cam video from the hospital. It was the officer who was wearing that body cam. So they authenticate the evidence, then they present the evidence while the officer's on the stand. But they don't really need the officer. Once the video is authenticated, that's it. I don't know what Tucker is going to say in cross-examination of that police officer. Maybe ask about any drugs she might be on or medications.
When are we going to break for lunch, Judge?
That might be, if they don't know what medications she was on at the time, that might be helpful to him. Yeah, Tom, he still has a chance of being acquitted here. That's definitely a possibility.
Somebody just sent me a video of roaches fighting. I don't know who won.
Rebecca, by the way, if I didn't thank you before, thank you for the 5 gifted memberships. Kim Halper, welcome to the jury. Padded chair, padded reserved seating, virtual, of course, but that's wonderful. Thank you very much. All right,
the jury.
I think we're about ready for the judge to come back. Let's see if he will come back early here, or if he's still screaming in his pillow in his chambers.
Are we going to address subject matter jurisdiction?
Wow, as if on command.
Okay, so we're back.
Here we go.
Anything further before we bring the jury up?
Your Honor, I would actually have to take a little bit longer to review these. I'm reviewing an entire deposition, and the videos that they brought are clips from videos, and I'm trying to get the context of where the clips came from.
Judge, typically on a rebuttal case, it has to be narrowly tailored to the issues that you're rebutting. So I took clips from the interview with Paula Belmonte at the hospital. The clips, I think, total like 1 minute and 20-some seconds. The defendant, I guess, wants to watch the entire video. I have no objection to using the entire video. Whatever way he wants to go, but that's where we're at, I think.
Your Honor, for me to know that, I just have to review it, that's all.
Review what?
I'm just reviewing I was actually reviewing the video right before you came out, Your Honor. I'm trying to make good use of my time. There's actually 3 videos, and I'm not even sure which one it is.
They're excerpts from the 3 videos where she talks about her inability to ID the second assailant. That's what they are.
Okay. And
how much more time would you need?
I don't know, Your Honor. Again, I'm not going to need that much time. I mean, as far as reviewing the videos, but then I also have to review the depot where these are coming from because he didn't provide the entire depot. At least not that I can see here. Again, it's being excerpts from the depot, and I don't know the context.
How much time would you like to have?
To do the entire depot and check the videos, all 3 of them, I'd say at least a half hour, Your Honor.
How long would you anticipate this presentation to be?
Judge, maybe half an hour
total? I'm just contemplating bringing the jurors out, telling them to come back at 1 o'clock, letting this unfold, because I just don't want to continue to go back and forth and have these people waiting further. So if that would make it more palatable or convenient. I mean, none of it's convenient for the jury, but if that would be more considerate, then we could resolve whatever objections there are to this. I could tell them to come back at 1. We'd be prepared to present to them. Then we can have our charge conference. I'm assuming, I inquired a few days ago about proposed jury instructions. I'm assuming that that package is together.
It's in the process, Judge. I'm just about 90% done, but I'll have them by this afternoon, and I'll email Mr. Tucker his proposed jury instructions.
And jury verdict form?
Yes, sir.
That was my question, Your Honor, so they already addressed it.
And so then, if we let these folks go to 1 o'clock, we have them come back, we have the rebuttal case, we do our charge conference. I guess that's the best way to handle it. That's way I don't have to continue to come back and ask how much more time. And wait a second, just hold on a second.
Just drank everything that was in that cup. I'm not sure what it was. Butler Bailiff is going to refill. Get the refill. Bug Duggar gifted 5 memberships. Thank you. Rachel Brandenburg, welcome to the gallery as a new member. Thank you for being here. Here comes the jury. Judge just had to formulate his thoughts because he has to politely welcome the jury, let them know that we've had some delays. These things happen in court. Judge needs a bigger mug for sure. The bailiff gets like 10,000 steps refilling the mug every day.
Have a seat, folks.
Mark Jones. Honorable Mark Jones.
Ladies, gentlemen, good morning. Good to see you all here. So, I can assure you, I can tell time. I know that clock says 10:15, and I know I told you to be here at 9:15. So I, in good faith, believed that we'd be able to get to you at 9:15, but just like all of you and all of humanity, I can't predict the future. I do my best to try to gauge how much time things are going to take and what's going to happen. Sometimes I'm accurate and sometimes I'm not as accurate. Unfortunately, in this particular case, I haven't been as accurate as I think I normally am. So I have to, again, be very grateful for your patience, your understanding, your attendance, and all the other things that it takes to be a juror on this case. I do want to advise you that we haven't been idle here. In other words, while you're waiting, it's not like we're all taking an extended coffee break or none of the above. We're working and making progress in terms of ultimately getting the case to you. And so I can advise you that the defense presentation has been completed, that I can advise you of. And so the next step is the state's going to have an opportunity to present its case in rebuttal, which will be relatively short. And so what we need to do, or what has to happen now, in light of the fact that we've reached this juncture in the case, once again, I have to spend some time with the attorneys outside of your presence. How long is that going to take? I don't exactly know, but I do know that the best way to do it and try not to keep you in limbo is to excuse you to 1 o'clock. And that way I am as confident as I can be of anything that at 1 o'clock you'll have evidence and rebuttal presented to you, and the evidentiary portion of the trial will be over at that time. What that then means is that the lawyers, defendant, and myself will confer outside your presence. You'll be excused, and tomorrow we should be able to go to closings and deliberations. So again, I always try to be mindful of your scheduling, your time, try to give you the best feedback I can as to where we're at in this process. So again, I apologize for the wait, but this is where we're at, and I'll look forward to seeing you back at 1 o'clock, and have a good rest of the morning.
How much leeway does a pro se defendant get? Depends on the judge. The judges also, their hands are tied a little bit. Mr. Tucker is not looking pleased as the jury leaves. I wish I could see his reaction when the judge announced that the defense was done. He's mumbling to himself a little bit.
So they're going to 1. So so you'd think that Mr. Tucker,
that's more than enough time.
Well, no, I mean, I've got to come back here. I don't have to, but I would think I'd need to come back here at 11 to see if there's any objections. I mean, so if you have any objections, I want to be able to rule on them so we don't find ourselves sending these folks back and forth again.
So 45 minutes, Your Honor. Is that what you what?
That's what I'm estimating.
No, I'm just checking.
So like 11:05, and sometimes the opposing sides actually reach agreements on some of this stuff, where one side may say, gee whiz, I have a problem with that, did you notice that? And the other side might say, oh, okay, we'll withdraw that one. Other times they don't. They need the judge to make a decision. So if there's any agreements and if there are any objections, if they're not, that's whatever. I'll be back at 11:05.
Thank you.
Okay, so the judge steps off the bench. Mr. Tucker now is going to start analyzing the material that's going to be presented in the rebuttal case. While we do that, let me just say this. We'll keep the audio on. We'll keep monitoring. When the judge comes back in 45 minutes, we're going to be there as well. There are some things we want to go over a little bit, and we've tried to steer clear of some of the outside analysis of this case, just because it's very difficult to authenticate every bit of information once it's been through several hands of people. But one person who has not been shy about talking with the media during this trial has been Mr. Tucker himself. We know that Mr. Tucker's wife has been talking as well. She called in twice. She called into the show and talked and explained some things to us, and that was quite informative. But Mr. Tucker made a post last night, which has been shared on social media. It was a public post. And I'm going to read a little bit from that. It was on his Facebook page. It says, I'm sure some of you know how my day went, and for those that don't, it wasn't good. Almost nobody knows the history behind my case at this point, except for the few people who have been here since the beginning. There's been so much dirty crap done on this case that people would lose their minds knowing what has been done to me and what could be done to them. If these legal analysts had any idea how bad this case actually is and what they've done trying to prosecute me, it would make them sick to their stomachs. It has nothing to do with legal procedures, my abilities in court, objections, cross, or my lack of legal expertise going pro se. You have to put that illusion aside and look into the entire case history to know what's happening and why they're still trying to lock me up, even with this crappy, I'm editing, case. It also explains why the judge is acting the way he is. If you look back, this dirty jackwagon, I have to edit some of these words for the kids, did the same to my lawyers, hence why I'm now pro se. I'm pro se now. He didn't deny me setting up witnesses, and my defense, because he's worried about the jury's time. He did it because he put him on blast about some of the misconduct when I did my JOA motion, and he's scared crapless, once again another edit, that more of it will come out in front of the cameras. My team has known for a very long time how dirty this judge is, so we had to face the question of how do you beat a dirty judge, especially when the state and the investigators are dirty too. The only thing we could come up with was expose the cheating and hope someone from outside this crooked county helps us. Arguing law to a bunch of criminals with one on the bench would never have worked. I'm guilty simply because they say I am. So to all the analysts, stop thinking that my case is about procedures and filing motions or how I cross-examine and look into what actually happened here. Check the documents, the videos, the reports, and witnesses that prove every word I'm saying. Don't believe my words. Look at the proof we have. I wrote this judge many years ago, now accusing him of being a criminal. Why? Because he is, and I could prove it. And still can, but people need to ignore his words and fake pleasantries and see him for what the evidence says he is. Still a criminal. He just knows when to smile for the jury and the cameras. Think of it this way. You are literally trying to argue legal points to an organized crime and then somehow thinking you'll actually win. Good luck with that. The Bubba system is strong here. And if anyone out there can tell me the legal argument that will win against a dirty judge who has already shown he's willing to commit crimes to see you convicted, I'm sure I'd love to hear it. Till then, I'll have to get back to work and hope there's at least one honest person on that jury. If not, then for as much as I love you all, this will probably be my last post. Guess we'll see you tomorrow. Guess we'll see tomorrow. Love you guys. Ty. Wow. What's with the law counter? Do we need another law counter? There's a lot. There's a lot here. There's a lot to unpack. Let's see. Hang on one second. So let's put it this way. I shared that with you because he's shared that, and he's played his cards as far as what where he wants this to go and what his ultimate goal is with trying to disqualify the judge. That gives you an idea into his mind a little bit, because he didn't make that full argument in front of the judge. I don't have any information outside of what's shared in court here. I don't have additional information. I know there are people who've tried to share things with me. I can't authenticate other stuff, so I can't carry that on. So if I'd say we don't need people to find other posts or analysis or videos or things people have made and try to post them to our channel to show that he's innocent or guilty or anything else. Once again, that's not the best thing use of the channel that way. But it's interesting looking into this to see what is going on. This post is rubbing me the wrong way. It is inappropriate the way he's talking to the judge. But if what he says is true, I would ask you this question: how should he bring it up? If what he says is true, how would he bring it up? Debbie, thank you for the super chat. Thank you. I love the music icon in your profile picture. Thank you. How would he bring it up? We're definitely being punked, says Lois Cox. It's crazy. I've got a call coming in. Hang on. What? I was reading my phone.
Call from
Nina, Canadian.
Nina, Canadian Nina. How are you doing?
I'm doing really well, thank you. Good morning.
Good morning. What's on your mind?
Well, I'm a little bit off track of that Facebook post. I wasn't really listening when you read that, which is cool. I don't know what he's putting out there. I want to start by saying hi to everybody. The community is so wonderful. The mods on Recovery Addict channel are so fantastic. Everybody, it's nice to be able to call out, say hello, and thanks for hanging out every day together. I want to tell you, when we started watching this, I went through with what I'm learning from all of you is the presumption of innocence. And last week, inadvertently, I saw Lauren and Tucker interviewed on one of those on like Court TV or something.
They did a Court TV interview.
And then
live.
Right. Which revealed to me quite a bit about them. So we saw more about them and more about them. And what, again, in this trial, what really gets thrown around is the investigation was sloppy. Oh, everybody's doing a terrible job. People don't do their jobs. You know, I see this criticism broadly across the internet. And I just kind of wondered and thought, you know, I don't presume everybody is doing a bad job. I kind of think everybody does what they can do. And I think maybe there must have been a reason. You know, just in my heart, I knew there's other sides to what keeps being brought up. And then over the weekend, I went back and had to listen to some of last week's stuff. And I'm like, wow, these, you know, this is still so heavy. It's very frustrating for everybody in the courtroom. And then I watched more of these outside, like interviews, just like what Brandy Churchwell will find, the interviews out available. And when now, in the past 2 or 3 days, I've had the benefit of seeing the interviews with between the police and the other characters, and it became obvious to me that this is a smokescreen. This is a big thing, huge smokescreen that he is creating, and he is sorry. We're not getting the other side. As much as we get to see what Tucker and Lauren are saying and how they feel, even today, how he feels that he needs more time. Well, if we knew the stuff that we don't know, it would make a lot more sense. How we are today and why the courtroom is going the way it is. And I think that was really what was coming out of it for me, is if we knew, this is exactly like all the times we've been able to see conversations without the jury in the room, and then they come back in and we kind of know, oh, they've been sheltered from information. We're being sheltered from information in this, and it's getting very lopsided. But what a roller coaster ride. I still think, great, I'm learning out of all the experience. So that's, you know, it's kind of cool. But this case, like even seeing how people in the chat have been, you know, like this, we're all trying to sit on the fence, but we're all also trying to figure it out. But if we knew more, we wouldn't be in this confined. Okay.
Were you surprised by the amount of evidence that the state presented, or the content of that evidence? in this trial?
I'm not good at analysis like that, I guess. I don't know.
I've never seen. Let me put it this way. I've never seen a DNA expert get called to the stand to testify and not have any matches with the defendant.
Okay. Sure. All right. I just kind of feel like, okay, whatever. And if I'm a juror on that, in that group, I'd be like, well, that's not a big deal to me. Like, there must be reasons why, right? And for instance, I like, what if they were wearing gloves? Would that have an impact if they went in there wearing latex gloves? Would that affect how much DNA got left behind?
Well, they tested the glove, including on the inside, and didn't have any matches.
What kind of glove?
The gloves
was it
that
a latex glove?
I believe it was black gloves that they were wearing.
See, okay, therein lies where I feel like we didn't get great evidence.
Yeah.
I don't know what gloves we're talking about, right? Like,
because the
I
gloves
really
themselves were
feel
not
like,
admitted in evidence. We didn't get to see them.
Yeah, right. And I don't know, did they talk about why we didn't get to see them? I do feel like there's gaps in the evidence. I feel like it's not been presented to us well, like we've seen in other cases where they come in and they kind of explain things step 1, step 2, step 3, and ta-da, here's, this is what we want you to understand. And hopefully they can recover in the closing argument. That's what I really hope for when I get off track in these things and don't understand. But he's making it really hard, no matter what their best efforts are. That courtroom is like, and I hope I'm becoming a better mom because I'm participating in the Recovery Addict group and with all you guys. Because, like, I'm a judge in my household, and my kids, I tell them, like, you stop talking, they go first, you, then you, and we'll do that. And then with him, I would have been like, stand up. You gotta it was astonishing that just a few minutes ago that he was sitting down slouching while they were trying to determine if they were giving him more time. Oh my goodness. But that's on the judge for not keeping the courtroom decorum.
Yeah, I agree. The judge should enforce that, and every judge is sort of different. There are some courts where they actually say don't stand up, remain seated. They're actually told to stay seated during argument and everything else. So, but
I've learned about all that.
Definitely
learned about that. That if the defendant is chained to the table, then they want to sit down. In this case, it's obvious. Like, I felt the way he walked around with his microphone. Oh my goodness. It's just all been very inappropriate.
It's been very different, very, very different than what we expect.
Sure.
But every time there's pro se, you get a little bit of that.
We got a lot of it. It's been a lot. It's been overwhelming. And you know what? It hasn't set a great precedent for down the road with other people wanting to go pro se and thinking that they can just behave like this or like Darrell Brooks. It's really unfortunate in that sense. Yeah. But I do challenge us all to think, like, if we were able to see testimony from the other characters, they would be filling in blanks for us, and the story would be more fulsome. And I believe if I was on a juror and being given all of the information, I would feel like this guy, there must be a reason why we're here. There must be a reason why we couldn't see everything, but this guy, this isn't right. I would go back and see how I felt about how he treated Paula, how I would kind of go through what I've learned from you is which witness, as a juror, you have the ability to assess the truthfulness of a witness or the reliability.
You can dismiss all, none, parts. Yeah.
Exactly. And so I would be taking all of the stuff that I've gained from being part of these groups every day, and I would be saying that as a juror. And however, the other thing I've learned is you've got to go through the forms, and they're going to say, has the evidence proven this? Has the evidence? Am I correct?
Yeah.
You go through. Have the state, up here we have the Crown, has the state proven and given enough evidence to meet this? I'm sorry, I can't think of.
Have they proven the elements of the case? Have they proven beyond reasonable doubt?
Yeah, exactly. You got to get to beyond a reasonable doubt. At which point, I would be going back to which witness is more credible. That's how I'm going to have to come up with my evidence, because I can't rely just on this black and white situation that we've seen between the two of them. I would have to think who's credible,
right?
And then I'd have to assess that form. And at that point, I can't tell you where I would be, because I don't have that in front of me. But that's where I would land.
There you go. Nina, thank you very much. Great to hear from you. Thanks for checking in from Canada. Appreciate it. We'll see you.
Yeah, thanks so much.
Bye-bye.
Have a great day.
You too.
Bye.
Bye. I have to address this. Content Lasagna posted, you said, you watched a dude get convicted for murder without a DNA match for a pinpoint of blood in the back of the van. They could tell it was male. That's it. False conviction, rather. Recovery Addict. You're talking about Zachariah Anderson. And this is a point I've stuck on. And I'll go back to this is as close as I can get to the transcript on that Zachariah Anderson case. Trefflinger was on the stand. Attorney gravely was questioning him and saying, "Did you do DNA testing? Yes. Whose DNA was that a match for?" Rosalio Gutierrez was Trefflinger's answer. That spot, that pinprick, there wasn't enough to do a test to see whether it was blood or not, and for DNA. So they just tested it for DNA. That's my understanding. And it did match the victim in that case. And that spot of blood was in the defendant's van. The victim's blood was in the defendant's, or not blood, I shouldn't say that. The victim's DNA was in the defendant's van. And that's what put me over the edge on that one. Let's see. Gravely was horrible. I did not like him at all. I did not. Was it? It was confirmed to be Rosalia Gutierrez's DNA. That was the testimony in trial, was that it was matched. They didn't give us the 1 in 9 billion, but they confirmed that it was a match, was the testimony. Let's see. Jamie, welcome to the gallery. Thank you very much. My phone's beeping at me. Sorry. Interesting. I don't want that. I want to go back here. Let's see. Got lots of messages to read. Sorry about that. All right, we have a couple things. Vince Clortho, welcome to the gallery. Thank you very much. You've got a scary looking profile. What movie is this from? I think this is from a movie, like an 80s. Is it Gremlins? No, it's not Gremlins. Somebody tell me what that is. I don't recall what it is. Jamie, we welcomed you at the gallery already. Welcome, both of you. Good to have you here. Starting to believe he befriended Paula just to manipulate her to be on his side. However, they still haven't proven he did it, but he definitely was there. I'm not with the definitely was there part. I'll have to go back and find the parts of the trial, especially in the questioning early on of the witnesses, where his wording of the questioning almost implicates himself as being there. If you guys remember that happening, I'd love to get some timestamps. Go back. It was Gremlins? Was Gremlins? That's cool. Let's see. This would take more than YouTube chat to respond to, but they didn't have a DNA sample to match against. They said it was within the profile. It was not a match by any definition. I just read you the quotes from the transcript is all, where they said they quoted it was a match for Rosalia Gutierrez. Dark Angel, today is a mess. It's a mess. We are actually waiting in just a few, probably about 20 minutes or less. The judge will be out and check on them to see if they've got all their work done. If Tucker's ready to move forward, be interesting to see what he does here. It was is it Ghostbusters? Not a match. There was not a match. Okay, so tell me, because I've stuck by this since the very day we watched it. It was flat perjury by the expert. So I'm telling you, the expert testified that it was a match on the stand. So you're saying that you don't believe what they testify. I'm just telling you what they testified. So you can disbelieve the witness, but that doesn't change what they said on the stand, right? Do you think the judge is being unfair? People, for real, in some ways, it looks like he's being unfair, but at the same time, being pro se, there's still rules you have to follow. It's like you're at a serious disadvantage being pro se, and Tucker's having a hard time following those rules. They do normally give the odds. Yes, there was a match. It just wasn't blood for sure. That's what the testimony was. They were not able to test it for both to determine if it was blood and test for DNA. So they just tested for DNA. All they can say that it would have been blood. Because of the profile they got, it could have been blood or a couple other types of DNA. Like it could have been skin cells or something. Let's see. I'm going to have to pull this up. I get this comment a lot, and I think, Shauna, we're misunderstanding the discussion. I'm very confident that the witness was asked about that speck of DNA testable material in the back of Zachary Anderson's van, that they could not test it to see if it was blood. That would destroy the sample, because once you test to see if it's blood, you can't test that same portion to see what kind of DNA it is. So because of the size, they opted to test for DNA instead, directly for DNA, and the profile they got was a match for Rosalia Gutierrez. I think we need to rewatch ZA. We may do another interview with Solomon. Talk to him a little bit to see if we can swing that. Heather Reed says you can't match DNA. You have to give odds. Even with the victim's blood, you never hear match. All right, but it's like when the odds of it being a match, quote unquote a match, what we consider a match, are many zeros more than the odds of you winning the lottery, and you won the lottery. It's for all intents and purposes, we can say match. If statistically it would take several times the population of the Earth to find another person with that same DNA or to find that same profile, I think we can use the term match for that. There shouldn't have been anything of his in that van. I stand by that as well. Let's see, we can watch it again, then we can hear me in court again. Now, it's interesting. I would like to, I think we will probably down the road, possibly between trials, meet up with Solomon. I really enjoyed interviewing Solomon last time. He's a very respectable gentleman to interview. He's very smart. He's very knowledgeable. He's adamant. He stands by. He believes what he's, that his brother is not guilty of the crime that he was convicted of, and they're fighting to, seeking for justice, and now they're fighting for an appeal. So it would be nice to check in with him to see how the appeal's going. Let's see. That judge is no longer in service. That's correct. I believe this judge has been too lenient, which has contributed to all the disorder in the courtroom. It does seem, at times this courtroom does seem a little bit relaxed, a little bit laid back. 67 worlds of people to one. Yep. He says they spoiled the spec. There was not enough to use both RG and Zach. They chose RG. Ace, I think you're wrong on that part. They don't have to. They're not like putting the two pieces together to see if they fit, and you only get to try it one time. My belief is they tested it and they have a profile, and then they can check that profile against any number of other profiles. And that's how they can check a drop and see if it matches all the knowns that were in the case. And that one, it matched RG's profile. When is the judge back? Judge will be back here at the top of the hour. Let's see. Hang on one second. Weather Watch, I'll talk to you about it offline. Let's see. We all need to do a rewatch of the Anderson case and break it down together. Possibly. I will say this of the Zachary Anderson case. I still firmly stand with the jury on the decision they reached based on the evidence that was presented to them in court. Listen very carefully. I still stand with the jury on their verdict based on the evidence that was presented to them in court. I also, more now than ever before, believe there should be an appeal and that it should be granted, and they should probably get a redo because of how that went down. And look back at that trial. Look at how many times we were shaking our heads and saying, how can this go forward? How can we find a way to get past this? Is clearly mistrial. We've gone so far off the rails. You can't correct and get back to where we need to be. And then time after time after time, the judge would claw us back from off the edge of the cliff, and we would avoid a mistrial. And I don't think that was handled properly. So. So I think there should be a mistrial on that one. Okay. John, I hear you. A lot of people have different reasons for why they think there should be an appeal, but I think we're on the same page. That I mean, if I were on the appellate court reviewing the appeal, I would grant it. Not because I think that the jury came to the wrong conclusion. That's not what you grant an appeal for. You can't grant an appeal saying you came to the wrong conclusion. He's innocent, not guilty. There has to be a misconduct. There has to be something that went wrong in the case that was prejudicial to your client, that impacted the outcome of the case. I believe there was. And I believe it should have been a mistrial. And Zachary Anderson. Now, are we on the Treehouse case, says Patches? We are. We are on the Treehouse case. We are waiting. What's happening right now is Mr. Tucker Anderson is reviewing material that's going to be presented in a rebuttal case against him. And the video that's going to be presented is body cam footage and some deposition footage of Paula. And this is going to be Paula. I'm not sure if she's going to say Tucker's name, but it's going to go more to the fact that she can't identify who the second person was in that robbery. So, let's see. All right. Appeared to be a cast off of forcible blood. They didn't use the luminol to maintain the DNA pinprick. She was asked who it was a match for, and she said Rosalio RG. I read the transcript. Yeah, that's what the transcript is, and that evidence. I realize it's presented differently than we normally hear DNA evidence, but that is the testimony the jury heard. And for me, that was too much. There was a lot of circumstantial stuff there. There were a lot of holes where I thought they probably should have had evidence where they didn't. But for me, that put it over the edge. Successful rebuttal does not prove a case, though. I still do not believe the prosecution has met the burden of proof. Bravo Chick, I'm with you on this one. I'm with you. If all they have on this rebuttal is Paula saying, I'm not sure, I didn't get a good look at the second guy. It could have been anybody. If all they have is that, I'm still not voting to convict. K-Rab, I hear you. The Zachariah Anderson trial, there was no body. That was a no-body murder trial, and those are always interesting. We have had other no-body murder trials where, with convictions. It's not a requirement to have a body to prove that somebody died. But the blood spatter, the amount of blood, the type of spatter, all that is just like when the judge says, you don't have to see that it was raining to know that it rained last night. If you walk outside and there's, the ground is wet and there's, all this, there's standing water here, there, and everywhere. Let's see.
Call from
their verdict based on the evidence that was presented to them.
To accept, press 1.
Hello, all I hear is myself. Who's on the phone?
How can we find a way?
Can you turn off your TV? Hello? Hello.
Hi.
You have to turn off your TV or it'll be really confusing. You've got to turn off your volume.
Sorry about that. Yeah. I was just trying to text you a photo of my cat sitting on top of my TV watching your show.
Okay. Yeah, send it through. We'll have to do a pets day coming up.
I'm trying to do it, but I'm trying to figure out how to do it. I'm not all that tech savvy.
All right. If email works better for you, you can send it to email mdrecoveryaddict@gmail.com. Will get to me as well.
Say that again.
My email is MD, like doctor, but it really stands for metal detecting. Okay. So mdrecoveryaddict@gmail.com.
mdrecoveryaddict@gmail.com.
Yeah.
Okay, thank you.
All right, thank you. Appreciate it. Bye-bye.
Bye-bye.
Love cat pictures, so that's gonna be just wonderful. Thank you.
He looks a lot like yours.
All right, thank you. That'll be great. We'll see you. Bye.
Bye-bye.
All right. We are respectful of the case at hand, but nothing is happening that we can really review about the case at hand because Mr. Tucker's just reviewing material. Did anyone watch the trial Boyd had yesterday? We watched just part of the closing arguments, I believe. I believe the verdict did come back. I think it was like 2 years probation was the sentence. It seemed rather small. Dr. Recovery Addict, eh? Metal detecting. Let's see. Corina, you're frozen. I'm sorry. Is it cold where you are? Are you saying the feed is frozen? Yes to the cat photos, says Vern. Do you think CS should get an appeal? I do. I think he should. But I also think that if the same evidence were presented without the mistrial material, if the jury got the same evidence they got at that trial without that mistrial issues, I think they would convict. I think they should convict. Let's see. Why after all these years people still have not worked out this whole TV and background while on the phone is not a good thing? No, it's all right. It's all right. A lot of people don't understand how the technology works, and it's great. We can work with them. Looks like there's some motion in the courtroom. I'm just checking here. Some people are walking back and forth. So we might have the judge coming back in the next few minutes. Did you ever find anything exceptional while metal detecting? Martha, a $5 gold coin from like 1834. Does that count? I mean, I found some old stuff. I found, I don't know, probably 100 rings. A handful of them were even valuable. I've given them all away. Law Talk with Mike has only good behavior defendants this morning. That's new and different. Mike does a great job. From Chicago. Let's see. We've been jumping back and forth between this case and Brandy's, and they're both so hard to follow, for lack of a better word. This one's bizarre. You almost have to keep up to the minute. Tell you what's going to be hard to follow is the Karen Reed case, and Brandy's going to be covering this one. The further this goes, the more I think the Karen Reed case is not going to go forward, that it will be dropped before trial. Now, I don't know what the date is because it's coming up here soon, but it'll be interesting.
Call from
Braxton.
Braxton, how are you doing?
Good. How about you?
Not bad. What's on your mind today?
So I've been thinking about this case, and I couldn't convict either at this point. And I think I'm in the minority. I don't think Murdaugh should have been convicted.
Oh, wow. Okay.
I don't think that case was proven beyond a reasonable doubt. I think he was involved, but I couldn't have convicted.
Yeah, there were a couple things on the Murdaugh case that really stuck out to me. The lies, because there were some lies. The lies he told different people about what was going on, about where he was going, about what he was doing, how that worked up with the timing of the cars and the placement of the cell phones in different locations. That one, it just struck me as that there were too many lies. There were too many lies.
Absolutely. The inconsistencies were everywhere, which is why there's no doubt in my mind that he was involved. But the story the state put forward with the two guns and he was the only one who was there, I couldn't believe it.
Interesting. It's interesting. Yeah. What do you think if say this whole thing with Becky turns into a new trial? Have they decided that yet? I don't think they've decided. It's still in the process, right?
Yeah, I believe it's all in process.
It'll be interesting if that goes back to court. I would like to see that trial again without the huge emphasis on the financial crimes because he's already pled guilty to those. So extract that bit and just have it on the straight murder trial without the huge emphasis on the financial crimes. I realize that could be used as motivation so that you'll never be able to fully extract financial from the Murdaugh trial if they gets retried. But I'd like to see that in a cleaner version.
Definitely, because it felt like they were only trying to bring in the financial to show that he's an awful person and he's a lying liar that lies.
Yes, there was a lot of that testimony.
And they proved that,
and he admitted it
really well.
He admitted it. He lied. I lied to get money so I could feed my drug habit. I lied. Yeah, but that was a fantastic one.
But when it comes to this case, they have nothing.
Yeah.
They just don't.
There's very little. A lot of circumstantial evidence, maybe at the best, and very little, zero physical evidence. Right? All you've got is one person's word, who arguably is not very trustworthy, and that's it. So, I'm with you on this one on the acquittal.
And he's doing surprisingly well for being pro se. I just feel like he keeps stumbling into good arguments and stumbling into wins.
Not the ones that matter, though. I think there have been a couple good arguments. I think an attorney in a couple cases could have really changed the course of this trial, especially with the objections. We would have the objections and the leading. Oh my goodness, the objections and leading. You've got witnesses that the witnesses were not. I believe they were not of the caliber that could have been able to present the information that the state got them to testify to. I don't think you would have heard Travis say what the state said and then said right, and he said yes at the end of. You wouldn't have had all that evidence. It would have been very difficult, and a good lawyer would have objected to the leading on day one, and definitely objected when the judge got the ruling wrong and said, oh, it's on cross. He's allowed to lead when it was actually direct. So,
right, that was insane. And it's so hard to watch him defend himself, because I binge watch trials. So I know the court process really well at this point. And so to watch him mess up on these things, it's like, why? Why?
I will tell you what does impress me about Mr. Tucker is his ability to refocus on the moment after a big loss. And I mean, if I were in his situation and thinking I'm about to have this whole thing dismissed and, you know, put for 10 days we're on hold, and the judge says no, and he's upset about it, and then he moves on. He's like, okay, well, moving on. Here's how much time I need to handle to prepare for rebuttal. And it's like I'm still in the moment of like, what do you mean no? You know, this should be a motion to disqualify. But Mr. Tucker has been able to move to be in the moment and address what's coming up next very well. But I think he's playing 2D chess, and it needs to be 3D or possibly 4D chess. So it's
he thinks he's playing 4D chess, and that's the problem.
Yeah.
Yeah.
We just saw, Stevie just pointed out that our butler bailiff just filled the judge's mug, so there's a good chance he's going to be returning here in just a minute. It's 11:01, so in the next 4 minutes or so, 2 minutes or 3 minutes or so, judge is going to come back in and check up on us. We expect a lunch break and then the rebuttal argument with the juror after lunch. Are you expecting more fireworks today?
Oh, yeah. There's no way there isn't. Yeah. Like, there's been fireworks every day.
It's been crazy. This case is not disappointed that way. Give me your name one more time so I can remember.
My name's Braxton.
Braxton. I should remember that because I have a family member named Braxton. So, Braxton.
Calling in from Utah, actually.
Wonderful. I know a Braxton that lives in Utah. His last name was Hill.
Oh, wow.
It was Hill. So,
wow, very close.
Very close. Yeah. So apparently it wasn't you, but all right. Thank you, Braxton. Appreciate the thoughts. Look forward to seeing how this shakes out later today with you.
Likewise. Have a wonderful day.
You too. Bye. All right. Always more fireworks in pro se cases. They do not disappoint that way. Let's see. The hardest and most unexpected thing about cancer, oh man, is trying to survive with only one income with 2 kids, but at least I have to GoFundMe. My community here in California has been great. Still broke, but it helps. One man army. Hang in there, man. Cancer is a monster. It's a beast. It's ugly. I've lost friends to it, and it's heartbreaking. Let's see. This is great chat with respecting our fellow chatters. Yes, we have some very diverse opinions here. This is what I love about this. We've got some people who are 100% convinced that I am wrong, and there's a very good chance that they are right. But the fact that we can have this discussion constructively and discuss things without making it personal against each other and still being friends at the end of the day, that's what makes this unique, and that's what I love about it. You must defeat your Braxton twin to become the Braxton King of Utah, Alice says. Never heard of that name until this channel. Which name? Braxton? Shauna, thank you very much. Love that you're here. Appreciate that. No matter where we are, whether we agree or disagree, it's wonderful to have the conversation with you, and thank you so much for that. All right. Yes, Braxton. We speaking of Utah, we have a case coming up that we're hoping gets on the schedule this year, and that's the Corey Richens trial. This is in Summit County. This is the same place where we had the ski crash civil trial, the first civil trial we covered on this channel. It was quite the interesting trial with Gwyneth Paltrow and Braxton Hicks. That's different, Rona. That's very different. But that trial coming up is a criminal trial. It's a murder trial. It's got all the attention of the news media, and we're going to be part of that. I'd like to be there in person for that, so I could bring you not just the feed from the courtroom live from there, but also some of the surrounding information because it's an area I'm familiar with, and I'd love to be able to get to some interviews outside of court and all that during the trial. I think Stevie, I'm going to pause and say yes. We're in jury selection. The Crumbly trials. You say trials. The key word is trials. because the S there, they have split the two cases. Husband and wife will be going to trial separately. I think we're starting with Jennifer, the wife. They're in jury selection right now. We're going to finish this case out and probably catch up with that one. That's my plan right now, is to go to that trial next. It was up to the state to bring the evidence. They have the duty. They have the duty to prove their case. They have the burden of proof on their shoulders. How long are they thinking the trial takes, though? Lady Draconis, are you talking about this one or the Crumbly trial or what? We need a Law 101 shirt. Send me ideas for that to the phone, even if it's just a little sketch on a paper. Let me know what you think. I know I owe you guys some new merch options, and I haven't been very forthcoming with those. Let's see, being from Utah and seeing what's been happening, she seems real screwed. Shelby, she's done some things that have hurt her case. The wag the dog, or walk the dog, I guess was the phrase. Walk the dog letter. Oh my goodness. That was pretty bad. Corey Richens. I don't know the length. I imagine it's probably going to be a 2 to 3 week trial at a minimum. There's a lot of evidence that goes over a long time period, so it could be well over a month. Oh my goodness, there's Judge is back.
Okay, I'm back about the time I said I would return. So, Defendant presumably has had an opportunity to view the rebuttal material. Or any objections?
Your Honor, there's a couple of things I'd like to go over with Mr. Mansfield, I guess, on this. The videos, he stipulated that he would play them in their entirety. I agree. You know, if we're going to play the videos, we play them in their entirety.
Judge, let me explain. The three, typically speaking, what I'm using the videos for is to rebut her statements about IDing the second person that came in yesterday. So I pulled 3 snippets from the first video at the hospital, or 3 clips from the first video at the hospital. Mr. Tucker wants that video played in its entirety, so I will play the first video in its entirety where these 3 clips were pulled from. That interview goes on, they go outside of the hospital. I'm not playing all that. That's not my purpose in using this video. My purpose is very specific. I'm rebutting the statements that she made yesterday on the defense case, where she articulates what she knows about the second person in the treehouse that night versus what she's saying here the night that it happened.
Your Honor, if I may.
Under the rule of completeness?
Well, first off, I would like to renew my objection to the videos coming in at all because, again, the perpetuated testimony was supposed to be used solely if she was unavailable and nothing else after that. They had all this available to them at the time. They got their cross in, all that at the time, and now they want to go ahead and redo it. Since mine was stricken from the record, I would suggest that, that yes, I'm not going to get an opportunity to redo mine. I would imagine they don't get to redo theirs.
I'm sorry, when you say
her original
mine?
testimony when she came in to testify, Your Honor, it was stricken from the record. So I didn't get to actually cross her. I didn't get to actually direct her, I should say. But now they would like to go ahead and recross, even though they've crossed this testimony before.
Yeah. Okay, well, I'm going to overrule the objection because I don't believe it's a recross. In fact, it's a rebuttal, so okay. I believe they're entitled to present rebuttal, and I believe the Zoom effort with Ms. Belmont, I've covered that completely, and I don't think that's pertinent at this point.
Your Honor, I just wanted it on the record, that was all.
Yes, sir.
Okay. Now, as far as the current videos, Mr. Mansfield was not able to tell me which videos they were pulled from, so I had to go and look at all 3. I didn't do so completely, but I kind of have an idea, I guess, which videos he's pulling from. And like I said, any video he's pulling from, I'd like it played in its entirety, just for context. Because taking clips out of context, taking sound bites out, I don't like that idea. It has a danger of prejudicial impact on the jury.
So,
Attorney, I have no problem playing the video that incorporates all three of these statements. But once the last one is made, I'm not moving anything in beyond that last statement about ID. So to play that other, that's not what I'm planning on presenting.
Okay, just so I'm clear. Just let me understand the issue here. The state has, when we say a video, could you again identify what, where, when?
Yes, it's a video at the hospital the night of the event when Miss Belmont was taken to the hospital, and Danielle Malone approaches her in the hospital and begins to ask her questions about what happened at the Treehouse, and Miss Belmont gets into detail about the assailant, both assailants actually.
Okay, so there's portions of that you believe rebut assertions, statements in yesterday's deposition to perpetuate.
Correct, Judge, that's correct.
And Mr. Tucker would like to have context, so you're amenable to that interview in the hospital being played.
The portion of the interview that addresses the ID of the second assailant. Okay. Then that interview goes on, but that's not rebutting anything at that point. My rebuttal is her statements about that second assailant. So I have no problem playing the video that incorporates the discussion about the second assailant. But at that point, I don't think there's any purpose in playing the rest of her interview because I'm not using that to rebut anything.
So, is there anything further from the defense about this issue?
Yes, sir. Because innately, I guess, what Mr. Mansfield's trying to argue is that we're not going to use these cuts, but we're going to go ahead and cut it. Cut it right then and there. And again, you're removing all context of where what was happening, what was going on, her state of mind at the time. I mean, you're really, again, if you're going to use this as a rebuttal, you have to provide the complete picture.
There is a rule of completeness.
90.108.
That doesn't go to the entirety of the interview.
No,
if there was some statement that she made and they chopped it off in the middle of the sentence or within a paragraph that explained, that would be one thing, but there's no obligation to play the entirety of the interview.
Well, it's not that long, Your Honor, and to be quite frank, I mean, I'm looking through the deposition here, and that's exactly what they did. They chopped out different sentences.
Well, as long as those sentences are not misleading or they're, but...
That's why we haven't gotten to that part yet, Your Honor, but I'm saying is, the video is not that long. If it's the first one, if that's what he wants to use, I don't see why we don't just play it in its entirety.
I've already said I'll play that one in its entirety, the first video.
Okay, and that's the only one. That's the only one with the cuts, right?
So we both know what we're talking about. The first video.
Yeah, we're in agreement.
Okay, so all right, fine. So what other objections are there?
Well, at this point, again, I've been going through the deposition. And I'm almost inclined to want to go through literally just submit the entire deposition. Because, I mean, again, these sentences are cut out. They're cut out from, again, they're taken way out of context. And if we want to provide the jury a clear picture of what she said, I think we give them the entire deposition.
But that's not the goal.
I mean, he's almost doing it already, Your Honor. He just takes out the stuff he doesn't like.
Well, again, if it's misleading, if it's not complete, but
that would be the case.
state is not under an obligation, or vice versa, either party is not under an obligation to present adverse material to their case, especially if it's just redundant as to what the other side already presented. Well, so if there's some particular excerpt that's objectionable, I'll be happy to look at the
Your Honor, like I said, I haven't had a chance to go through the entire thing, right? But as I've seen so far, right, literally we would have to go through, and again, we're going to have to go through piece by piece by piece. And yes, there's different parts where, yes, it is definitely misleading.
Well, well, let's get started because I'm
Oh, and the other thing, Your Honor, I did have one more issue, or not issue, but one thing I'd like to address is, okay, if they want to go ahead and play this video as a rebuttal, we have videos that actually add context to this video that we would like to play.
Okay, so,
the defense doesn't put on a rebuttal to the state. I'm rebutting evidence he introduced yesterday with that video at the hospital and the deposition. We've already covered the video from the hospital. I would submit we need to start going through the different deposition statements and see if the court will make a ruling as to whether we should be able to go into those or not.
In all honesty, Your Honor, I mean, this should have been addressed before we came in today. I would say, you know, I mean, it's not like I haven't been, you know, available for communication. I haven't been available to go ahead and go ahead and look at these things. But what I'm saying is, okay, again, she says things in this deposition specifically in response to things that, you know, happened outside of the deposition. And again, it takes it out of context.
Okay, well, again, let's look at the specifics because that's how we handle it.
I would agree. That's fine, Your Honor.
Okay, so this deposition was a discovery deposition?
Yes, sir. Back on May 1st of 2019.
Do you happen to have a copy I can look at?
Judge, I gave you the excerpts.
You gave me the excerpts, yeah.
You want the entire deposition?
I can actually.
I have it.
Well,
I disagree with the judge. Florida's version of the rule of completeness. When one party introduces a part of a document or recorded statement into evidence, the adverse party can insist that some or all of the balance of the document be recorded or recorded statement be introduced contemporaneously, meaning they have to play the whole thing.
Thank you.
If he's saying, I want to cut it right here, I don't want anything after this point.
So
I believe the judge is wrong in this ruling.
Judge, first and foremost, let me draw your attention to the beginning. The witness was sworn in, so we covered that. The first excerpt the state intends to potentially use is on page 13. It's a rather involved question and answer about identity. Yeah, and dark clothing. I don't remember. It's been a year.
Wait. Hold on. Could you please just give me a second to pull it up so that I can follow, please?
Right. Page 13, line 1, just reading from the, actually, from what I can see, it's lines, you want to use lines 1 through 25.
Yes, sir.
Okay, so go ahead, read it.
The first one.
Actually, I can read it. I don't need you to.
Fair enough.
Let me read it.
Let me read it to myself, he says. I do think the rule of completeness applies here, especially if there's something afterwards that may change the perception of what happened before. If there's something that says, you know, at the end she's like, I'm on drugs, I can't think straight, right after she says it could have been Tyrone, yeah, that's relevant. The tally spiked a little bit. I might have missed a couple here. You keep me honest on this one, on this Law 101 count. I appreciate Solomon Anderson being in chat. We've interviewed him before. Thank you, my friend. I still am open to interviewing again. I think we need to work out when we can do that down the road. I'd love to do it, mostly because I'd like an update on the appeal process. I still am of the same opinion I was before, but I will say once again that Solomon Anderson was incredibly respectful, knowing that I came into the interview thinking his brother was guilty. And for him to be willing to come on the channel and talk to me and share his opinion and do so in a very respectful way, mad props. I really, really enjoyed that. Solomon's he's a smart guy. He's a nice guy, and he 100% believes what he's fighting for. I think we're on the same page as far as believing that Zach deserves the appeal to be granted in a new trial. I'd still have to hear different evidence to change my opinion about guilt, but I think we're a little closer, at least on that point.
I don't have.
Thanks for being here, Solomon. Appreciate that. We need to talk.
In opposition
to schedule
in this section, Your Honor, but she does go into later. She actually says some things that add to this section.
Okay. Frank, if you have no objection, that's fine. I honestly, starting at the top of the page, it's like confusing. I don't know who it's talking about, and moreover, it doesn't seem to be inconsistent. She's talking about Rory Wilson, at least on.
Judge, may I jump in?
Yeah, go ahead.
So, I included the beginning of the page just for context, but she really gets down to it. line 10. Are you sure it was Rory Wilson? Absolutely, without a doubt. Who else did you see there that night? No one that I can identify. Do you know Ty Tucker? I know him, yes. Did you not see Ty? Not that I can identify. I saw another person, but I can't identify him. In the perpetuated testimony yesterday, she was adamant 100% when Colorado asked her that it wasn't Ty Tucker. Here she's saying she can't identify the second person.
I understand that would be inconsistent with the testimony. I just didn't, again, understand how the portion about Rory Wilson. But again, if it's given context.
Your Honor, could I again interject here? I don't mean to. I don't want to step on your toes, but okay. But this is what I meant by the videos again. Because it is inconsistent with a statement she made, but she also says in her videotape deposition, was the perpetuated testimony. She says there was a time there that Detective Pitcher had her thinking it wasn't me, and unfortunately, this is the result of that time, which we have the videos of where he is confusing her. He is giving her other information. He's feeding her information, saying it wasn't me. That is, again, not inconsistent with what she says in her perpetuated testimony. She says exactly that.
This is a good argument.
Well, I'm going to overrule the objection. I mean, if
I just think it would prejudice the jury to think that, man, she's actually saying something. Again, she is in different states of mind depending on when these were asked.
Right. This happened immediately after the episode.
Not the deposition.
Oh, not the deposition. You're right. But in any event, I think that I
think in all fairness, we should show the context. I mean, again, she says that Detective Pitcher had her questioning at a given point, and I can see why when you look at the videos.
Okay. In any event, I'm going to allow this particular excerpt. Yes. So then we go to the next page.
Page 14.
This is just a continuation.
It is a continuation, Judge.
Okay. Let's see.
Lois Cox just gifted 5 memberships. Lois, thank you so much. For those that don't know, Lois helped out a ton on my trip down to Florida with the Maya case for being in the courtroom. Helped us out with the media down there. Thank you, my friend. Thanks for your generosity too.
Okay. Is there any objection to this segment?
Yes, Your Honor, because again, this one actually does have sentences that are removed. They have, again, there's things in here that are removed. I'd have to again go over quickly here just to make sure that
sentences that were removed.
Yes, there's statements that are actually removed from this. I mean, if our copies are correct, it's
page 14, lines 1 through 25. What's removed?
Okay, let's see. We've got you saw 2 people.
This is I'm looking at the transcript.
I'm just making sure mine is on part.
It's a bold assertion.
Yes, see. Okay, no. Second person.
He's comparing the 2 documents. I think he's wrong here.
So far, nothing inconsistent.
So far, nothing inconsistent, he says.
See, and this is where I'm getting it at here, right here. This is the section where it's been removed, Your Honor.
What section, sir?
No, I can't. I don't remember. I know at one point a small knife fell. I know at one point another stick fell. I believe that is when Roger got it, but you are talking a year and a half ago, and they are memories that I try to hide, so I can't answer that honestly.
Why do you say that's been removed?
Because I don't see all of that there.
Well, I don't know. What I've been given, it says the whole page.
Because, I'm looking at it, Your Honor. It goes, okay, let me see.
Goes page 14.
Oh, you know what? Hold on. I may be mistaken. Hold on a second.
I think he's mistaken on this.
Okay. Now, let's see. We're at line 20. Did you see the second person? Okay. Check it again right here. Okay, I'll backtrack on that, Your Honor. It was my mistake. I was reading the wrong section.
So to be clear, Judge, nothing has been removed.
But let me again check it for inconsistency. So I want to see where we're inconsistent here. Because okay, the only thing that I see that's inconsistent with this is, you know, that she thinks that, you know, at one point where Rory Wilson has the billy club, which again, you know, I don't see how if he's on top of her slicing her throat, she, you know,
it's not evidentiary.
Billy club.
It's.
Well, Judge, it doesn't matter what he thinks. She said in her perpetuated testimony that the guy on top of her had a knife to her throat and the other guy had the billy club. And here she's putting the billy club in Rory Wilson's hand.
Again, this goes back to state of mind.
Yes, and those are all subjects that you can make closing argument about. The issue would be weight and credibility as opposed to admissibility. In other words, I admit it, but if you care to and you believe that this was she was confused, that her mind had been somehow or other impacted by some other event, or that it's unworthy of belief, that goes to the weight and credibility. It doesn't go to the admissibility.
No, and Your Honor, I would agree, and I'm just saying that she did make those statements in her current state. You know, in her current statements, she said that, you know, she was confused by Detective Pitcher.
Okay.
Now, the only other thing, Your Honor, actually, let's make sure I'm correct here. No, go ahead. As far as that section, I have nothing else, Your Honor. I'm good there.
Page 15, lines 1 through 25.
Judge, before we do that, so on page 14, is this court ruling that the state's allowed to introduce those statements?
Yes.
Okay.
What Mr. Tucker's looking for here is for parts of this deposition, presumably outside the portion that the state wants to introduce as rebuttal, that may put the part that the state introduces into perspective or add additional context to those statements. So if he can't find those, the judge will most likely rule in favor of the state.
The objection to this
those
page.
Little excerpts.
Quite honest, I'm trying to remember exactly what Ms. Belmont said in her testimony as far as the altercation. I'm not sure if it's. I can't honestly be sure if it is or it isn't.
Well, let's hear what the state's explanation is or argument.
Very well. Page 15, she clarifies who was in what position. During her perpetuated testimony, she was all over the place about who was where and who was doing what. So here she somewhat clarifies that when Matt came up the stairs, Rory was behind him and who was facing Rory when he came up the stairs, et cetera, et cetera. So she clarifies a lot of where she was on the perpetuated testimony, which was all over the place on who was where on the inside. She also clarifies about there being a small knife that fell. She wanted to get it.
Your Honor.
Yes, sir.
The small knife is in reference to a knife that Roger Rugged had, and yes, you did try and go after it. I don't see where that, again, I don't know where that's going to come in as inconsistent. But as far as, being all over the place, again, she seems to be all over the place in here too, as I'm reading it.
Yeah.
Maybe I'm reading it wrong.
Well, I would agree with you there.
He's reading it wrong.
Is there an objection or no?
The only objection you would get from me, Your Honor, is I don't think it's inconsistent. I mean, she's all over the place. I can barely keep up with. I'm trying to picture in my head what happened here, and again, it is all over the place.
Well, yeah, I mean, Mr. Mansfield, unless there's something specific, it's really just hard for me to be able to pigeonhole this into a prior inconsistent statement. It just seems too broad to me. I would incline to sustain the objection.
Okay. Judge, and that was it. It was just basically lines 12 through 18 about who was where coming up the stairs and where was he in relation to Matthew Bonner. But it is vague, and that's fine. I understand. I won't use 15.
All right.
So Tucker won. It's a rare win for Tucker in court. Objected to rebuttal material.
16 lines 13 through 25.
Do we subtract the Law 101 for the win? No, we don't.
Mr. Tucker?
I'm looking at it again, Your Honor, because this would be one of those where I was talking about lines being cut out, because it is starting off at 13.
Yeah.
And I just want to make sure that there's nothing that adds context, before that or after.
Well, there's nothing special about the pages. It's not like they're organized by.
That's all.
They're not organized by subject matter. They're just, chronological recordation or transcript of what was said.
Recordation, word of the day. Michelle, Tucker has a style of questioning people where he states what he believes their statement is, that he states it as fact. I think he's done that during questioning, which makes it seem like he's saying what was happening.
Yes, I think we killed him. That's what I heard him say.
Page numbers, a chronological recordation.
That's the prosecution. What's inconsistent here?
Judge, what's inconsistent is right at the beginning, I couldn't see the second person hardly at all, except he was the littler person. And in her perpetuated testimony, she's giving these statements about being 100% sure it's not Tyrone. It wasn't his physicality. It wasn't his stature. It wasn't his walk. It wasn't his persona, whatever. She went on a whole litany of explanations. But the truth of the matter is, here in this depo, she says, I couldn't see the second person hardly at all. In her perpetuated testimony, she was adamant it wasn't his walk, it wasn't his this. It's completely contradicting what she testified to.
Your Honor, if I
Yes.
may. Again, I don't see it that way because, okay, she does say that she has trouble seeing him because, Rory Wilson's on top of her and she only sees parts of it. She actually later on goes to say in this one that their best view is when he actually goes down the stairs. Now, at that point, she definitely can see size, and she does say that he's smaller than Rory Wilson. She repeated that many times in the perpetuated testimony. Again, it's
not an inconsistent
I don't see where it's
statement.
inconsistent here. I mean, it may be a little bit, again, maybe
it's a variation.
Confusing, but it's not inconsistent.
Well, did she ever say definitively who among those two people said, I think we killed him?
She thinks the second person said that, but she said here that she barely saw the second person, and she heard the second person say that. In her perpetuated testimony, she was adamant the second person was not Ty Tucker.
Well, she doesn't say specifically in this that it was or it wasn't. It's not inconsistent. She just doesn't say it. She doesn't mention it.
Well, I think that the statement, I couldn't see the second person hardly at all, except he was a littler person. I think there's an inconsistency there in terms of one's ability to be so adamant as to who it's not. Now, if you want the rest of this stuff carved out, I might be inclined to do that, although I think this is precisely what you were concerned about, Mr. Tucker, as to context.
I would agree. I'm looking at it right now. I'm just trying to figure out context right here. And it's like, okay, because I know she makes other statements, and I haven't, Your Honor, I did not have enough time to go through the deposition in its entirety. I'm happy we're doing it now. But, so I haven't had a chance to look at the entire thing. But I do know she goes into it later where she's talking about, again, she sees different details. Just because she only, they pick out one detail here doesn't mean she doesn't, say other details in another section.
Well, in any event, I don't understand why this business about Todd O'Quinn at the end is in there.
I can take that out.
I mean...
Again, it was for context, but leave it in or take it?
Well, so line 13. Okay. Okay. Line 14, line 15, line 16.
I think I would object to those, Your Honor, just because she doesn't say who says it. Like, she doesn't say that it was, she doesn't actually get asked whether or not, she recognized the voice, anything like that.
Judge, I would propose that we potentially cut it off at line 18 because that's the sum and substance of the identification.
It's interesting that Mr. Tucker's been arguing for completeness, and now they're cutting pieces off.
13 to 17, is that correct?
18.
To 18. 18 answers the question.
Okay, yeah, I mean, that would be
all right.
That would be fine.
So now we're on page 17.
That motion has not been filed yet.
14 through 25.
There was a motion for continuance filed this morning that the judge dismissed. The continuance was to give them time to file this motion to disqualify. So unless he writes it tonight, it's not coming in this court case. I agree, it's Triton. These contradictions, these are not gotchas. These are not blaring. If anything, I think the jury's going to listen to this and think, yeah, we already heard this testimony. It doesn't just reach out and grab you as a contradiction to what she testified to before.
What about this one?
He's had the discovery for 7 years, but realize many of those years he had lawyers that were working this for him.
Okay, this would go back to that whole picture thing. Because, yes, he does confuse her and has her at a point where, and she says that it's not inconsistent with what she said in her perpetuated testimony. She says specifically that picture confused her about things. And she says right here that she is confused.
Where does she say?
Well, I mean, she's not saying specifically she's confused. What she's saying is, no, because I didn't know he had anything to do with it, or if he had anything to do with it, I didn't know what they all lived together. That was being perpetuated to her by Pitcher. And, again, he specifically sat there and told her, Ty Tucker did this, Ty Tucker did that, Ty Tucker, has a long rap sheet, Ty Tucker has all this other stuff, and he's literally pumping her full of it. And she says that, it confused her.
Where's the inconsistency here, State?
Judge, during the perpetuated testimony, she talked about knowing that it wasn't Ty, that Pitcher had told her, and she kept saying to Pitcher, are you sure, because I don't see it,
That's
and here she says, didn't you tell him at the time that you knew he had nothing to do with this? No, ma'am, you did not know, because I didn't know he had anything to do with it, or if he had anything to do with it. I didn't know that they all lived together.
And
And so, wait, just let me...
The absence of evidence is evidence?
Ruminate on this a second. So what is this inconsistent with?
During the perpetuated testimony, she articulated that she knew it wasn't Tucker that was the second person. That is not what she's saying here. Here she's saying that I don't know if it was him or not. I don't know if he had anything to do with it or not at that point when they met at McDonald's. In the perpetuated testimony, she was adamant that he wasn't the second person.
No, the defense argument is...
Yeah, the prosecution just made it for me. He literally just spit back what Pitcher was telling her. And again, he's sitting there telling her. She's like, "Are you sure? Are you sure it wasn't Ty?" And he's feeding her a bunch of stuff that says it. Says her memory is wrong. And later on, after she found out that Pitcher was lying, yes, it solidified her memory.
Judge, he can argue all day to the jury about what Pitcher put in her head, but this is an inconsistent statement from what she made in her perpetuated testimony.
That's why I say it's unfair to put it out of context when she says that happened, and yes, we know it happened. You just repeated it, but you want to use the section where she was being confused by him.
Was he? I'm sorry. I mean, obviously he wasn't the deponent here.
No. He literally pulled her in the squad car. I don't know how many times, and literally sat there and said, "It's Ty Tucker. It's Ty Tucker. It's Ty Tucker," over and over and over again.
Well, I mean,
and then blatantly lied to her about a whole bunch of things, and she kept on going. "Are you sure? I don't think it's Ty. I don't think it's Ty." And she's saying, "Are you sure?" And she is obviously confused by the guy, and she says that in her perpetuated testimony. She, again, there's nothing inconsistent. She says at one time she was confused.
Okay, so maybe this was one of those times, but nevertheless, it's an inconsistent statement, so I'm going to overrule the objection.
The judge is wrong there, I think. She literally testified that she was confused. I don't know. Maybe he's right. It is an inconsistent statement.
Page 18.
Oh, man.
Lines 1 through 25.
That one's on the line for me. The perpetuated testimony was Paula's deposition. They tried to have her in as a witness over Zoom, and that did not work well. They struggled with that. They had to cut it off and ended up striking the whole thing for the record. And then they said, instead, we're going to perpetuate her testimony by playing her Zoom or her deposition.
Objection here. I mean, this is one of the ones where I say taking the sentences out of it definitely changes the context.
What sentences are taken out of it? I see 1 through 25 as what the state's...
Yeah, I'm looking at it. I'm like, okay, let's see. Hold on. No, after, okay. Police didn't tell you that. She goes, who told you that Ty had something to do with it, right? Let's go back here. Nobody told me. Police didn't tell me. No. Well, afterwards, when they arrested him, yes. So, and that
It's not removed. It's right there in the
I would assume you would...
Sorry.
You would want that based upon what you've...
Not afterwards, arrested. Okay.
There's no way the state edited the transcript.
Because there's nothing inconsistent so far.
There may be nothing inconsistent, but don't keep accusing the state of editing the transcript and cutting lines out. That's not going to fly. The inconsistence is he's looking at this statement to see where she says something that doesn't match up with what was in her deposition that was played in front of the jury. If there's an inconsistency there, the state can present that as a prior inconsistent statement in rebuttal. And I don't think that last one, I don't like the judge's ruling that he'd allow it, because she literally said there was a time when Mr. Pritchard had confused me about what was going on, and I thought, he's told me it was Tyrone Tucker. There was a time. She admits that, and now they're presenting that, saying you were inconsistent because previously you said there was a time. Here you're saying it might have been him.
This is actually hearsay too, Your Honor, as far as the things that I say, right? Because okay, I'd be happy to clarify what I said in there, but you're taking my testimony and putting it in there.
Well,
statement by opposing party.
A statement contrary to interest is admissible against the party if it's in fact contrary to one's interest. You're right, it's hearsay, but it's one of the many exceptions to the hearsay rule, which is why in many cases, statements made by the defendants are admissible if it's against interest. So,
Your Honor, the thing is, there's nothing against interest in this. I did make that statement. I made it on video in my interrogation. That's where I learned about the knife. That came from Captain Phelps. I learned it from there. So it's hearsay from her to me to Paula, which the state knows.
Well, state want to respond
Sure.
to
The inconsistency here starts with line 9. What kind of question is that? I had told you I can't identify him. The person was wearing a mask. In the perpetuated testimony, she's saying it's not Ty Tucker. Here she's saying I can't identify him. The person was wearing a mask. So here she can't say that. And then the perpetuated testimony, she's saying it was, I don't know who it was, but it wasn't Ty Tucker. That part I know. That's not what she was saying here. So that's an inconsistency.
Well, I would
and
have
then,
that is not an inconsistency.
And then if it continues on, it's the context of this conversation. When you get to the next part, in page 19, the knife that the police found had Matt's blood on it. That's what he said. That's what Tucker told her. And you hugged him at McDonald's? Yes, I was upset, crying because of what Roy did, not knowing, like I said, not knowing that Ty Tucker had anything to do with it, because I can't identify him as being there one way or the other. So here she's saying she can't say he was there or he wasn't there, and in her perpetuated testimony, she's 100% sure he wasn't there.
That is fair game.
So that is the inconsistency that is being articulated in the from page 18, line 9 to page 19, line 7.
Again, Your Honor, like I said, I'd almost have to, because again, you're talking about the same thing she said, and I've already argued this a few times. And yes, I understand it's an inconsistent statement, but she says she did this in the perpetuated testimony. She says she did that.
She said she did what?
As far as her story was, she was confused because of Detective Pitcher, and that's why I suggested if we were going to do it, we might as well play it for context, because again, it's highly prejudicial, and yes, I think it outweighs the value that he has here.
Right.
It's more prejudicial than probative.
The objection here. So from page 18, line 1 through page 19, line 7.
Oh, and I'm sorry, Your Honor. As far as the hearsay, if I remember correctly, I am allowed to add context as far as my words in that.
What do you mean?
If I remember the hearsay exception, I may not be remembering it correctly.
How do you mean add context?
I actually have a chance to respond to what I supposedly said.
This is if you're challenging someone.
I can't remember the hearsay.
Well, okay. Are you going to be testifying? I guess
you missed that part.
You told me earlier you were.
Well, I wasn't planning on it, but if they're going to go ahead and put my words in here, I might have to.
Whoa.
Judge, I think what he's saying is that somehow he would be able to get up and flesh this out, and that is not how this works. This is her statement in her deposition that contradicts what she said during the perpetuated testimony.
Well, okay.
Go ahead, Your Honor. I'm sorry.
Hold it.
The judge has his head in his hands.
Let's go back here. I want to be sure before we get into the rebuttal case that...
Do you want to testify?
You were not going to testify in your own case, because I didn't go through that colloquy, and so based upon what you'd said earlier in the proceedings, that you absolutely weren't going to testify, I assumed that wasn't the case. But if that is the case, then you would I would certainly allow you to testify before the state's rebuttal case if you want to include your testimony in your case in chief. So I didn't go through that colloquy, and I'll be happy to let you testify in your case and tell the jurors that, that's part of your case if that's what you want to do.
I don't think he wants to.
Your Honor, I would, at this point, I would almost say I'd have to, because, I mean, the state's putting out things that I said in response to the things that happened, and, I mean, I'd almost have to. So, I mean, because that's the only reason I didn't plan on it. I didn't plan on hearsay testimony from me coming in.
I understand. Trials, you can't completely plan, but I want to make it clear, your testimony would be now. This at the beginning of the afternoon. It wouldn't be after, at this point, the state's rebuttal case. So
I would tell you, actually, Your Honor, if I could do it in narrative form as you suggested, yes.
Narrative form means he doesn't have to ask himself questions.
So,
there will be objections.
Input from the state, as I said. I didn't go through that colloquy. I was occupied with many other things at that point, but I always, before we go any further, go through a colloquy with the defendant.
Correct.
So
we have to do that if he wants to testify. He's got the right to testify. So
you have to do that either way.
Okay. So as long as you understand, Mr. Tucker, we come back and I'd explain to the jurors that there was one more bit of evidence or one more evidentiary presentation, and that would be the defendant's testimony. That's your right. Nobody.
I think at this point that would be the best, Your Honor.
Well, that's your choice.
This opens the door.
And yes, you within reason, you can testify in narrative form. That would certainly mean you have to speak at a pace, not a rapid pace. And normally I tell people who do that to kind of break it into segments and just not one run-on, because it's not ideal. It's awkward for a person to ask the questions to themselves.
Very awkward.
So, Your Honor, again, if you give me a second so that I can go ahead. I got to figure out where I'm going to start, where I want to end, because I don't want to just run on forever and just rattle off. But yes, I can go ahead and I can testify via narrative form. As far as objections, could I make them from the stand? That's the only question I have.
Yes, you'd have to be able to, but of course, the direct is, the cross is subject to the scope of direct within reason, but that can be broader than one might imagine.
His prior criminal convictions, if any, may be brought up.
I've never seen it in the narrative. Is there any way to have a lawyer direct him while he's on the stand and have his testimony elicited from a direct examination?
He's his own lawyer.
Not a lawyer that I know. I'm not going to. No.
He's got these advisors. I don't know if they're available.
They're not counsel of record. They're
and they're not available, Your Honor, or else I would ask them.
Well, then they have to make an appearance, and if they're willing to, put their name back on the dotted line, so be it. But otherwise, that's the way I've seen it done, and it's manageable as long as the person isn't speaking a mile a minute, which I don't think Mr. Tucker does that, and as long as they, pause and,
The only thing I would ask, Your Honor, because I'm just looking for some direction here, because, again, things that happened over the course of this thing, I talked to other people, I had experiences with, different people.
Mm-hmm.
I'm sure some of that would be hearsay, it'd be objectionable. I don't know how I curb that, so to speak, and tell the story.
I really can't tell you, other than it's you
just try
like
to
any witness. I don't know what to tell you, other than I'm going to assume that the state will make objections they deem to be appropriate, and I'll make my best ruling. So if you want to testify, again, I just want to make it clear that it would be when we get back. It's not in the wake at this point of the state's rebuttal. It's part of your case in chief.
Okay, that sounds fine, Your Honor. It's just I think it's better. It's best at this time. I wasn't aware that the state was going to do this. That's
I understand that, and again, I'm in an abundance of caution. I'm revisiting the issue about your testimony, and because I'd made an assumption you weren't, but now you are, and that's fine, and that's your right. And so, in any event, to some extent, we're going to continue with this exercise here.
I guess we should, Judge, because I'm still planning on the rebuttal case. So.
All right.
Okay, so now we set aside the rebuttal.
You're going to rule through page 19 would be admissible.
Yeah.
Oh, hold on. Where were we at?
We just dealt with.
I think Mr. Tucker made the right argument, but about the wrong
18,
person.
Lines 1 through 7 on page 19.
I believe.
Oh, I'm sorry. 18, 1 through 25, 19, 1 through 7. So now, page 32.
I believe Paula should have the opportunity to rebut or explain her prior inconsistent statements, and them just presenting that without letting her answer and explain that. I think that's wrong. I think that's the rule.
Did you see who took your purse? The other person with the backpack. And what did the backpack look like? It was black.
That's
black?
not inconsistent.
It was black. Okay, what's that?
Judge, it was context. I'm not worried about it. We can take that out.
Okay, take that out.
Thank you. Yebamos. Thank
Page 33, line 2, 3, and 4. And what was in it? Stuff. Perfume, $27. I don't know what else was in it. It's been a year and a half.
I think Mr. Mansfield and I agree. He wasn't sure if it was inconsistent.
I don't think so.
I wasn't either, so.
I don't think so. She pretty much parallels her testimony that I recollect. So that's out. Page 38.
I think he stands more to lose than he stands to gain from testifying. I don't think it's the right choice. I think the judge made the right choice in stopping everything, saying, "Wait, you want to testify? I should have done that." Yes, that was appeal written all over it. Maybe even also already with the fact that he says the state's rested and Tucker wants to testify. That still might be an issue. Now that they're going to go back and open it up, but at least they didn't go too far. I think he can correct it now.
Mine's coming from the cloud.
The way the judge has changed his attitude this afternoon, I've got to think when he said I've got to go back and look in the reflecting pool, if he made a phone call to a friend and said, "Hey, this is what's going on." Yeah, you might want to be careful there. You're walking on a thin line. Oh man. Maybe the chief judge, who Tucker said he's been in contact with regarding this.
Mr. Mansfield, do you happen to have an extra copy?
Of what?
Of the original deposition.
No.
Mine, it's coming from the cloud, and it's just
I don't have that.
We can look at this if he wants to.
Thank you. Thank you, Your Honor.
Okay, we've got to wrap this part of it up.
Thanks.
There was a scuffle between them, and Roger got thrown like into a tarp. I don't believe I said he was beating him. I was the one getting beat, but there was a scuffle between those two, the other person and Roger. And you saw the second person holding a knife to Roger's throat? No, ma'am. You did not see that? No, ma'am. You were told that? I was told that by Roger. That is why Roger wasn't helping me. And Roger was the one who told you that the other man had a knife to his throat? Yes, ma'am. But you never saw that? No, ma'am. I couldn't see past Rory Wilson because he was on top of me beating me for the third time. I have told you.
Okay. I'm sorry, Your Honor.
Yeah, go ahead.
I don't see anything inconsistent here.
I'm trying to see it myself. So what is the point here?
The inconsistency, Judge, is that she said she saw the other person holding a knife to Roger's throat. Here she's saying she didn't see it, that she was told that by Roger, and she says, I couldn't see it because I couldn't see past Rory Wilson, who was on top of me beating me for the third time.
That's what she said yesterday.
In her perpetuated testimony, she said she saw the second person with a knife, holding a knife to Roger's throat. That's not what she's saying here.
Your Honor, if I may.
Yep.
If I remember correctly, she said she thought the other guy had a billy club, not a knife.
At one point,
That's
she
the
said
consistency.
that, but
And then she also puts the billy club in Rory Wilson's hand at one point.
No, that is true. And when I was looking at this testimony, she does. And it's like I told you, she's highly confused right here. And especially the hospital one, she definitely is.
Mr. Tucker's making the stakes argument for validating this as
I'll
inconsistent
overrule the
statements.
objection. I believe it's within the scope of impeachment. So page 43, lines 1 through 10. I don't know if he was the driver. Is that the one that was arrested for being the driver? Question, yes. No, I don't know him. Have you ever seen a picture of him after he was arrested? Okay. Who showed you a picture in the newspaper? And you didn't recognize him? No.
You guys, we're removing all comments that talk about contacting people involved in this case. We're observers on the outside. Please do not.
Okay, and so
don't even bring it up in chat. It's not something
maybe that's
we would want to do.
inconsistent with the Zoom, but I told them to disregard that. It's not in play, so unless there's some...
I thought in the perpetuated testimony she said that she looked in the newspaper and saw the picture. You know what, Judge, that's fine. Take this one up. It's fine.
Page 54, 14 through 25. The second person that you can't identify, do you know whether or not that person was white or black? I couldn't tell you. Okay. Only that the person was smaller than Rory Wilson. Yes. And you believe it was a male? It was a male. When you heard his voice, yes, but the voice did not sound familiar to you? No, but it wasn't Rory Wilson's voice. So
the inconsistency there, Judge, is in her perpetuated testimony. She testified that it wasn't Travis Tucker's voice, and that Tyrone Tucker's voice, and that she knows his voice, and she was even specifically asked, do you know if he was masking his voice or not? And she said it didn't sound like it, and it wasn't Tyrone Tucker's voice. Here she's saying, you heard his voice, yes, but the voice did not sound familiar to you? No, but it wasn't Rory Wilson's voice.
That's consistent. That's consistent. It wasn't Tyrone. It wasn't Rory.
So we'll allow it. Page 57, lines 18 through 25. I may have asked you this. The second person that you can't identify that was there, do you remember what that person was wearing? Dark clothing and a mask. Did Rory Wilson have on a mask? Yes. Were the masks the same? I don't know. I didn't get to see the second person.
Again, Judge, it just goes to her statement that she couldn't see the second person, which is contrary to her adamant testimony in perpetuation. Her perpetuated testimony where she was adamant that it wasn't Tyrone Tucker.
This
is the last page, correct?
Page 57, lines 18 through 25 is what.
Thank you, sir.
Mr. Mansfield is looking at that as if the person was Tyrone. And if it was, then it would be an inconsistent statement. But she says it was not Tyrone. So it's a consistent statement.
She says that.
I think this will go and actually serve to help Mr. Tucker
Second person. And
more than help the state.
if I remember correctly, in a second. I think Mr. Mansfield and I talked about this, in her perpetuated testimony. She says like it was a hoodie mask kind of thing.
I'm sorry, I didn't hear that last part.
I'm looking again at the. Hold on, let's see, because this goes over into page 58.
Well, right, but you said he was wearing a mask. Yeah. Did you see the person from the back when he was leaving? His darkness, what kind of mask was it? I don't know. It was dark. The mask was dark, like a hoodie mask.
That's not inconsistent.
I can't tell you anything about it other than that. So
that's what I mean. That's not inconsistent. She said, literally, she said it was a dark hoodie type of thing. She doesn't say anything specific about a mask. She doesn't say anything like that.
Yeah.
Tucker wins another.
Judge, 58 was more in context with the last lines in 57 where she says, I didn't get to see the second person, which again completely contradicts what she's testifying to in her perpetuated testimony, that she can't ID that person, but she knows it wasn't Tyrone Tucker. Well, how can you say that if you didn't get to see the second person?
Again, Your Honor, in perpetuated testimony, she says specifically she got a look at him from the side. The best look she got at him was going down the stairs. She didn't, because again, Rory's all on top of her. She's getting glimpses of him. She never says that she sees anything. Anything that is, again, is going to specifically.
The point that the state.
She doesn't say anything about the mask, basically. But she says other than it was a black hoodie type thing.
But the point that the state is trying to make here, which they've been trying to make many of these
it's kind of repetitive
quotes, is that Miss Belmont was adamant it wasn't Mr. Tucker. She was adamant. And then state's trying to say, how can you be adamant if you didn't see the person? That's the point they're trying to make.
I understand the point they're trying to make, but again, she says that in her perpetuated testimony. The biggest things that, for her that were the identifying features were height, which she did get. She says again, in this she's saying, okay, she didn't get a good look at him, and she does say that in there. Okay. But height, weight, and most importantly, the voice.
Right. Well, I believe it's within the scope of impeachment. The only question is, do you want page 58 or not? Because I would think, based upon the arguments you've made, that would almost be advantageous for you. But Mr. Mansfield's suggesting he would strike that, agree to have it stricken. But
no, I mean, if we're going to put the one in 57, you might as well put in 58.
Okay, so that's that. So we're going to come back at 1 o'clock then, and again, Mr. Tucker, you're
testifying.
You're going to testify. You've informed me.
Yep.
That's fine. The only thing, and I will. You can certainly, as we discussed, when it's crossed, you can raise an objection. The only thing I think it's important to be mindful of, and I'm not suggesting you would do that, but testimony is different than argument.
I understand that.
Oh, okay. And similarly, when you get to final argument, that's different than testimony. But you understand that distinction, so then I don't need to explain it.
Your Honor, the only thing I do still
It's
have
not-
a question
it hasn't happened.
is like some of these, like the one where he's talking about, I talk about the knife and all that. I mean, I don't want to get into too much hearsay, but I mean, I was actually told that, so how do I address those type of things when I was told something like that? And that's what I'm telling DePaul.
I really can't.
It's a hairy.
I can't really answer that question.
Just deal with it when you get there.
I'll have to hear your testimony. I'll have to hear if there's an objection. I'll have to make my best decision. But as a general proposition,
no, you did not.
Hearsay is a complicated matter. Judges and attorneys review it and have courses on it and read treatises on it on a regular basis. So your question is certainly not unusual or not something that isn't fairly debatable, but I can only make rulings when I hear it and when it's objected to.
In your story when you can't say who you talked to or what you said.
I'm not here to impose limits other than the rules of evidence and procedure.
Okay.
Judge, I would just ask the court that Mr. Tucker should not be able to go into the IA investigations and all the
I have no
collateral
intention.
things that came out, because that's hearsay. It's not been admitted into this case, and he shouldn't be allowed to testify to it when he's on the stand.
Internal investigation.
He just indicated he didn't intend to, and I, as a general proposition, would be consistent with what I've ruled thus far. It would be inadmissible, but we'll be back at 1 o'clock.
Okay, thank you, Your Honor.
Okay, I see a big problem right here. The colloquy still has not happened. The judge saying, oh, I didn't do it because you said before you didn't, but now you're saying you want to. Okay, I guess you can. That does not equal colloquy. The judge needs to have the discussion with the defendant so he's clear and he understands what is happening, what's at stake, he needs to know that he can be forced, if he gets up there and testify, he loses his right not to testify in his own defense. He loses that right. The state will get up and ask him hard questions that he has to answer. This is appeal. If he testifies here and then blows it, completely loses his case, blurts out stuff that he doesn't on the cross. Colloquy should not happen before a jury. No, that happens outside their presence, but the judge has not done it. He has to read it. He has to go through this process. This is a procedural step, that a checkbox that has not been checked in this trial yet. There's still time. He can still fix it. Before the jury comes in, he might go through the colloquy with him. And, if I were the state, oh my goodness, state, why don't you just give the judge a little note, remind him about this? It's an easy thing to do. It takes a couple minutes. But without doing this, if this goes forward, it's like a flag being thrown as the play is hiked in football on the other team, and you get a free pass. Doesn't matter what happens. You know that if there's a bad result, it's coming back. You get to redo it. Mr. Tucker gets a get out of jail free card if this happens. So Anyway, do not call the court. Do not call anything. We are observers. Please know we don't get involved in this. Let this happen the way it does. We're observers on the outside. The problem with people calling the court and getting involved, it closes doors for future trials, and we believe the openness is important. All right, so we have 45 minutes before we come back. This is a short lunch break, guys. This is going to be spicy. Do we work through lunch? Do you want to talk this over? This is a Hail Mary pass. Yeah, it's a Hail Mary pass that could win really big, but it's one guy who's throwing the ball, and he also has to catch the ball in the end zone. He has to run very fast, and it's got to be a 100-yard pass. I mean, this is a shot in the dark. I do not think it will work. I don't think it's a good idea for Mr. Tucker to testify in his own defense here. He has no lawyers on his side to talk to him. They're not even available right now. His counsel, which is not standing by in the courtroom, it might be a phone call away, but maybe they can talk him out of it. Man. Yeah, now's a good time to walk the dog, Rudy. We've got 45 minutes before we come back. It's a long break for the jury. The jury's just now probably getting ready to drive to court because they're going to be back at 1. This is a very, very messy trial. We're just here to observe. Why is his standby not there? He doesn't get standby like perpetually on hand.
Call from
Kayla.
Kayla, this is Scott. How are you doing?
Good. How are you?
I'm a little wired right now, but what's on your mind?
I have questions.
You, me, and Emily D. Baker,
Okay.
we have questions. What's your question?
Okay. So he's basically throwing a Hail Mary. Like, I'm just gonna do this because they're doing a rebuttal. And I'm not expecting a rebuttal. So this is what I'm going to do because I didn't throw in my motion to disqualify. I don't understand what's going on.
Okay, so the motion to disqualify is separate. Okay, so first he filed a motion for a continuance, which means, Judge, we need to pause what we're doing, give us 10 days because we need to file a motion right now to disqualify you. And that's a very tough motion to write, so give us 10 days. Judge says, sorry, we're not going to stop. We've got a jury sitting here waiting in the hall. We're not going to drop this. And just because you can't get your motions in order, we're not going to stop. So that was dismissed. If he had filed the motion to disqualify, that would stop the process, at least for a time, probably for an hour or so at a minimum, because the judge, by law, has to file a written motion in response, and he has to address everything. It probably also would get dismissed or overruled, rejected, but that would work that way. So now what he's doing is he's looking at the rebuttal, the proffer the state is giving about the rebuttal, and in the rebuttal there's interview information about what Paula said in this interrogation, when Paula said something that Tucker said and that he heard from somebody else, and he's trying to say, hey, that's hearsay, you know, and shouldn't I be able to, if you're introducing this contradictory prior statement, shouldn't I be able to rebut that? And he's understanding the law a little bit, but it's different. Paula is the one that should be able to rebut that, and she is alive. She is not dead.
Right.
She is alive. She should be able to have an opportunity to explain that prior inconsistent testimony. I believe that's the law. So there has to be some way for that to happen. But he hasn't argued that. Instead, he looked at his part of Paula's statement and saying, I should be able to, and he's using that as a rationale for, I guess I have to testify in my own defense. The judge is like, oh crap, I forgot that part. Wait, hold everything. You want to testify? I didn't do the colloquy because I thought you didn't want to. Paula's back in the hospital, says Lauren. Lauren would know. Lauren is Tucker's husband. The judge has not done the colloquy. The judge has not advised him about his rights, whether to or to not, and it's crucial because I believe it is very detrimental to his case. Very few people have testified in their own defense, and it served them well. The one I can think of is Dean Cummings in Arizona. He was phenomenal. I told him not to do it, at least virtually from here. I yelled, don't do it, don't do it. This will sink your case. And it saved him. It got him out of jail, and the jury sided with him. It can happen, but I just don't think that this is the one where it can happen that way. Oh, man. Blood pressure.
Okay, now I'm under... It was a lot. It was a lot going on today, so I just want to make sure I was following. That's all I needed. Thank you for giving me the spark notes.
I said Lauren is Tucker's husband. I apologize. Thank you for correcting me. I'm tripping over my words. We know Lauren is Tucker's wife,
You're good.
not husband.
Wife. Yeah.
I've introduced myself as somebody's sister before. It happens, you guys. And nowadays, I guess it's all okay, right? But thank you for your patience, Samantha. Thanks for the correction. Any other questions? Anything else that's on your mind right now?
No, I appreciate the Spark Notes version of that.
Yeah, it's
perfect.
It's crazy. I think the big thing is if this colloquy doesn't happen, this whole trial, this is a mistrial. This is a big problem. If a defendant gets up and testifies in their own defense, having not been informed properly by the court on the record of what their rights are and what will happen if they do. And I'm not liking it. I like it to be clean. I like it to be clean and follow procedure.
Yeah, so if he doesn't give him I can't say the word, the whatever colloquy, the word is.
Yeah. I can't spell it, but I can say it.
See, okay. So then he can appeal it?
It's huge grounds for appeal. This is a procedural step.
Okay.
It's like a checkbox. That needs to be filled out and signed off and dated and stamped and notarized by a notary public. It's so important in a case like this. And he can't just be like, oh, what? He said he wanted to. Go ahead. Come on up.
Okay, then.
Anyway.
Interesting.
He still might do it after lunch. Somebody might put a bug in the judge's ear, and that can happen. And I think it's appropriate. I think it should happen because I think Tucker needs to hear that. Needs to hear the judge say, if you proceed, this is what will happen. This is what will, the state will be allowed to do, and they're allowed to ask you questions out, to some degree outside of what you testify to, and you will have to answer those questions. So I don't know. It may be phenomenal. It may be the thing that pushes the jury over and say, you're right. The state has nothing. We've been hoodwinked by them. They've led us down this path, and really it's just a corrupt system that's trying to railroad somebody who's innocent. They might come to that conclusion.
Right.
That's why I'm not his
and
lawyer.
You know what?
That's
He's
why I'm
done
not
really
giving him advice.
Well, neither am I. But you know what? He's done very well so far. So.
Much better than any other pro se we've ever seen.
Yes. Yeah, I'm very impressed by him. So.
Anyway, thank you.
Okay.
Thank you so much.
Well, thank
Appreciate
you.
the question. We'll see you.
Yeah, thanks. Bye.
All right. The judge just assumed he didn't want to testify. There was some prior interaction where he had made it clear that he didn't want to, and so he skipped it. He should have, at least procedurally, he should have read through it and just made sure, just to, as a process, before he told the jury that defense case was closed and there was no other evidence they were going to be putting on. Now they have to open it up, and the jury's going to be like, wait, they were done, now they're not done. And there's just going to be that big question mark. Why was that? Hopefully that doesn't prejudice them against him. Maybe they're like, yeah, this has dragged on forever. And they're like, oh, defense is slowing us down again. Now they're back with more evidence. That could be prejudicial. I don't know.
Call from Heather Reed.
Heather, welcome.
Hey.
What's on your mind right now?
I have never heard like the defense's case being closed and now it's going to be reopened. Like, what is that? Like, how do you even do that? The judge closed it for him.
It's like this. Let me use an analogy. If we were playing Monopoly, Heather, and I had rolled the dice and I landed on Park Place and you owned Park Place, but you were busy counting your money and enjoying the fact that you were thoroughly whooping me at Monopoly. And then I'm like, all right, I've rolled, I'm done. Here are the dice, and you roll the dice, and you go, and then you move, and you look back, and you're like, hey, you landed on Park Place, that's mine. I'm like, too late. You've rolled by Monopoly rules and by the rules by the Geneva Convention that control Monopoly. You can't go back. You forgot to charge me. I get away with that. Okay. In this case, they have the next person hasn't rolled. Yes, the judge did say it was over. Okay. He can correct that. Nothing's happened. If we had moved on to the rebuttal and then we went back, that would be the next person rolling. Right. So I think it's still...
We're like halfway into like discussing the rebuttal, but
right.
I don't think... I don't... I don't know.
It's right on the board. I mean, the dice were being shaken. I mean, we're that close to the next roll. It's Park Place and Boardwalk, for those that know. Those are the two most valuable. I like Park Place because I never land on Boardwalk. Park Place is the only one I ever get. Heather, what else? What's on your mind?
I don't know what's happening. I'm afraid that he's gonna like testify and just screw this whole thing up because like I feel like it's in.
He's almost got it won.
The jury's going to hear, oh, look at all these inconsistent statements she made that she couldn't identify. We already know that.
Yeah,
she couldn't identify him.
It only sounds inconsistent if you listening to this are convinced that she knew it was Tucker as a second person. And then you've got an inconsistent statement. But if you listen to this, as she said, where she says it wasn't Tucker, it's not inconsistent.
It's consistent. So
it actually serves
testify, and
Tucker's
he should
defense.
let the state. He should let the state just bolster his statements instead of.
But we don't know how the state's
more ammo.
We don't know how the state's going to present this. First of all, they're going to lead the witness like they have before, so they're going to provide the context for these statements, and in context, they might make it sound bad. So that's...
To the detective that we've already established has stepped down because she was.
It won't be
convinced.
her. It won't be her on the stand.
What?
It's going to be a different police officer, one that was at the hospital talking to Paula, and then possibly some depositions.
They said Malone.
It was.
They
her?
said Malone. Isn't that girl?
Oh man. Oh.
They said Malone.
Same person. It is the same person. Oh
yes.
Man.
Yes, it's the same person that
the same person who's been
suggested
impeached.
to step down. He should not testify so that he could impeach her again and be like, "Oh,
my goodness, she's going to be back."
You're the one that stepped down, right?
She's going to be back, and then Tucker. Tucker's right. He doesn't get to do a rebuttal. He can't put on a new case after this, but he does get to question that witness. Or cross that witness. Now, I'm not sure what will be there because basically she's authenticating that this body cam video is, happened. Oh my goodness, this is bizarre. This is crazy.
I know. You heard my voice on the TV. My daughter heard my voice on the TV.
Mom,
she wants to say hi.
What's your daughter's name? Hi, how are you doing? Charlotte, if you run to the TV, you're going to hear your name. Scarlett or Charlotte? Scarlett, okay. Scarlett, your mom's awesome. Thanks for letting her call.
You'll hear it on the TV. I can rewind it forever now.
Scarlett, thanks. This is the best hobby in the world. I hope you grow up liking true crime. Thank you so much. I appreciate the call. We'll catch you later, all right?
Yeah.
All right,
yeah. Bye.
Mom, you're on TV. Scarlett. Scarlett, hope you have a great day. Let's see. Okay, a couple things. Just from my own selfish perspective, being a true crime fan and liking to watch court, and I like to see trials where things are different, right? Where we see something new. We have never seen this play out. Lauren, exclamation point burner. We'll get the phone number in chat. It's 801-513-1160, but that's it. Why wouldn't he just put this in the closing statement and therefore not subject himself to cross? That is a rush decision. Yes, he has this opportunity and closing statement. He also has more leeway. He can say things that aren't evidence, that can go outside of the boundaries of what he can in evidence. And that's coming up next. But he seems really caught up on some of these statements that are being made. I was saying I like to see things I don't normally see in trials. We have never seen a pro se defendant testify on their own defense before. This is Mr. Brooks was the closest one, and that got shut down by Judge Doro. So it's a very unique situation, even so much so that the lawyers themselves are not sure how is that going to go. Who's going to do the questioning? Who's going to say what? He's live on Court TV right now. Wow. I'd be prepping. He's got some big ones. I don't know. That takes some nerve. Oh wow. All right. There's the. I think the burner phone command should pop up on the screen here. There's the number right there. All right. Wow. Okay. So we have just a few minutes. Mr. Tucker is half an hour away from the judge telling the jury that he was wrong. The case from the defense is not over, and that Mr. Tucker has chosen to testify in his own defense, will be taking the stand and testifying in the narrative form. After which he's going to be cross-examined by the state, and then we go on. I don't know if Tucker can do this. I realize he has so much stuff he wants to share, so many things that the judge will not allow as evidence, which he feels should be allowed because they pertain to the case, but they're not evidence in the case. It's the wrongdoing, it's the improprieties, it's all the things. The police officer on the scene that says the $100 bill was his and he knew the serial number on it. All these things he wants to bring in. But the judge is going to be sustaining objections from the state, left, right, and center to make sure they stay out. All right. It's my understanding that Tucker's wife Lauren is not there. She told us that she didn't feel safe down in Key West at the time, so she's not there in court for that reason and just that reason. All right. I will say that him giving an interview right now, if that's what he did, this furthers the purpose that he has been, the whole purpose for why he has been why he's been pro se, because he knows that this will bring eyeballs. He thinks that the system locally is corrupt. He's fighting against a corrupt system, against corrupt people. That's his argument that he's made, even in his motion for. We saw it on his Facebook, regarding this motion for disqualifying the judge. And because of that, he's trying to get eyeballs from somebody outside that environment that can step in and say, hey, that is a problem. If we get enough people looking at this, then, you can't hide this in the dark. All right, we have a call coming in. Let's see who this is. It just dropped. Hold on one second. I'm sorry, whoever just called, the call just dropped. That might have been my fault. I might have dropped that one. I apologize. He needs the jury, not eyeballs. I think he has the jury right now. I really do. I think the jury is looking at this and saying, we're supposed to convict because this one guy, Travis, who said it wasn't him, I didn't do the crime, and then when they say, yeah, we've got you on video, you did the crime, he's like, oh no, but it was the other guy. We're supposed to believe that? That's why? Oh, it was Lauren that was trying to call me. I apologize, Lauren. If you call again, I will. My phone's acting up just a little bit. Let me make sure everything's working. It's free. I don't want to try to call you back because you might be trying to call me at the same time. Okay, here we go. Lauren's back. Just one second.
Call from
Lauren, good night.
Hey, Lauren, are you there?
Yes, I am.
Lauren, thanks. Sorry for my technical hang up here.
Oh, it happens to all of us, right?
It happens to me a lot. Appreciate you calling in to give us perspective. What did you want to mention here? We've just got a few minutes, 30 minutes or so before court comes back.
Yeah, I just thought I would call in because this is, like you were saying, this is crazy, the twists and turns, and it's, definitely been very difficult for me to watch. Yeah. Of course, I'm supporting Ty 100%. I talk to him all the time. Yeah. But he is doing his own thing in court.
It is. He sounds like somebody who's, he beats his own drum and he marches to that beat.
He does.
And he's doing it.
He does. And honestly, I think one of the major things where, I've been following a lot of the chatters on this case and, getting a pulse of what people are saying. And, I think so many people believe in our justice system that if you just go through it, it works. And the whole situation is it doesn't work that way if you're innocent and being railroaded.
There's a presumption
and I know nobody
of
wants to believe that happens.
when you get arrested.
Yes, and nobody wants to really put themselves in Ty's shoes. Or let's not even say Ty. Put yourself in the shoes of a person who does get arrested for something they were not remotely involved in that has life in prison as its consequence. How do you respond? And then you also have to realize that Ty and I have been fighting this for 6 years in front of this judge. Yeah. We know this guy. He's dirty. 100% he knows that Ty did not do this. He lies when he says that, oh, I've not heard anything like that. Nothing like that's come before me. Bullshit. Excuse me.
French.
My French. But, it's crazy to think. And this is, again, part of why Ty decided to go pro se. He does not believe he's going to get a fair trial. Based on the judge's rulings, the prosecutor's twists and lies throughout the 6 years fighting this case. The things they've done have been horrible. His rulings have been horrible. And, Ty feels desperate. Yeah. And like I think I said when I called you before, desperate times take desperate measures. And, it's hard. I'm sure it's hard for everybody to watch because Ty's not an attorney.
Yeah.
And,
but he's done better as a pro se defendant than any pro se defendant we've ever seen. We still see some shortfalls that we think an attorney might have done better at. And I still think in my heart that anyone in this situation, this should have a good attorney representing them. But I can see the reasons that he's presented for this, for wanting to do it. And it's worked. I mean, he has got eyes. He's got us. Yeah. He's got a lot of people looking at this case now saying, hey, something doesn't smell right. This doesn't look right, and it will put more scrutiny on this situation and the individuals involved, even beyond this trial after it's done, whichever way it goes.
And that is our greatest hope. I mean, the whole time is that we have been wanting accountability, and however this turns out for Tyrone, I hope for God's sake that these people are held accountable for what they did at some point.
It's crazy. Can I ask you what your opinion is on him testifying in his own defense?
Well, that was news to me this morning as well. So I'm still
you found out as we did.
Yeah.
I tell you, my concern I have is obviously Tyrone has a ton of information about this case that the judge will not allow in. Okay, it's stuff that's happened, but under the rules of evidence, either it's not admissible, it's hearsay for whatever reason, or the judge just might say it's not relevant. It won't be allowed in, and now he has an opportunity to testify in his own defense and tell his own story. Jury will be listening for an alibi. They'll be listening for his version of the events. There's a lot of opportunity for him to say something wrong that might change the jury's perspective here, whereas right now all they had going into this before him testifying is one person who was caught red-handed committing a crime says, but I wasn't the really bad guy. It was somebody else. And there's no evidence other than me saying that it was.
I understand. And I totally agree, that this is a risky thing for Ty. But at the same time, what's he going to say to incriminate himself? I mean, he does open himself up, but he wasn't there. I think one of the benefits is I think the jury's probably very confused as to what actually happened.
Yeah.
And I think that Ty, I don't know how much he can get in to paint a better picture of what happened. Just the fact, factually, like the things that happened based on the evidence. Maybe he can fill in some of those dots for the jury, because they must be terribly confused. If I look at it just from their perspective, then what the heck happened here?
I really would have liked to, if this trial was one where the jury was allowed to ask questions. We've seen that in some other trials where at the end of each testimony, out of each witness testimony, the jury fills out questions. And
that's smart.
I love it. I love it. It's incredibly insightful. We saw it in the Maya trial, also in Florida, but in different county. Unfortunately, we're left in the dark, and maybe the jury's still in the dark as well. But maybe that's enough for reasonable doubt, where they're like, if I've got this many questions,
exactly.
I can't convict.
Yep.
So we'll see.
I mean, we were very disappointed. I think Ty had an overreaction yesterday, feeling like the judge was not allowing his witnesses in and whatnot, and kind of forcing him to rest his case. And I mean, we were both really upset yesterday, and I slept on it. I woke up this morning, I was like, it might be best that he does rest sooner rather than later, because just like you're saying, if he gets on the stand, he's won the case, in my opinion. There's no evidence, there's a reasonable doubt, let it be. But at the same time, I think that one of the benefits of Ty is he is genuine when he talks. People might not like his personality or his, how he acts in court, but when people tell the truth, you can feel it. And I think that this is an opportunity again for Ty to tell the truth and be able to tell at least part of his story in front of the jury, so that, when this goes into deliberation, he feels like he's done everything he could in his own defense.
Yeah, I would hate for this to go into deliberation where he feels like he didn't have a chance to do this. I will say
exactly.
that if the judge doesn't do this colloquy, this has appeal written all over it. So maybe the judge will do the colloquy when they come back, because I think Tucker needs to be advised by the court in the moment when he makes a decision exactly what entails and what his rights are. And him just saying, "Oh, you want to testify? Sure, we'll do that next." I don't think that cuts it. So we'll see what happens.
All I got to say is that is one brave man. I mean, obviously, I have feelings for the man and everything like that, but I mean, right. I can't even come close to imagine what it's like to be in that courtroom for him every day.
Yeah, it's impressive what's happened. Obviously, you and I even have disagreements about different things in this case. You've got a lot of information that I don't have. I'm just trying to watch it as a jury has seen it. I'm not convinced. I think we're on the same page as a jury member. If I were voting, I would vote to acquit at this point, because I'm not beyond reasonable doubt. I do have lots of questions, but it wasn't presented as evidence. The state hasn't proven the case in my mind, and I think if the vote went down today, Tyrone would walk.
Yeah. Well, I don't think he can. I don't think his testimony is going to change that. I don't know, but I've never heard him make incriminating statements against himself. I don't know how the prosecution could get him to.
There was a time when he was talking to the judge. I think it was outside the presence of the jury, but he made a statement where he said, "This court has been fair and the prosecution's been fair," or something. He was stating it sort of like what they have been sort of asserting to him, but he made it as sort of like his opening statement, which is sort of confusing. I could see what he was doing after the fact, but he was saying, "This court, everything's been fair and above board and no problems. That's what you want me to believe," was sort of how he couched
right.
it. And that might be a little confusing. It's a little jarring when he comes out and, if he was, and I think he did something to that extent or sort of that style in some of the earlier questioning of witnesses at the beginning of the trial. That sort of,
I remember.
But I don't recall the exact wording. I'd have to go back and watch it.
I remember, and he commented on it because he, at least in one instance, he said, yes, I think it was with Moeller. Like, yes, I recall that, and it was something the night of the crime.
Yeah, it's sort of like,
and it seemed like he was implicated. He was there, but the fact is, he's watched the video, the body-worn camera video.
He's recalling all the discovery, their statements, the reports.
But you're right. That's a downside for both me and Ty when we talk about this, because we know too much. And sometimes, I mean, I don't know how he's not going to ramble, because I know I would.
There's going to be a lot of objections. I think he's going to get frustrated, because every angle that he tries to tell this story, he's going to find a roadblock to evidence, a rule of evidence. And the lawyers against him are seasoned lawyers. They know how to work the law. They know how to work the objections, and that he's going to be facing that at every front. And then also have the responsibility of arguing the objection, and then staying, on track for his narrative, for his story, and telling his side. It's an uphill battle. I really think it's not going to serve him to testify in his own defense, but that's his decision. I can't advise him. I'm not an attorney. I can't do that. But Lauren, I know you're sitting on pins and needles watching this, but I appreciate you calling in and giving us some clarification and updates. And
absolutely. And thank you for your coverage.
Thanks a lot, Lauren. Appreciate it.
Thank you.
Mm-hmm. Bye.
Bye.
Oh, wow. I don't know why that's working that way. That should work like that. Okay. Appreciate Lauren calling in and giving us an update. Thank you very much. I ask for respect for our guests on the show. I don't always agree with everyone who calls in, but one thing I try to do all the time is be respectful to them. And thanks for extending that respect to people who are calling in. I'm not in their shoes, and thankfully I'm not, and so I can't speak for them. I try to give people space to say what's on their mind and how they believe and how they feel. And speaking of which, here's Ivan.
Call from
Mr. Respectful.
Mr. Respectful is on the phone, fully apologetic. Your ban is over just now. I actually watched the timer expire. Your 24-hour call-in ban, which next time it happens will be 2 days, just so you know. So
okay, well, I've done many 24 hours in the hole. I know when the time is up. I could sense it was coming, and I figured I'd give a buzz. What is Tucker doing?
I've got to warn you, we're on a time limit as well. We're going to keep this one short. So
cut it when you got to. But this can only go bad, right? This can only go negative.
It's likely to go bad, but there's a chance it can go good. We've seen it go good before. People who are accused of murder testifying in their own defense and have it go well. Add to the complexity of that the pro se side of it, where you've got to deal with this in a narrative with opposition, objections all the way through it. It's an uphill battle. It's a tough road to hoe.
But many would say he's already winning. Usually when people have to take the stand, it's like a last-ditch effort. You know what I mean? It's like, okay, it's all or nothing now. You talked about the Hail Mary pass. He's throwing a Hail Mary when he's up by 20.
Well, here's the thing. He's seen the state has proffered what they're going to present on rebuttal. And in that, it has statements that Mr. Tucker sees are taken out of context that he has made. So they're saying they're taking his statement that he's made to someone else that they're making. It's like hearsay upon hearsay upon hearsay. I'm not sure how it's going to come in, but apparently it will. So he's saying, this is when I can win. This is one I can set straight because that's me. That's my statement. I'm not fighting to get somebody else in, and I know that I can testify. And I think he's looking at that and seeing I can get a win in this area, and it's very narrow. Unfortunately, the larger risk that comes to a defendant that testifies in their own defense, I think outweighs the benefit in Tucker's case for this. And so I don't think I think he shouldn't. I think he's a little narrowly focused on that little bit where his name came up.
Do you think he comes back and flip-flops again? Because that's sort of been his MO, right? Do you think he comes back after break and says, nah, I'm not going to do it?
No, I think he's going to go ahead with this. I think it does this. It extends the coverage. It extends the attention. It widens the viewership of what he's tried to do. He said this whole time, I'm not going to get a fair trial. That's his MO in this. I'm not getting a fair trial here. This is going to end badly for me because the system is rigged. And if he can up the level as far as interest or the curiosity factor, how many people would want to watch and hear what's happening, I think he'll do it. And one way of doing that is being a pro se defendant who testifies in your own defense in a murder trial. Every eye is going to be on this courtroom.
Well, I mean, and the judge still has to give the colloquy, right? He has not done that, right? That little statement he gave was sort of just like a half-hearted, okay, you can if you want. Well, we all know you can if you want. he still has to give the rules, right?
I'll say this: unless the judge did the I can't say it now.
It's a tough word.
Colloquy.
It's a tough one.
I think it's colloquy. Unless the judge has done that earlier and it has sort of checked that box off, I think it needs to be done. I think it is on its own a standalone appeal issue. Where he
doesn't that
say,
have to be done in front of the jury, or am I wrong on that? I thought that was always done in front of the jury.
Not in front of the jury. The outcome of that is presented to the jury, and then the jury gets to hear in the form of jury instructions that a witness testimony, if they don't testify in their own defense, can't be held against them. He's not required to put on any evidence. All that comes in the jury instruction. Now that jury instruction switches because you take that part out. He did testify in his own defense.
Okay, I got you. All right, I'll let you fly, man. Love you.
Thanks. We'll see, Ivan. You did good. You did good this time. Gold star. Thank you. All right. Yeah. We'll see you. All right. Bye. Oh man. Colloquy. Thank you. No mandates. When you say a word like 700 times and then you go to write it down and suddenly you don't remember the word anymore? That's this word for me. Another friend on the phone here. Jules, how are you doing?
Great. Listen, newsflash. Mark today's date on your calendar. I agree with Ivan.
I was going to say, did J Hatch pay up? But no, they haven't. The accounter is still going.
No.
Looks like 208,650,000 plus in some change.
Yeah, and so far. Yeah, and so far there's been no filings in regards to the sanctions on either the defense or the plaintiff side because I've been monitoring nothing.
Yeah. Well, Ivan's going to take that as a double win. I gave him a gold star. Now you agree with him. He's going to be absolutely unbearable in chat the rest of the day.
But he's really making a huge error in judgment. In my opinion, the man doesn't realize that I feel the jury would have found him not guilty. He's opening up a door he does not want to go down if he gets on that stand.
Yeah, I agree. I don't know how the state's going to handle this, and it may be with him on the stand that things get spicy again, confrontational. That the state fumbles this ball. That they, he's throwing a Hail Mary. The state's going for a pick six. It's going to be a big play one way or the other, and it's a big risk, big reward. I guess is what we have right here.
Yeah, well, I just wish his wife would tell him, please don't do this. But I guess we're going to find out in about 12 minutes.
In contact with him, so he knows what he wants to do. He does march to his own drum. It's
which could backfire on him.
It can. Parts of it has, but he won a few things today. I don't know what happened when the judge went and looked in his reflecting pool earlier today. But when he said, "I need to go reflect for a while," he came out a little bit different judge. He has been different since that moment. And I don't know if he phoned a friend and somebody said, "Hey, you're on thin ice. You've got some rulings here that on face value, I would overturn." I don't know what he did or who he talked to, but the judge is a little bit different today. So we'll see how it goes this afternoon.
Yeah. All right, guys.
All right. Thanks, Jules.
See what happens in about 12 more minutes. Have a great day.
We'll see you. Bye.
All right. Bye-bye.
Let's see. I just got an update here. Let's see who sent this. This is a good one. Seventh Circuit holds that defendant's waiver of the right to testify was valid despite district court's failure to engage on the record colloquy regarding the decision. So Seventh Circuit, is that Florida? I realize it's a circuit court decision, but is it the Seventh Circuit oversee Key West? So the district court failed to engage in the colloquy, but that's a failure of the waiver of the right to testify. So he didn't testify. There was no colloquy. Here he is testifying. There's no colloquy. I'm not sure if that's going to be if that ruling is still going to act as precedent on here.
Call from
Ramo.
Ramo? Who?
Yeah, it's Ramo.
Ramo, welcome.
Thanks so much, Recovery Addict. Yeah, I've been kind of watching here. And I had a question about if there's any possible positives for him testifying as himself, or when it seems kind of strange, like how it would work functionally. And
yes.
then couldn't he just do that other stuff in his closing argument?
Yes and yes. There could be positives because the state is trying to spin a narrative, and they're going to have to ask him questions, trying to get him to testify that say things that make him look bad. And they may be allowed to go into questions about, I don't know, past criminal record, or, you know, have you ever been convicted of a felony or something like that, that might go to his character a little bit. I don't know how much the judge will allow there because that's very prejudicial. He's the defendant. Not sure. So there could be some things, but if he is innocent and he wasn't there, every question they have, he's going to have an answer for, and an explanation that will probably make sense and be reasonable and not help the state out at all. So if the state asks the wrong question, the state might open the door to allow some of the stuff in that the judge has ruled can't be allowed in. I mean, there's a lot that can happen here. The door can be opened either way. And it's just at the last minute as well. So, you know, either side could really fumble the ball here.
Those poor jurors thinking they're going to be done tomorrow.
I think this testimony is probably going to take the rest of the day, because I don't think he wants to be done. I think he has a lot of story to tell, and it's going to take some time to tell it, and especially with the objections, it's going to be crazy.
All right.
But Ramo,
thanks so much.
That second part, I'll answer that question.
Question.
Yes, closing is basically his free shot at saying everything he wants to say without a cross-examination. He still can have some objections offered, but closings are usually, you know, your fair game to tell your story. So good points.
So just to put a pin on that, then, is there something he can't say in closing unless he adds it as testimony himself?
He couldn't get up there and testify, you know, in closing and announce that there's actually a fourth person who was guilty of the murder, and, you know, there's some things you just, within reason, you can't go there. He can't bring up, you know, this judge has been against me since I first had a traffic ticket in Key West as a 16-year-old. You know, he won't be able to go in areas like that. And I'm making those up as examples. They probably aren't true, but there's some areas where the judge will say that's inadmissible, that's not relevant to the case. But if he wants to put together the narrative and spin it the way he sees it, even if the state doesn't agree, he can do that. That's perfectly fair game.
Okay, thank you so much. Bye.
Yeah, thanks a lot, Remo. Appreciate it. Good points on both counts. Let's see. Hey, how's it going? Yeah, yes, please. Ooh, apparently, I'm getting some lunch. All right, we are just minutes away from Mr. Tucker, I guess, possibly testifying in court in front of the jury. This is crazy. This has turned into a proper courtroom drama. It has been wild from the get-go. Stop spreading misinformation. Sorry, we have Amber on the phone, one of our mods. Did I do something wrong, Amber?
No, you didn't. I'm gonna chastise the chat again real quick. I need everybody who's arguing in chat to drop it, or you're getting timed out for 24 hours. What's happening in chat right now is absolutely uncalled for. We do not attack people in this chat.
You've heard it. Let me tell you this. The mods are watching this closer than I am. They work their tail ends off to keep chat clean and fair and nice and friendly. If you have an argument, now's a good time to let it go. They don't joke around. They'll time people out for the day, and you'll just be done with the conversation. You can watch, but just won't be able to add. So let's let it go. If you think, hey, I didn't say anything bad, you saying I didn't say anything bad, that will get you timed out for 24 hours. If the mods time you, or give you a 10-minute timeout, and you come back and say, what did I say that was wrong? That'll get you a timeout for 24 hours. It's too much work for the mods to address all those issues, and we'll just take it away for 24 hours. It's not banning you from the channel. It's just saying, hey, we need to reset. So Amber, I support that one wholeheartedly. If you continue an argument, even if you're in the right, timeouts happen. Okay, so Amber, we're with you on that one.
It's all parties involved. It's all parties involved. There's no discrimination. If you're involved, you get timed out.
There you go. All right, the law has been laid down.
Thank you.
Thanks. Have a good day, Amber.
Have a good day.
Bye. Oh, okay. There's no problem. No problem. Don't worry about it. We can just move on as if none of the arguments happened, and everything will be great. No one can get timed out. So, all right. We got the laughter as well. So we are 5 minutes away from court restarting. The jury should be there at 1, so hopefully they're in the hall ready to move in. The last check here before we go back. Jay Hatch currently owes $208,650,648.49, $50. So $208,650,650. That was their total. They could have written a check right then and had a cool number that repeats on it, but no, they haven't. Anyway, we'll keep watching on that as well. Oh, we've got one more call. Let's see if we have time before the judge comes back. Let's see.
Call from
Connie.
Hey, this is RA. Who's on the phone?
Hey, RA, this is Sonny. How are you?
Sonny, I'm doing well. What's on your mind today?
Well, I just wanted to mention that I was a court and crime reporter for about 10 years, and he's making a big mistake right now.
A lot of people feel this.
And I'll tell you a couple of reasons why.
Mm-hmm.
He wants to talk about the reference to the knife. All that does is draw the jury's attention to that fact when it'll really just about be just overlooked.
Mm-hmm.
And the point is, the rebuttal testimony is consistently inconsistent and only shows, just further bolsters the testimony that he demonstrated, as well as how it also points out the coercion or the pressure that the sheriff's department or the detectives were putting Paula as well as maybe some other witnesses under. At the other point, which nobody really seems to be mentioning a lot, is that the backpack was found in the other fellow's possession.
Travis.
And I just don't think, I don't think as a juror or even somebody who had heard, who saw some of maybe the detrimental testimony against Ty, that there's no way that anything is compelling or convincing.
Yeah, I agree.
And I think he'll hurt it. I think he will hurt his case. He just opens himself up to credibility. There's a lot of credibility issues in this, and
I think some things
there's already been enough.
Some things that haven't been allowed in.
There's already been enough. Yes, go ahead.
I was going to say some things that haven't been allowed in about him may come in that made him look
exactly
not as good.
Exactly.
And we've avoided that to this point.
401 or 401 A and B evidence will come in. So I think it's a huge mistake, because there's no way that, and I covered criminal courts for years, some really big trials, and there's just no way that but he is playing a 3 or 4D chess game right now, because if the judge reopens his case, he then has an opportunity to want to recall those witnesses. And, so he's got the one disqualification sitting there. Then he will have an opportunity to attempt to recall those witnesses, even if the judge does give the colloquy. He doesn't necessarily have to testify. So he's really essentially delayed his case today.
So, Sonny, you're saying that with the judge reopening the case, turning back to the defense, saying defense has more evidence, he can say, and we call this witness who's now arrived.
I think he can. I think he can, because now his case is no longer closed. It doesn't say what order. A defendant giving testimony is not always sometimes it's the beginning of a case. It doesn't necessarily have to be the conclusion of the case. So now they've reopened the defense's case.
Sonny, we have people in chat asking you to become a court reporter for us and go watch trials. I don't know. What part of the country are you from, if you mind sharing?
Originally grew up very close to where you are right now.
All right.
And I still have family there, but I'm in the mountains. I'm in the Appalachian part.
Oh, wonderful. Wonderful. We might have some cases out in that part where we assign you to be our court reporter. So we'll see.
Let's hope not. We have a wonderful place to live.
It's beautiful. We spent
Okay,
some
well,
time
thank
there.
you. I appreciate
Thank
it.
you.
It's good coverage.
We'll see you.
Okay, bye-bye.
Sonny, thank you so much. Appreciate those thoughts. That was something I hadn't thought of.
Hey, you're great.
Oh, I've still got you, by the way. Sorry.
I said you're great. Thank you.
Thank you. All right, Sonny was wonderful. I had not thought of that if the judge reopens the case in chief for the defense, he technically could call a witness that's been subpoenaed if one's there. I don't think that's going to happen. That is a 4D chess move that's next level. And I agree that Tucker is playing a higher level of chess outside the courtroom than inside. So we'll see. All right. Diet Coke Mama should have been here 4 hours, 9 minutes, and 23 seconds ago. You're late. You're late. Thank you very much, Diet Coke Mama. Good to have you here. We need to figure out a way to send Jen out your way periodically. All right. That was a hot mic moment there where the call continued. Can he call more witnesses after he testifies? I believe he could if they're there because he has not rested. The judge is undoing the defense rest side. Can we get a recap? Yes, and John with the super chat. Thank you for the recap. This morning, it's been like this. Tucker said he was going to file a motion to disqualify the judge. That didn't happen. Instead, he filed a motion for a continuance, saying we need a motion for continuance for 10 days, delay everything for 10 days because we have to write the motion to disqualify the judge. We'd like you to consider it as if we followed a motion to disqualify the judge and drop everything until this is resolved. The judge ruled on that and said, no, we're going to proceed. Well, Tucker said, well, the problem is I've told my witnesses who are going to be here today not to come because we're filing this motion for a continuance. And we expected that to happen. And the judge says, okay, if you don't have any witnesses, then we're going to move on straight to the rebuttal case. The state says, all right, great. We're going to do a rebuttal. Here's what we're going to bring in. We have evidence to rebut Paula's testimony from body cam footage from the hospital from the night of the attack, as well as some footage some excerpts from some of her depositions. And we want to bring that in. They argued that in front of the judge. They went over each one. Mr. Tucker argued for the rule of completeness on the video, which I think he won, but I think we're going to see it actually not played the way he wants. The state is going to stop the video before the end of the actual complete video because there's some stuff after they definitely don't want in. Mr. Tucker's argued for that to be in. I think the judge said yes, but I'm not sure exactly if that was finalized. Then the actual parts, the excerpts from the depositions that are brought in, Mr. Tucker argued against them, several of them. He won one of them. The state says they have all these prior inconsistent statements from Paula. Honestly, to me, they sound consistent. They sound like, from the mindset I have where I believed Paula's testimony yesterday, they sound consistent to that. If you look at them in the light that Paula, apparently from the state's perspective, knew it was Tucker who was the second person, then they're inconsistent, but only if you have that foundation. Really, I don't think it's going to harm Mr. Tucker in anything. If anything, it might help his case. But that's going to be brought on through testimony of the same police detective who was given a glowing letter of recommendation, recommending that she not be a detective anymore, and that she be demoted. And she ended up being a dispatcher instead. So she's going to be back on the stand authenticating that evidence, and we're going to hear that. But wait. Before that, the last item that the state wanted to introduce as rebuttal testimony included some sayings by Mr. Tucker, or at least some things that Paula said Mr. Tucker said. And Tucker took objection to that and said, shouldn't I be able to clarify that? And through that process, he then reopened the opportunity for him to testify in his own defense, which the judge is now allowing. The jury's going to come in, and we think that Mr. Tucker is going to testify in his own defense starting right now.
Tucker. Jurors are in the jury room, so you prepared to proceed with your testimony?
Yes, sir.
Okay. Let's bring in the jury then.
No colloquy. It's been a crazy day. I mean, there are some days that have had very little things happen. Today has been busy from the get-go. And we didn't even take a lunch. So While the jury's coming in, I think I'm going to try to show you the thumbnail to see where we're at right now. The latest and greatest. Give me just one moment to get that prepared.
All right, folks, you can have a seat.
We'll wait for the
remaining juror.
While we're waiting,
comfortable.
Here's our thumbnail. I have added the judge, an angry judge with a gavel in the back of the truck that Tyrone was driving to SVC Pharmacy. The butler's there. I think that's it. I think that's the latest additions, but we've tried to stay up to date on that.
Thank you. Please be seated, everyone. The jury, welcome back. Good to see you back again. I'm sure you recall that I informed you before we took a very early break this morning that the defense's presentation had been completed. I was a bit premature with that. There's one other aspect of evidence that is going to be presented. So, Mr. Tucker.
I guess I'm calling myself to the stand.
All right, so Mr. Tucker is going to be a witness in the case. So if you'd approach the deputy, turn, face the clerk, just raise your right hand, face the clerk. You like everybody.
Got nothing on me.
You've already cleared security like everybody else here, so you're good. We want to put you under oath like every other witness.
Do you solemnly swear or affirm that the testimony you will give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, please have a seat on the witness stand.
Here goes.
Actually, if you would, thank you. I'm probably going to need somewhere in here.
All right, so first of all, would you state your name?
Franklin Tyrone Tucker.
All right, so as you all know, Mr. Tucker's acting as his own attorney. So in this particular direct examination, he is being allowed to testify in narrative form rather than asking himself questions and then giving an answer. He's just going to testify as a narrative. So you can proceed.
Okay. Yeah, it's a little weird. Not exactly expected, guys. I'm sorry about that. But I guess we're going to start. I think the best place probably to start is probably around Hurricane Irma. That would probably be the best way to go. I had been in Key West for, I don't know, a while. Been probably a couple of years. Been working on boats. Originally, before this storm happened, I got myself a boat. Actually, I had 3 at one point. But, doing the idea was to, sail the Caribbean, eventually island hop my way down to Venezuela and then go to, South America, go up the mouth of the Amazon. Didn't happen. Obviously Irma did a lot of damage. I mean, I'm sure some of you were here and remember. But the thing is I didn't evacuate when that happened. And eventually, just prior to this incident happening, I was working doing hurricane cleanup. There wasn't very many of us here. A lot of people had evacuated, so there wasn't too many people here to do that kind of work. Not that it was my normal thing, but yeah, I mean, I was getting paid pretty good money, to be honest. It was, they had some of the more wealthy neighborhoods that were up in the Big Pine area. They had people who wanted their roofs blue tarped. I don't know if you guys know what that is, but they wanted their roofs blue tarped, and they were paying me $300 an hour to get up there. And at the time, I mean, it was like $300 an hour. I'm up there, no problem, So, I did some of that, and I also did hurricane, debris, getting rid of debris and chopping up, cutting up logs or whatever, trees that had fallen. I do remember finding an airplane cockpit in somebody's backyard in Big Pine, and there's no airport near there, So, anyway, but that's what I was doing for money at the time. And I was getting paid cash. So, like I said, $300 an hour. And, sometimes I'd do, 4 or 5 roofs in a day sometimes. So, that's pretty good money for that time, right? And, yes, I did stay at cots at, certain points, just because, like many people at that time, didn't have it. A lot of us if you want to say homeless, I guess that is the word. But the thing is a lot of people were homeless at that point. A lot of people lost their boats. A lot of people lost their houses, lost their homes. I wasn't exactly special that way. But I was working the whole time, and, you know, I was making good money. And my whole plan was to buy another boat, you know, and, you know, again, resume my plan to sail off into the Caribbean. And this, you know, this is a personal note, I guess, because of the time. Most people don't know I have a 14-year-old. I had a 14-year-old son at the time that I raised myself. I was a single dad, you know, and I raised him up till he was.
Judge to the relevance.
Well, because he was supposed to come live with me. That's the only.
I'm sorry, Mr. You wanted to complete your thought there? If it's connected, go ahead.
No, it's just part of the story because he was actually supposed to, you know, he was supposed to be coming to live with me in about 2 months before, you know, when this happened.
Okay.
Right after this happened, I had about 2 months, and he was supposed to come live with me. So, you know, it is kind of part of the story. You know, you can see my mentality at the time. But the thing is okay. So anyway, that didn't happen, obviously. So as far as the warehouse, right? The warehouse, I remember it from the storm because, yes, I did stay there during the storm. And, you know, it was a big steel building. It was on cinder blocks. So, I mean, you know, okay. You know, it seemed like a good place to ride out the storm. And the only thing I was worried about was the roof getting blown off. You know, so, you know, I stayed there for, I don't know, maybe a week. I don't know, something like that. I can't remember exactly. But, you know, and I know it's come out before that April Walker, Rory Wilson's girlfriend, did not like me. And I didn't stay there because of that. You know, it's like, and not only that, they were having, you know, between Rory and April, they had domestics that, I mean, I remember the cops coming out 3 times in one night when I was there. And I'm like, okay, this is not someplace I want to be, right? So I didn't stay there. I went, you know, I was staying at Cots again, right? And when I was staying at Cots, you know, I mean, it was okay. I mean, I don't necessarily like staying there, but I mean, you know, I was saving up money. That's basically it, saving up money, getting a new boat. Anyway, so, you know, somewhere along the lines, and I don't remember exactly when this was, but, you know, I know Mr. Johnson testified that, you know, we met after he got out of jail. No, I was actually at work when he went to jail, and I remember very well when he went to jail because we knew each other prior to that. How, you know, he actually knows how I ended up at the warehouse. The way I ended up there is I had a friend, CJ and Michelle, who lived, you know, they were living in the same, I guess they, you know, you guys know conch houses, I guess is what they call them down here. But it wasn't really a conch house because it's a warehouse, and they had built apartments in there that I guess weren't really legal, but they were renting out rooms but sharing a bathroom and a kitchen and a dining room, right? And there's multiple roommates that are up there. So there's people, I don't even remember how many people live there. There's a bunch of people who live there. But anyway, Roy Wilson and his girlfriend had the apartment downstairs. They actually had an apartment to themselves. And then there were people upstairs who lived in the apartments upstairs, or the rooms upstairs, I should say. One of them was brought up before a guy named David Gross, right? They like to call him the White Detroit in this whole story. But yes, he lived upstairs, and my friend CJ and Michelle had one of these rooms up there. And Michelle, she was the manager at Burger King. She was actually a manager at Burger King. I forget what CJ did, but the thing is okay, CJ somewhere along the lines gets into an altercation with David Gross and punches him in the nose, right? And you know, again, you know, David goes ahead and gets a restraining order against CJ. Now, I just happened to show up the day that, man, the police are escorting CJ and Michelle out of there because of this restraining order, right? And you know, as they're going out, they're going to a hotel. That's where they're going to go, and they can't take all their belongings with them, right? Can't take everything with them. So they asked me. They were like, "Okay, well, would you stay here and watch our stuff? Make sure nobody messes with it. Make sure nobody steals it. You know, that kind of stuff. Stay here, you know, while you know, until we can come back and get our stuff, right?" And I was like, at first I was like, okay, you know, well, I've got to be at work in a few days, you know, but yeah, I can watch it for you, you know, and so I do, and I go and I stay in CJ and Michelle's room, and I did come into contact with a few of these people. I mean, it's like, again, Travis was one of them. I didn't know him very well. As far as I knew, he came down from Michigan with a guy named Scott Gideon. That's the one I asked about. Or no, sorry, Matthew Gideon is his name. They called him Matty. But anyway, he had come down from Michigan with this guy. And, I mean, they were okay. I mean, I didn't really think anything of them. But, but they were okay. And, I don't remember exactly how long I was there before this incident happened. But this is how I end up, in this thing. Because, okay, like I said, I don't remember exactly the time frame here. But I do remember some of the people that were around at the time. I do remember Travis was there. I know Matthew had already left, and I think Matthew went to the beach, if I'm correct. But again, Mr. Johnson ended up with his medications. So, that's a whole different story. But the thing is I'm trying to remember now. It's like, you got to remember, this is around Fantasy Fest time, when this happens, right? Because, okay, it happens on November 17th, right? And Fantasy Fest, that year was on Halloween, the 31st, right? Now I know just my own phone records that I looked at recently when I was looking at it for this case, right? I had 2 phone calls with John Travis Johnson, right? And they're from the 28th of October, right? So I must have met him somewhere in that time period, right? And I know that year for Fantasy Fest, I don't remember what the theme was. I really don't remember what the theme was, but I know that the parade was on Halloween night, and I know it was at the Green Parrot that night, right? And I hung out there quite a bit. My friend, longtime friend, runs the place. I don't know if any of y'all know Jim Fossum, but yeah, he runs the place. And so I still have quite a few friends. I've been coming here since I was 13, and been, I guess they call it a Key West rubber band is what they call me. It's like, I'll move away, I come back, I move away, I come back. My daughter was even born here, right? So anyway, to keep on going here, Fantasy Fest happens, and I'm hanging out with a friend of mine named Ben, and we're hanging out on what we call the party bench. It's right outside the little deli that's right there down on the corner. And he has a dog, can't take him in the bar, so, we're hanging out on the bench. And some girls come by, and they wanted to paint up our faces, and of course we let them, right? I mean, it's like, okay, why not, right? So they go ahead and paint up our faces and all that. And, then they're like, okay, well, can you pose for us, look scary, that kind of thing. Okay, so we do, both of us, right? So there's a picture of both of us like this. But anyway, so fast forward. We go down to the point where all this has happened. And again, Fantasy Fest, I mean, I have a tendency to drink more when I come to Key West than any place else I ever live. It's like, especially when I was on the boatyard and working on boats and stuff like that, because I did do quite a bit of that. I actually did a restoration project on a big Hatteras yacht at one point. But, so yeah, I have a tendency to drink more when I'm down here. And this one day, and this is about the best I could recollect, is, I remember that day I was drinking Fireball with Travis, right? So I know I had been drinking that day. And I know I went into the bedroom, which is, again, CJ and Michelle's room. And I know, so this is during the time period where I'm watching it for them. So I remember that. And I don't remember much else about the day, except I do remember at one point, it's got to be later on in the evening, and I wake up and I'm out of cigarettes, right? And I wake up and I get, and Travis is actually there, right? So I go and I walk to Tom Thumb, to get cigarettes, and I go over there to get cigarettes, and I come back, and when we were up at Tom Thumb, right? I remember looking, and I'm like, I could look up, okay, there's the fire stations right there, and then you can see Laurel Avenue, where this happened, right? You can see Laurel Avenue from there. And I could see the cop lights up there, right? I could see a bunch of cop lights up there. And I remember saying to Travis, I was like, man, I wonder what happened up there, right? And it's like, and the thing is again, I'm not in dark clothing. I am in shorts. I am wearing sandals. I am wearing, normal people clothes, right? I guess I guess I should say normal for Key West, right? But anyway, yes, and Mr. Mansfield alluded to this. I did have a nice big long goatee, and I had, Lord knows I have tattoos when I take off my suit. But the bottom line is I planned on living on boats, and yes, I was living that lifestyle. It's like, I planned on sailing off into the sunset, and just enjoying my life and kind of traveling, so I kind of looked like a little savage. I'm not going to say I didn't, it's like, us boat people, we kind of had have a style, I guess. I don't know what it is. And, it's kind of a freer way of living, I guess. Anyway, but beside the point. So getting back to that night, I remember looking up on Laurel Avenue and seeing the lights, right? By the time we got back, right, so it's not a very far walk from Tom Thumb to the warehouse. But by the time we got back there were cop cars everywhere. I mean, I'd never seen anything like that on Stock Island, right? I mean, literally, you had the FWC, Border Patrol, there's police everywhere, and they're going everywhere, right? And, there's police sirens everywhere. And I remember, we went back inside, and I think Travis did buy like a 12-pack of beer or something like that, right? And we go back inside, and I remember you could see, again, there was a bunch of these cop cars that went down into what they call it Little Haiti there, right? It's a bunch of trailers, and yes, it's before you get to the Hogfish, right? That road there. And I remember there's a bunch of cop cars that, man, you're going down into that neighborhood, right? And I'm like, damn, I wonder what those guys did. I'm like, whatever it is, they want them bad, so. And I think I said that to Travis. I'm not sure. Oh, and by the way, when we got back, that was the other thing. Big Scott was waiting for us when we got back. I remember that too. Because, okay, I know Travis, he testified that, he had the key to the door. Him and Maury Wilson were the only ones with the keys to the door, right? So, Big Scott was waiting outside for us, right? And because he couldn't get inside, right? He couldn't get in the door, right? So anyway, so we go upstairs, and, and when I saw all that stuff out the window, you got to remember I'm still a little bit lit. I managed to walk my butt down to the Tom Thumb, but I wasn't going much farther than that. So anyway, so I go from there. Let's see, I go from there, and I remember Big Scott and Travis were going to go, and they were going to go hang out on the front porch downstairs and watch the cop cars go by. Just see what was up. They're going to drink beer on the porch and watch the cop cars. I'm like, okay, I'm going back to bed, because I was like, I'm not, I'm still not good, right? So I went back in, and I passed out and in the bed, right? And was it CJ and Michelle's room, right? So I passed out in there, and from what I understand, again, I can't, I can't really, say, except for I've seen it on video now. I mean, I've seen it on video as far as some of this stuff, but while I was upstairs and I'm passed out in there. This is where, okay, to clarify, when I went to go get cigarettes at Tom Thumb, right, it has to be sometime after the Florida Keys Electric video that you see there, right? It has to be sometime after that. I don't know when, but, unfortunately, that's all we have for video. So I don't know. I just know that, it had to be sometime after that. Because, like I said, Travis is already there. So it's like, okay, I know it has to be there, right? So anyway, so I don't know exactly, what time. I couldn't tell you exactly what time. I do know that, yes, it would have been helpful if we had the video from Tom Thumb.
Judge, can we come sidebar?
Oh, okay, yeah. So.
I'm eating. He interrupted. I wish I had popcorn, but I'm enjoying this narrative. The objection here, he's objecting to not having video, and I think it's a good objection. You can't fault the state for not having certain evidence. I guess in this case you can, because I think there was an error made getting this video, right? I cannot recap this. Cachette, this is a one-time thing. If you don't get this time, you need to rewind and listen to it again. It's a little bit meandering. I realize he's hitting key points that are important to him. I'm not sure if the jury is understanding why those points are important. Say like saying if when I went to get cigarettes at Tom Thumb, it had to be after the video from the boat place because Travis was there already. I'm not sure if the jury understands why that's important, but we've got quite a bit of background. I understand now. Yeah, yes, Hurricane Irma was on the 10th of September, and this is back in November 17th. After that,
so we'll resume with the direct examination testimony.
So I'm back to where we are with the story. So again, I'm passed out in bed, and somewheres along the lines, again, the police show up at the house is because this was told to me by Travis and Big Scott. Okay.
We'll sustain the objection.
Okay. Well, I get woke up along the lines somewheres along the night, and I don't remember when, but I remember, man, I get woken up in the middle of the night, and because when they went downstairs to go and check this out, right? I remember telling them, I was like, I'm going to go to sleep, man. I'm like, tell me what happened later, just tell me what happened. Because, I mean, it is kind of a big deal, So, anyway, so I go pass out, and somewheres along the night, I wake up, man, and Rory Wilson is there, and Travis is there, and Big Scott's there. And, I mean, we're drinking, and, smoking some weed, as far as crack, I don't remember, man, the crack thing. Not too much of it anyway. I mean, I vaguely remember some of it. But the thing is because I say that because I seem to remember somebody having crack and somebody smoking it, but man, I don't remember. I do, again, at this point, I'm resuming drinking and I am smoking weed at this time, right? So I'm not, again, I'm refogging my brain at this point. So anyway, so after that, let's see, because like I said, again, I had a tendency around Fantasy Fest. It was usually a couple weeks worth of partying, man, during Fantasy Fest is usually what it was for me, But I don't remember much, man, as far as the next day. I don't really remember too much as far as that went. I do remember, this is one thing I do remember. Because again, it starts, it's been many years and I can't really tell you guys, man, exactly because it has been years and I'm trying to, my best to remember here. But I do remember there's a point that comes in there where we have two detectives that show up at the door, right? And they come to the front door, and I open the door for them. I literally open the door for them, and I know now who they are. I mean, I'm sure they introduced themselves at the time. I just don't remember them introducing themselves. But it was Detective Smith and Detective Fernandez, right? And now don't get me wrong. I knew they were detectives because they're not wearing uniforms and they've got their badge on their belt, right? So the thing is so I know they're detectives, right? And they start asking me questions about Rory Wilson, right? And I know Rory. I mean, I don't know, again, it's not like we hang out all the time. It's not like I know him, I know him that well, right? But I know him, right? And but they're asking me questions like, they're asking me, is he a drug dealer? They're asking me stuff like that, right? And I'm like, well, not that I know of. I know he has a job. I mean, I know he has a pregnant girlfriend. I know that. But they're asking me a bunch of different questions, right? And I actually even I even gave him Rory's phone number. I was like, if you want to contact him, here, I'll give you his number, right? And I remember Rory after that, man. It's like it's hard weird, but he texts me right after they leave, and because I also told him that Rory's door is around the other side of the building, right? It's actually on the back side of the building. He has like a front door that's all his own, right? And I told him about that, and it's like so anyway. Again, it's a little fuzzy here, but I do remember Rory texting me not long after they left, right? And he's like, cops.
To hearsay.
I'll sustain the objection.
Okay. Well, anyway, so I do remember, telling Rory I go to him because they left me a card, right? And I go knock on his door and I give him the card, right? And I said, look, man, these aren't uniformed officers. These are detectives, man. I'm like, and they were asking me some questions about you, and you might want to give them a call. I mean, So anyway, so that's what I tell them, and I give them the card, right? And after that, let's see, I'm trying to remember anything important after that, because okay, after that I don't remember too much. Oh, because it wasn't too long after that where they come in and they do this raid. But okay, prior to the raid, I remember this. It's Thanksgiving time, right? So it's around Thanksgiving, right? And I remember DeLuna's had like a Thanksgiving dinner, like a free Thanksgiving dinner or something like that, right? And I like DeLuna's, and so I went over there for that. And I think this would be the 21st. I would have to say it's the 21st, because actually, I know it's the 21st now. Okay, so it's the 21st, right? And I go, and I was a little sketched out by the detective showing up there, because look, the warehouse, like I said, Rory Wilson, and April had cops come there many times, right? And look, it's only a matter of time before you're going to get caught up in something, right? So I didn't want to stay there very long, and I actually told CJ and Michelle this, right? I'm like, I'm trying to be a friend here, but at the same time, I'm not trying to hang out here too long, right? And so anyway, so I remember, the raid at the warehouse. That's what I think. That's what Travis called it. I don't know what you actually call it, but that night, okay, I went to DeLuna's, went and did the whole dinner thing, and this is when I first heard about what had happened up at the Treehouse, right? I hear through a friend of mine, Janice. We were having dinner that night, at the DeLuna's thing, and she told me that.
Objection to hearsay.
Oh. Okay, I was informed.
The objection in terms of the details.
I was informed that somebody got stabbed in the parking lot up at CVS. That's what I was informed of, right? And so that was my first, hearing of this. Anyway, but that same night is when this thing happens, as far as the whole raid thing. And I'm telling you, it's the stupidest thing I ever did, man, in this whole thing. Because, okay, they come in, and I'm upstairs, and I'm literally in CJ and Michelle's room, and I had a laptop, kind of like I do now, but I had a laptop, and I was watching TV on the laptop, right? And I was just getting ready, watching, another show. And when they came in, the way that place was laid out, they had because it was an old warehouse, right? So they had, the one I was in, you could literally see to downstairs, right? It had like a plexiglass window that went across one of the walls. I imagine it was like an old supervisor, like an old supervisor office or something. But you could look down and you could actually see right downstairs, right? And I hear a bunch of commotion down there. And I look down, from the plexiglass, the window, and I could see the cops banging on the door, right? They're actually, because, okay, it's two separate, Rory's got his in the back. There's this big storage room. And then there's like the stairs that go up to the other, I don't want to say apartments, but the other rooms where people were renting, right? And so they're banging on the door, right? And they've got a battering ram. And there's boom, boom. And then I see they've got ski masks on. They've got assault rifles. There's smoke. I mean, literally, I look down there and I'm just like, oh my God, right? And so anyway, do the dumbest thing that you could possibly ever do. I go out of CJ and Michelle's room, and I come walking down the stairs with my hands up, looking like an idiot, because I'm sitting there going, I'll open the door, just don't shoot. Like they can see me. It's like, so as soon as I open the door, the next thing you know, I've got an assault rifle in my nose, right? And they're leading me out. And, literally I'm like whipped around, handcuffs on, and taken out to a squad car, right? And it's like, and I remember, and one thing I didn't like is I remember as I was going by, seeing Rory Wilson's girlfriend on her stomach. Now, look, April and I didn't like each other, that's true. But she was 8 months pregnant, and seeing her on her belly on the ground did not make me happy. But they take me out to the squad car, and I am literally, I have no idea what's going on. I'm literally sitting out, you guys have a warrant, am I being detained? Am I arrested? The whole thing. I have no idea why I'm being taken out to the squad car, or why even any of this is happening, right? But based on what the detectives told me that had showed up there a few days earlier, I guess, based on what they told me, I thought it was over drugs. I thought maybe, they were there for drugs or something, I didn't know. But I just know that, man, they came in, they're coming in like that. They've got a reason, if they're coming in like that. And, so I'm way confused at this point. I have no idea what's going on. And I'm sitting in the back of the squad car, and they left me out there for a while, and I'm still, I have no idea. And eventually somebody got in the driver's seat. I don't remember who it was, but somebody gets in the driver's seat, and, I'm literally I'm asking them a bunch of questions. I'm like, trying to figure out what the hell's going on. And so, eventually they tell me they want to take me down to the station. And I'm like, well, look, I don't have a shirt on. I don't have shoes on. I don't even know what this is over. I'm like, am I being arrested? Any of that stuff, right? And no, it ends up, it actually is Detective Pitcher. He goes and he gets me a shirt. It's like a camouflage shirt, but he gets it from David Gross's room, right? And he brings it down, so I at least have a shirt on, right? And so they take me down to the station, right? And when they take me down the station, I'm trying, because again, this is, it's pretty traumatic. I'm not going to say it's not. It's pretty traumatic when that kind of stuff happens. But anyway, not that I've been through it, I've been through it a bunch of times, but I mean, I just, like I said, I'm lucky I didn't get shot going down the stairs. Anyway, so the bottom line is they take me into the station. And when they take me in the station, let's see, I don't remember who it was that brought me in. I know they bring me in and they put me in an interrogation room, right? And when they first start talking to me, I'm like, again, I'm wondering why I'm here.
I'm objecting to his testifying to his statements made back then.
I just said I was wondering why. I'm telling you my thought,
I understand, but in terms of the statements that you made at that time, I would sustain the objection.
Are you talking about what I would tell the police?
Yes, sir.
Oh, okay. I'll leave that out then. I'm sorry, I didn't understand.
His own statement is hearsay?
I'll leave that part of the story out. Anyway, so I go into the interrogation room, and at first, they're questioning me, and I'm thinking at the time, okay, remember I said I thought it was over drugs, right? So, and they're asking me these questions, and first that's what I thought they were, again, they're asking me because they want to know information, right? So, but then it comes around to the murder, somewhere's in there, right? And they start asking me questions about it. And again, I'm thinking, okay, they asked me what I knew about it, that kind of stuff. I'm sorry, I don't want to testify to what they asked me. But but at the time, I remember thinking, they just wanted information from me, right? They just want to know what I know, what I've heard, that kind of thing. But somewhere along the lines in there, and it became very clear they thought I had something to do with this, right? And I remember. Oh, wait a second, because I'm forgetting about a part here. They take me out of the interrogation room at some point, and they take me down. They put me in a squad car, right? And I'm still in handcuffs, right? So I'm still in handcuffs. But they put me in the squad car, and they leave me down in the squad car for I don't know how long. It had to be like an hour. I have no idea, But I was in the squad car. And then they bring me back up, and they ask me a bunch more questions, right? And like I said, now it's I'm getting this feeling. I'm like, okay, wait a second, they're not asking me because they think because they just want information. They think I had something to do with this thing, right? And at the time I remember, that they went to that direction, and again, I'm very adamant. I get very adamant once I realize this. I'm like, oh no, but yeah, so I don't know if I can testify to what I said, but I remember, saying it to them. I was like,
objection to what he said.
Yeah.
I mean, okay, then I won't say what I said then, but I will say this: I was very adamant about not having anything to do with it. So eventually, it gets down to the point where I've been interrogated all night over this thing, and it got to a point. I mean, I was like, look, I'm like, are you going to arrest me? Are you actually going to arrest me? Or am I free to go? Can I get, look, I'm tired of being here. I'm tired of saying the same, giving these answers. Can I go home, or are you going to arrest me for this thing? And they let me go, right? And not only did they let me go, the bad part about that is they made me walk home. And I remember the directive was to, check out the cameras, how many cameras there were, right? And and they did give me, I'll give them this, they gave me slides, because remember I told you I didn't have any shoes. They gave me slides, right? The stuff they use in jail, the slides, right? Kind of like flip-flops. Anyway, so they give me those and send me on my way. So now I got to walk all the way home, which, Okay, it's a little distance, And so I walked there, and I probably got there, I don't know, I probably got there like 5 or 6 o'clock in the morning. It was early in the morning, and I've been there all night, right? And when I get there, the door is locked, and as we've said, I didn't have a key, right? So, but my stuff is still in there. Now I'm freaked out. I gotta tell you, I'm freaked out, because okay, when they, again, that I've never had that happen, right? So I'm freaked out about the thing. And when, I get there, the door's locked, and I remember I had to throw rocks up at the windows to finally get Travis to come down and open the door, right? So he comes down, he opens up the door, and I tell him what happened. I just tell him what happened to me. I was like, I can't believe it, I can't believe they took me down there, blah, 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 this, that, and that, right? So anyway, but I don't want to stay there. I don't want to stay there. I'm like, okay, this is way more than this is way more than I want, right? So I get my stuff together, and I literally grab all my stuff, and I tell CJ Michelle. I called up CJ Michelle, and I was like, look, look, it's all good, you guys, man, but I can't stay here. You know what I'm saying? I can't stay here anymore. And I remember them asking me if I would at least grab, like, they had family photos and pictures of kids and stuff like that. And they asked me if I would grab that and take it down to Burger King and drop it off there, right? And I was like, yes, I can at least do that for you, So I grabbed a bunch of the pictures, man, from their room, and I tried to grab, anything, that could be of value or sentimental value to them, right? Because now I'm leaving, and I'm not staying there. And so, yeah, I grab all that. I put it into a bag for them, and I grab my stuff, and I head on out, and I go ahead. And this is, I don't know, it's I don't remember what time of day it is. I know it's morning, like I said, I got there probably like 5, 6 o'clock, so I don't remember how long it took them to open the door or anything like that. But I did grab, some stuff, dropped it off at Burger King, and I do remember I called 2 people that day. I called my friend Cliff, and I called one of my brothers, Jeff. He's not blood related brother, but he is my brother in every sense. But yes, so I go ahead and I call them because I'm freaked out, right? Because I knew when they let me go, I knew that, okay, they let me go, but I got the distinct impression that, man, no, they thought I had something to do with this, and they were, this was not going to be the last time that, they talked to me about this. And, I was scared. I'm going to tell you, straight up, I was scared, I didn't know what was going on, and I was like, and I can't explain to anybody, the feeling. But I was scared, so that's why I called them up, because I was like, look, man, everything everything
into what he was telling these people?
Oh, I'm talking about my head.
All right.
But anyway, in my mind at that point, yeah, everything was telling me, man, it's like, you need to get out of here, right? These people, man, they think you had something to do with this, and but then the other side of me is going, if I take off, they're going to think I did it, So I have this little war going on in my head, and anyway, so I went from Burger King and I started walking down towards Key West, right? Because there's that little bridge and park and stuff there. And I remember as I came across the bridge, there was a couple guys there, and they're drinking off of they're drinking off of a liter of Skull or whatever. It's the rot gut vodka. And at that point, I was like, yeah, I need one. And I was like, you might, So I sat there with them, took a couple hits off that, and I eventually end up down at McDonald's, right? And when I get down to McDonald's, and then I'm still sketched out. I'm sketched out about the whole thing, and I don't know what to do. To be honest, I just don't know what to do. It's like, man, I've never found myself in this position before. I don't know what to do. So anyway, I get on, because I went to McDonald's because they have free Wi-Fi there, right? So I could get on my laptop, because I always had a laptop in my backpack, right? So I get on my laptop, and I'm not even sure what I'm doing, to be honest. I really wasn't sure on what I was doing at that point. I didn't know. So anyway, but that's when Paula shows up. And Paula and I, we weren't friends, right? But we knew each other. It's like, it's one of those things, small island, and we know who lives in the neighborhood. We know who lives on the island. It's like you run into each other. Hey, how you doing? How's it going? That kind of thing. But but I don't know that much about her, you know, I mean, you know, so anyway, so I run into Paula, and I remember, because I was feeling so bad and so sorry for myself for, man, being interrogated, you know, for overnight, you know, being interrogated for this thing all night, and I'm scared, and I'm feeling sorry for myself, I guess, right? And I remember seeing Paula, and she had a bandage on her neck from the night, right? And I remember seeing her, and I was just like, and all of a sudden I felt like such a, I'm not trying to curse, I guess, but I felt really bad, right? Because I was like, here I am feeling sorry for myself, and then I see her, right? And she's bruised up, and she has the thing on her neck, and it's like, and when, you know, and I told her what happened to me. I told her that they took me down to the station. I told her, you know, what happened, and the thing is Paula, you know, Paula, yes, she did cry, and yes, she did, you know, cry on my shoulder, and, you know, and I told you I felt horrible, because it was just like, it's like, again, here I am feeling bad because they grilled me all night, and then I saw and heard from her experience, right? And no, I just felt bad about it. It's like, okay, you know, here I am again. I guess it's the somebody always has something worse thing, you know. There's always
Objection to the self-serving statements, Judge.
All right. I'll overrule the objection. You can continue.
Anyway, so it was definitely, again, while I was still not certain about what was going to happen here, you know, but it definitely put me in a different mindset to see her, right? And but anyway, so after I saw her, I remember I went back to COTS, because now I'm going to COTS, and I'm, you know, not going back to the warehouse. I don't want nothing to do with it, right? So I go back to COTS, and, you know, they had again another little Thanksgiving dinner thing there, and, you know, I had some of that, you know, whatever. And then I went into where the bunk is, and this is when I get arrested, right? And when I got arrested, you know, because, you know, Detective Pitcher was the, you know, one of the ones who talked to me when they were doing their interviews. And I remember him leading the charge, but there was a good amount of officers, and they were coming in from both sides. And I remember looking up at him, and I was like, I guess we're not talking now, are we? And he's like, no. And so anyway, so they arrest me, and they take me over to the jail, right? And and the whole time I'm kind of flipping, and I'm like, literally, like, I'm like telling them I didn't have anything to do with this, and you know, and so I'm telling him this stuff, and somewhere along the lines I get told that it's about witness tampering, right? And I'm like, and I thought it was over Paula. I thought it was because I talked to her at McDonald's. And I was like, nobody told me I couldn't talk to her, right? But that's not what it ends up being about, and I won't testify as to what it was, because I think that would, Mr. Mansfield probably object to it. But at the same time, so you know, so I'm thinking, you know, again, and my head is spinning again. And okay, so now I'm in jail, and they take me, and they literally, okay, the jail has the elevator, goes up, they take me in. I remember getting booked, you know, kind of booked in, whatever the hell, you know, whatever that is, where they check in, whatever, right? But they do that, and this is, you know, I'm not going to say I haven't been to jail before. I've been to Key West jail one other time, and it was for misdemeanors, right? It was boat charges, you know, it was nothing. I mean, I can't say it was nothing, but, you know, it was misdemeanors. But anyway, so the thing is they take me right to the back, right? And they put down all these brown paper bags, and there's a bunch of guards around me, and they literally make me drop all my clothes right down the bag, and they put me in the black and white stripes, and then they put me in chains, head to toe. I mean, chains, you know, like chains. And they take me right to solitary, right? Now, again, I've been to jail before, right? Never for anything close to this. And the thing is and I've never had an experience like it, you know, ever. But they take me there, they put me in solitary, and my mind is spinning. I can't even explain to you guys what it's like. You know, it's like I just didn't know. Look, I was a normal guy a second ago, and now I'm sitting in a jail cell, and I'm, you know, being put in chains, and man, everybody's, you know, people are telling me I'm a murderer, you know, and so I'm in there, and I'm in the solitary, and solitary is weird. It's 23.
Objection to the relevance of solitary.
Well, I'm just telling the story. I mean, look, you can tell me where to stop if you want.
Well, I could sustain that objection.
Yeah, I mean, okay. And I'm not exactly sure what is relevant of anything. I'm just telling the story.
I understand, Mr. Tucker, but...
Anyway, so yeah, I go to jail, and, you know, over the course of time, I mean, you know, it's, you know, I guess it's not really relevant as far as now. I meet my wife. Oh, I shouldn't say meet my wife. I've known her since we were kids, but she was the first person to contact me. You know, she was the first person to contact me when I got there. And I think it was like day 7. And I was surprised. I was really surprised because we hadn't seen each other in 33 years, you know, and I can't even tell you. But anyway, the thing is so yeah, you know, she comes, and by this point, you know, I still didn't have a lawyer. I was still in solitary. I still don't know why I'm there. You know, I have no idea why I'm there, really. I mean, I know what they're saying. I don't know.
Objection, Judge, to this.
I just...
Okay.
Overruled it.
Well, I don't rambling, but I'm not sure how much what we're hearing here is not relevant. So,
would you like me to?
Well, if we'd like a little direction, we can excuse the jurors, or.
Yeah, I'll take direction. I'll take direction. I mean.
Well.
You know, it's like, I just don't know what.
I understand.
Where you want me to
I'm
go.
just suggesting that it would be prudent, in my view, for just a moment or two to excuse the jurors, and we'll get back to you shortly.
Judge is picking a winner there. Just got that on a close-up. Okay, they're going to try to direct him and narrow the scope of his testimony here.
Okay, have a seat. So, I just wanted to excuse the jurors. I mean, not finding fault. Mr. Tucker has, you know, certainly comported himself well on the witness stand. It's just that when you start to get into the circumstances of incarceration, of reuniting with ultimately his wife and the like, you objected. That's objectionable.
Yes, Judge, it is objectionable. He's courting sympathy from the jury, trying to tell them how horrible solitary is. I mean, it's not relevant information.
I understand. I agree with you. I'm not sure if he's intentionally trying to do that. I didn't get that impression. I got the impression he was telling his story. And I didn't attribute any ill motive. I understand the potential effect that it could have. That's why I sustained your objection, and it's why I excused the jurors to try to give some direction so we don't have to keep going back and forth.
Very well.
So,
I mean, I understand he's being allowed to testify in the narrative, but, you know, getting into how devastating this was for him and all the thought process, I mean, what's the purpose of that other than a court?
Well, Your Honor, I mean,
go
if I
ahead.
may.
Go ahead.
Look, you got to understand, this was an extremely emotional experience. And it's like, when I'm trying to remember this, it is hard for me. You know, this was not something pleasant. It wasn't something cool.
Of course not.
You know, and it's hard for me to bring it up and not bring, you know, not have emotions about it.
I understand that. I mean, I think for most, the vast majority of human beings, it would be extremely traumatic, devastating, life-altering, whatever strong words you want to use to experience that. And I get it. And I think I've given quite a bit of leeway in terms of you, quote-unquote, telling your story. But at this particular point, I'm not sure how much else is relevant.
Yeah, I would ask the same thing. I bet. You know, what else would you like me to go into? I mean, how far back do you want me to go? I mean,
they can't tell.
Oh, I did miss the one in there. There is the one where I go to Metro PCS. I haven't talked about that because that is one of the things that got me arrested.
Well,
you know, so I don't know what you want to know.
I can't tell you what I would like you to go into or wouldn't like you to go into. The only thing I can say is that I feel I've granted quite a bit of leeway, but in terms of the building up to the event, if you will, the aftermath, your experience with law enforcement, your experience being arrested, but how much, I don't think there's much room for any more of that unless there's
a couple
something that you're going to say was seized from you, or you're going to try to explain away some statement that you made?
No, Your Honor, but there are a couple of important things that I actually forgot to tell the jury at this point. Not anything, I don't think it's going to take very long. There's just a couple of things as I'm going through this. I mean, I forgot to tell them about Metro PCS because to me it really didn't mean anything at the time, but it does later, so.
Well, that's factual in nature, and I'm not saying solitary isn't factual, but that's really not relevant to the proof or the defense. That's just the, what should we say, the fallout of being arrested. It doesn't go to the elements of the crime or a defense.
No, it doesn't, Your Honor. It's just thinking about it. It was like, okay, I didn't know where to end there, and I can end that right there.
I understand that, and you did kind of indicate amenability to seeking some sort of direction, and that's why I excuse the jurors to try to do so.
Thank you.
So I think we've
gone
given as much of that as we can in terms of direction, and so
I'd say there's a couple more pieces, and that's it. Just to make sure that again, they get the full picture here.
I understand that. So let's bring them in, please.
The self-serving hearsay rule statement that happened outside of court. It boggles my mind because of the setup. Jury's coming back in. Bring the jury. So, including this little discussion back and forth, Mr. Tucker's talked for about 45, 50 minutes, right around there, in testimony, and has a few more, and then we'll have some cross-examination, which I think will be the spiciest.
Thank you. Please be seated, everyone. Welcome back, members of the jury. The defendant remains on the witness stand and is going to continue his direct testimony. So you can proceed.
Okay, and I was just look, I think we agreed that stopping where story where that part is probably a good idea. But there were a couple of things I forgot in there that happened along the way. I go at one point, and this is before I get arrested. I go to Metro PCS, and I'm going to pay my phone bill. Right, that's all I'm going. I'm going over there, and I'm going to go over to Burger King and get something to eat. And I remember Rory Wilson. He's outside of he's outside the warehouse, and I just happened to be going out, and he asked if he could walk with me. Right, I'm like, okay. Again, at this point I don't know anything, so it's like I'm like, okay. So we walk over there, and this becomes something later, but I didn't think of anything of it at the time. But we go over there and I pay my phone bill, and but this is before the raid, and that it becomes something later. But the thing is that I just figured that had to be in there just because, again, it does become part of the story. So does the whole Fantasy Fest thing, that becomes part of the story too. Because I guess I can't testify to what those pieces are. I guess I'll save that for my close. But I felt it necessary to tell you about that trip. And then I just want to make sure that we've got everything here. Because I don't think there's anything else I can remember from the time period that's actually relevant to the situation. I can tell you this, because somebody else asked me this not too long ago. And they asked me if I had ever been to the Treehouse before, right? And yes, I've been to the Treehouse 3 times in my life, right? I was there once because when I first got back to Key West, right, I had gotten back and I was coming from Arizona, right, and I get back to Key West, and yeah, rents here are high. Everybody knows that, right? And I saw an ad in the paper, I want to say. I'm pretty sure that's how it happened. But it was Matt. And it's the only time I've ever met the victim, right? It's the only time. And he was renting out the flats on the Treehouse, right, for $350 a month, if I remember correctly. And, you know, and the thing is, you know, I go there to check it out because, like I said, I'm pretty sure it was an ad in the paper or something like that, right? But I go there and, you know, because I'm looking for a place to stay. I just got back, right? So I'm looking for a place to stay. And when I got there, I was like, okay, it's these flats on the Treehouse, and it's built up. It's like a deck on a deck on a deck, I guess. And, you know, I'm looking at that. And then, you know, for the bathroom facilities, it was like a trailer in the back, and it was like a caved-in roof, if I remember correctly, and there's a toilet in there, nothing else. Right, and I'm like, for $350 a month, I ain't doing it. Right, I'm just not doing it. Right, but not. That's not to say that Matt wasn't. Matt was actually a nice guy. You know, I mean, that's the only time I've ever met him, and he was a nice guy. He was, you know, that's about all. I mean, like I said, I didn't get to know him or anything like that. But you know, he showed me around, showed me what he had, and I just said no. That's all it was. And the other 2 times I was there was at Todd O'Quinn. I knew Todd O'Quinn, and Todd O'Quinn. You know, we went to the bar a couple times. You know, went down to the Hogfish, and I had a little bit too much to drink or whatever, and you know, I couldn't get all the way back to, you know, either Cots or, you know, I stayed at a couple of different places. But yeah, and I couldn't make it all the way back because, again, remember, this is after the storm. You know, I'm still trying to rebuild. You know, and so anyway, I you know, I remember staying there two nights. Like there's 2 different times, but different times, not 2 nights in a row, but 2 different time periods. And just because I couldn't make it back. And I remember one night, I don't know if Paula remembers, but I remember one night she woke me up yelling at me. But yeah, and it's like, you know, but the thing is so yeah, those are the only 3 times that I've been to the Treehouse. And let's see, and then what was the other one? There was something else somebody asked me not too long ago. And I think it's kind of relevant. Trying to remember. It's like, because yeah, that takes care of that. But I'm trying to remember here. Oh no, somebody asked me if I knew Matt, and like I said, I've already answered that question. It was, I met him once, you know. As far as anything else, I'm trying to think of anything else that you guys need to know. I don't know. I guess Mr. Mansfield can remind me now. I guess I'll go ahead and turn it over to Cross.
Okay, thank you. Is there any cross-examination?
Yes, Judge.
Here comes the cross. Buckle up, guys. This is going to be crazy.
Tucker, your story in front of this jury today is you were drunk that day.
Yep.
Plastered.
Yep.
You're drinking highballs, red balls, what you call them?
Fireball.
Fireballs. What's a fireball?
I'm surprised you don't know, but okay.
I don't know. That's why I'm asking you.
No, you're wrong. I was getting ready. I'm answering your question. Fireball is it's a whiskey. It's cinnamon whiskey. You know, it's very popular. That's why I said I'm surprised.
And that's what you drank. That's what you were drinking the day that this all happened.
Yes, sir.
Got so drunk you went back to the warehouse, went upstairs, fell asleep.
Knocked out.
Knocked out.
Yep.
Now you were at the warehouse. You said you had been there on and off, right?
Well, not necessarily on and off. I mean, I actually staying there. I think there was only 2 times. You know, there was during the hurricane, and then there was the time period. You know, for CJ and Michelle. Other than that, I knew a couple people who lived there, and yes, man, I'd stop by there every once in a while.
So you were basically house sitting for CJ and Michelle.
Yes, sir.
But this is not a apartment building, right? This is like a flop house. People are renting rooms or hanging out in rooms.
I wouldn't call it that. And the thing is, you know, because that's a fairly derogatory term. And
okay, the question is very simple. It's not a rentable apartment building where you rent rooms.
Okay, to put it this way, was the landlord doing something illegal? Sure. Did everybody else know that they weren't supposed to be there?
Mr. Tucker.
Well, I don't know what you're asking.
The question is very specific.
Okay, be specific.
It's not a place where you rent apartments. Is that correct?
Yes, it is, because they had apartments there for rent.
Okay. There were actual legitimate apartments for rent in this warehouse.
And that's why I was answering your question the way I did. Legitimate? No, the landlord was not. He was he's subletting this thing, and he built apartments in it.
So you were house sitting for your friends, right?
Yes.
And that's the only reason you were even staying at the place at that point in time.
Yes.
But you didn't have another place to live, right? You were going. You said.
No, I mean the thing is, I was actually saving up for a boat. I actually had money in my pocket.
Okay. I didn't ask you about money in your pocket. You were actually staying at a homeless shelter known as COPS.
Yes,
is that correct?
Yes, I was.
All right. So you didn't have a permanent home.
No.
And you did your share of partying during this time.
Yes.
Right? You said it was Fantasy Fest, and this is what you do at Fantasy Fest. You time went on for a couple of weeks, you said, right?
Oh, yeah. Around Fantasy Fest time, yeah, of course.
It goes on for a while, right?
Yeah. I mean, don't get me wrong. Again, yeah, probably every Fantasy Fest I've ever been to.
Judgment approach?
Yes.
Showing what's been previously marked as whiskey for identification. You recognize that?
Sure do.
As whiskey.
What is that?
That would be me.
And is that how you looked at back in November?
It sure is.
Does that seek to move in, W?
Is there any objection?
No, Your Honor. I'm just wondering what the relevance of what I looked like back then.
I mean, if there's an objection.
No, it's okay. We can go ahead and put it in.
All right. So admit as dates next in order.
18.
Just so happens to be whiskey.
So this is how you look back in 2017, right?
Hmm?
Pretty full goatee.
Oh, yeah. Big full goatee.
Big full goatee, right? Yep. Kind of thing that would be hard to cover if you were putting a mask on that stopped at the chin, right?
I wouldn't say that. I actually wouldn't say that
Wouldn't
because
agree with that?
I mean, again, that would be speculation, so I'll object.
Okay, so you don't agree that it would be hard to cover if you just had a simple face mask?
I'm not going to agree to that at all because, man, again, I'm not saying it would. I'm not saying it wouldn't.
Certainly easier to cover with a neck gaiter, right? You pull the neck gaiter up, it covers the mouth, the chin, everything.
Well, the thing is here's the thing: is that whole neck gaiter thing. I didn't know what one was until after I heard your client say it. Or
Didn't know
I should
what a
say
neck
not your
gaiter
client, but whatever.
Didn't know what a neck gaiter was.
No, I didn't actually. To be honest.
All right. So now you're living at this warehouse. You know Rory Wilson, don't you?
Yes, I do.
You guys are hanging out now and then, right?
Yeah, probably.
Partying together?
I don't know. You know, like again, I didn't go over there all the time because April and I did not get along. So, I'm not trying to hang out with her too much.
April didn't like you.
No, she did not.
You didn't like her?
No, I did not actually. Now, did we hang out sometimes? Sure. And I remember there's times we did party. You know, that was like I remember one time we went downtown. You know, Rory Wilson. Because again, here's the thing: is I remember this during the hurricane. They had, was it the hogfish?
Mr. Tucker, I'm going to cut you off, sir. There's no question pending. Did you hang out socially or not with April Walker and Rory Wilson?
No, April Walker, I tried not to.
Okay.
And you know, I'm not saying she didn't come looking for Rory a couple times, but yeah. I tried not to, but Rory Wilson, yes, I did hang out with him on a few occasions.
And you heard that out.
One thing. Is that exhibit being published, or are you going to take it back to the...
Oh, I've already published it, Judge.
Okay, so we're going to either put it on the podium or let's bring it to the clerk. Thank you.
Okay, so, Mr. Tucker, so you heard the testimony, right? You heard that there was an allegation that you threatened April Walker.
Oh, I've heard that testimony, but that testimony wasn't true.
So you didn't threaten Wilson's pregnant, 9 months pregnant girlfriend?
Oh, no.
You actually felt bad for her because she was put on the ground during the raid.
Yes, I did. And man, look, even if I don't like somebody, you know, again, seeing them on the ground in that position when she's 8 months pregnant, yes, that's not cool. You know, that's bottom line. I didn't like her, but that doesn't mean you put her on the ground in that position.
Now, you testified that you went up to CVS with Rory Wilson that night.
No, I did not.
When did you and Rory Wilson go to CVS for you to
tell you the honest
smoke?
truth, that was put to me by investigators. They said that, but again, I told you I was drunk that day, and I'm sitting there and I tried to remember it, and man, I'm sitting there going, I don't remember doing that.
But you just testified to this jury that you went to CVS to get cigarettes?
Oh, I went to Tom Thumb to get cigarettes, and it wasn't with Rory Wilson. It was with Travis.
With Travis?
Right.
You and Travis went. Let's talk about
get
Travis.
the story straight.
You and Travis were acquaintances, right?
Yes, we were acquaintances.
Okay. Travis was staying at the warehouse as well, right?
Yes, sir.
Matter of fact, you and Travis were both staying upstairs in the warehouse, right?
Yeah, when I was staying in CJ and Michelle's room, yes.
Travis was in another room upstairs.
Yes, he was upstairs. But you got to remember, he also went to jail. So, I mean, he wasn't there for a second. So.
Right? But he came back about a week later, right?
To be honest, I don't remember how long it was. I know I was at work when he went to jail.
Let me ask you, Mr. Tucker, was Travis there the day of the raid?
That's the thing is, he wasn't there in the beginning, right? Because the man, he wasn't there.
Was he there when they took you down and put you in the police car?
No, he wasn't there for that. He wasn't there for that part of it. At least not that I know of, right?
Was he there when they took you off to jail?
Was he there when no? So when I went to jail, I was at COTS. And when I went to jail, I wasn't. They didn't grab me from the warehouse. They grabbed me from COTS.
The night of the raid, they didn't take you down and then let you go?
They did take me down and let me go, but that wasn't taking me to jail. That was taking me down and interrogating me all night.
Okay, so the night they took you down to interrogate you, was Travis there when you guys left the warehouse to go down and be interrogated?
Hold on. Let me make sure I'm hearing this correctly. Please repeat the question.
The night of the raid.
Right, gotcha.
When they took you down, not to jail, but to question you.
Right, gotcha.
Was Travis at the warehouse when you guys left to go to the police station?
I don't know. To be honest, I don't know.
And how did you get to the police station that night?
I got there in a squad car in handcuffs.
Okay. Now, let's see. You said that while you were after you got arrested, you were in jail and you got reacquainted with an old high school friend of yours.
I thought that wasn't relevant.
You just testified to it, sir.
Okay, well, in that case, yes, I did.
I'm going to ask you just answer the questions if you could.
Did he object?
And if there's a relevance objection, you can make it.
Thank you.
But you don't need to question me.
Okay.
You said you were in jail.
Yes.
And you got reacquainted with this high school wife or girlfriend of yours who became your wife.
Well, actually, to be, again, she wasn't my high school girlfriend. She wasn't, she was a friend that I knew from when I was 14 years old. And yes, I hadn't seen her in 33 years.
And you guys ended up getting married, right?
Yes, we did.
And she is actually very wealthy, isn't she?
Multi-millionaires.
I beg your pardon?
Multi-millionaires.
And
he spells it
you
out
guys
for
are you married today to her?
Yes, I am.
Going beyond, I'm sorry, but I cut him off of your objection, and
Okay, Judge, well, he just testified about his wife.
He mentioned it, and you touched upon within the scope, but I believe this is beyond the scope.
I have no problem talking about my wife.
Okay.
I understand, but I do.
All right, so now you're not in jail the entire time waiting for your trial, right?
No, that's not true. I was in jail for 2 years.
And then you actually got out pending your trial?
$2 million bond.
Let's talk about Paula, your relationship with Paula Belmont.
Okay.
You just testified that you weren't great friends in the beginning. You just kind of knew of each other, right?
That is true.
She testified you'd never been to the Treehouse, but that's not accurate, right? Because you testified you'd actually been there 3 times.
I don't remember her ever testifying to that, but she may not have remembered it. It was 1 time. That's it.
I thought you said 3 times.
No, I've been there 3 times, but Paula, and she woke me up one time yelling at me. You know, because, man, I wasn't supposed to be there, apparently. I don't know. But, man, the thing is, she woke me up and she was yelling at me. I don't even know if she remembers it.
And now, describe your relationship with Paula today.
Paula's one of my best friends.
One of your best friends?
Yes.
All right. I'm going to show you what's been previously marked for identification. There's a deposit, 2 photos, Sierra 1 and 2. Do you recognize these photos?
I sure do.
What do they depict?
They depict me and Paula at the hospital when I'm trying to make her feel better and making funny faces at the camera.
When were these shots taken?
Very recently.
Judge, at this time, I think to move in states Exhibit S for identification.
Any objection?
Nope.
All right. Admit S.
19A and B.
All right.
I think Tucker's winning this exchange. I realize it's awkward. It's all over the place, but the prosecutor, with his brashness and how he's attacking, and the Tucker's openness and willingness to talk about it, to discuss it, I think in the jury's eyes, it's endearing him to them more than this prosecutor.
Thank So you said these were taken recently, like in the last 2 weeks?
Actually, you want to know exactly which day? I think I can remember.
Sure, go ahead.
It was the day that I actually, went over there to check on her because she said, she said that, she was, her doctor said that it had taken it worse. It was the day before I came in here and asked for the motion.
It's Mr. Tucker saying,
Didn't she have some kind of an infectious disease or something?
Hence the bodysuit.
But you had no mask on that picture.
That's true.
I was hanging out?
Took a chance. I was trying to make her feel better.
This is like, I was taking these pictures when I was late to court.
Like I said, she's one of my best friends.
Well, what's changed? Now you said you were not always friends and now you're best friends with her. What changed?
Well, I don't know if you know the story of how that happened, but I'll go ahead and tell it to you if you want me to.
Sure, go ahead.
Okay.
Now we can.
Paula was a victim in the crime, right? And now I am an accused murderer at that point, right? And here it is when this all happened, that makes it so that I can't talk to Paula, right? I'm not allowed to communicate with her. That makes sense, right? They had a protective order that immediately went in, and I couldn't talk to her. Paula, she gets diagnosed with COPD, right? And Paula, she actually files a motion with the court, right? Because she wants to, and she goes on the press and she starts saying this on the press, right? She wants to apologize to me for her role in, in anything that they've done to me. That's what she says.
So she's
and the judge
apologizing to you.
She wants to. She can't talk to me, right? So she wants to.
Now you're aware in the beginning she couldn't ID the second person, right?
Look, I'm aware in the beginning.
Very simple question. You are aware, yes or no, that in the beginning when she was first spoken
Mr. Mansfield,
she could not. Mr. Tucker,
you're
listen to
asking me
the
to
question,
remember
okay?
6 years ago, and
it's
then
a very simple
what I
question.
thought then.
Are you aware?
Gentlemen, let him finish the question, and you can answer.
Yeah, let me answer it.
Okay. He hasn't finished the question.
Okay.
Go ahead.
Ask away.
Thank you. Are you aware that 6 years ago when she was first interviewed by the police, she could not ID the second person? Are you aware of that, yes or no?
I'm going to tell you, I'm aware that she could not positively ID the second person, man, when this first happened, no.
And she was able to identify Roy Wilson, but not the second person, correct?
Yes, she did not positively ID the second person.
Well, she said she didn't get a good look at the second person, right?
That's not true.
She said that she was focused on Roy Wilson at the time, and that the second person,
I object, Your Honor.
she
He's
couldn't get a
asking me
look
to go
at.
what I know from video and what I know from police reports now.
I sustain the objection. There
from the witness chair,
statements
objection
that she's
sustained.
made.
Yep.
So at one point she said it, but presumably you're aware of other statements.
Right. Because again, I watched all these videos and I read
So
all
let's
this
go back
stuff.
to that first night when she's interviewed. She says she can't ID the second person, right? Didn't get a good look at it.
Hold on. Excuse me. Which night are we talking about?
The night of the crime when she's being interviewed.
Again, you're asking me to go to video. You're asking me to go to police reports, and that is hearsay. So
Are
I'll
you
object.
aware that she was
Object.
unable to identify the second person?
Excuse me?
Are you aware she was unable to identify the second person?
At which time period?
The night of the crime.
Again, you're asking me to go to police reports. You're asking me to commit hearsay.
Simple question, sir.
So objection.
Okay, I'm going to overrule that objection.
Okay.
It's just your awareness of one
My
point
awareness-
in time and one statement.
My awareness at the time, right? And if I can, and I'm going to have to remember this because the Lord knows I've gone over this a million times. So I'm going to have to think about my memory here. At the time, as far as even any statements by Paula, hold on a second. Because, okay, I was in jail when this first happened.
I'm asking
Right?
you, as you sit here,
Sir,
Mr.
you're
Tucker,
asking me to remember.
I'm asking you as you sit here today, not where your mind was back then, as you sit here today,
As I sit here today,
are you aware that she could not ID the second person on the night it happened?
Okay, and you're asking me to commit hearsay.
I don't believe that's the case. So you
can
answer it, and remember, you'll have the opportunity for
as I sit here today.
Just let me finish. You'll have the opportunity for redirect.
Okay, thank
you.
you.
So if you, after this is finished, want to elaborate on certain things, you may. But in terms of succinct answer to this question, you do need to give.
I'll give you a succinct answer to this question. Okay, it depends on the time period as far as Paula. As today, I could definitely tell you that different time periods she said different things. I can say that.
And you're aware that the very night it happened, she did not identify the second person?
The very night it happened, again, that's the only reason I would even remember this right now is because we've been going over it recently.
Correct.
And I'm going over it, and she had varying statements at that point.
Well, you're certainly aware that at the perpetuated testimony, she was able to say it wasn't you as the second person, right?
I'm also aware that she was, again, coerced into making statements by police. So, okay.
Didn't ask you about that, sir. A very simple question.
Well, if you're going to lead me.
You were aware that during her perpetuated testimony that you sat and watched, you observed her adamantly stating it was Tucker's not the second guy, right?
Yep, I sure did.
That was 4 years after the crime was committed.
That was
about 3 years.
That was 4 years after the crime was committed.
Well, September of 20 would be about 3 years, right?
Okay, somewhere in there. But here's the thing.
And there's no question pending, sir. I'm asking the questions you're answering.
Go ahead.
Okay? That's how this works.
Okay, go for it. Ask me another question. I'll take any ones you got.
Great. Good to hear it.
Yeah. That's why I put myself up here.
Oh, my goodness.
Now, she testified that she had talked to your wife through Facebook. Did you also communicate with her through Facebook?
No, I was not allowed.
So you never had any communications with her?
No, not on Facebook at that time.
Have you had any? You saw her at McDonald's after the crime, right?
Yes, but I was not under arrest at that point. I was not under a protective order at that point.
Okay, but when you saw her at McDonald's, you guys had a conversation there, right?
Yes, we did.
And did you tell her anything about the crime when you saw her at McDonald's?
I told her what had happened to me, about the police interrogating me, and she did ask me some questions. I remember that, and I remember answering, different questions as she asked them. I remember she told me her experience. She told me how horrible it was. I remember, like I said, sitting there feeling like, you talk about feeling, God, not sorry for somebody. That's the wrong way to say it.
So you communicated with, is it fair to say you communicated with her at McDonald's?
Yes.
Now, is it your testimony today that you've not communicated with her directly at all from that moment until today?
No. When did I say that?
So tell us about those communications. You said you weren't allowed to talk to her, right?
Yes, sir. And I also said,
and when did that end?
I also said she filed a motion with the court to be able to talk to me, and that yes, she was going on the press saying these things, that she wanted to apologize to me. Judge Jones granted that motion, and she was allowed to talk to me.
And
that's when now we
you've
are
had general communications with her ever since.
He was still testifying.
Sorry, I'm just telling you.
No, I'm not talking to you. I'm saying if you weren't complete with your answer, go ahead.
Yeah, I'm just, look, there comes a point where...
Judge, again, there's no question pending.
No, well, he was still answering the last question.
Yeah,
so go finish your answer to the last question.
Judge Jones granted the order allowing us to be able to talk. And that day, yeah, I was in tears.
Okay, so you got the in tears part out. The jury heard it.
Yep.
Okay?
Yeah, thanks.
All right, great. Let's move on. So you've talked to her, admittedly, since then.
Oh, quite a bit.
Quite a bit, right?
Yeah, quite a bit.
You remember her taking a trip to California?
Vaguely, yes.
She posted pictures of it, right?
If I remember right, she posted pictures of Woody.
Of who?
She likes Woody from, I guess, I forget what the name of the movie is. It's some Disney thing, man.
Cartoon?
But she likes a character named Woody.
Woody the Woodpecker?
Oh, Woody from Toy Story.
That's what it is.
Woody from Toy Story. I was going to say, do we need a woodpecker on the treehouse?
1 minute, please, Judge. All right.
Toy Story.
I'm not sure if we could talk
I can't
at
use that
time,
image. So now Disney's involved. Great. Here comes the lawsuit. Where's it? Pixar. Is it Disney or Pixar? Or is Pixar Disney now? I think Disney owns everything now. Every movie is made by Disney. Princess Leia is now a Disney princess. I know everything's conglomerated into one big whole. Both companies have lawyers. The cease and desist is in the mail.
Violet.
This is nuts. This is bizarre. This is crazy. Honestly, I think Tucker's doing better than I thought he would on this.
Wouldn't he normally have to show this?
I'm sorry?
Would he normally have to show this to me before? Yes. Yes.
Not necessarily. It's fine.
Checking.
That's fine. He's certainly going to give you an opportunity, and you know, you can go from there.
Okay, thank you.
Yes.
Mr. Tucker, showing you Mr. Mark's Tango 1 through 5 composite.
Okay.
Recognize these photos?
Yes, they're from Paula Belmont's Facebook page, and the thing is, I don't think we were talking at that time.
How do you know her from her Facebook page?
Because I've seen her Facebook page.
So, do you remember seeing these on her Facebook page?
Yeah, I don't understand the relevance of them.
Judge, at this time I seek to move in what's been previously marked as Tango 1 through 5.
Okay. Is there any objection?
Yes, relevance.
Again, I'd like to know the relevance of the pictures.
Okay, you're objecting to
relevance.
Okay, so we'll have to have a bench conference then. So come on around.
Run around, everyone. Musical chairs come around the front of this. This is bizarre. This is crazy. First of all, just the optics of having a pro se defendant objecting from the witness stand under heated cross-examination and winning an objection, now questioning the relevance of stuff he's being crossed with. This is crazy. This is crazy. You don't see this. I mean, this does not happen. We don't see this. You can't make this stuff up. Oh my goodness. Homeschool Ground Zero, welcome. This is my wife, by the way, you guys. She's amazing. I love her. Thanks for being here. Wouldn't be the same without you, honestly. All of this, none of this. Let's see. They're going to say he was communicating with her on Facebook. I think that's what they tried to where they tried to go with this. He says, I don't think we were communicating at the time. So he says, well, how do you know it was it was from Facebook? He says, well, I've seen her Facebook page. That's how technology works. You can go back and scroll back through somebody's timeline. You don't have to be friends with them. You can see what they posted before you became friends with them. Musical chairs is over evidence Tango 1 through 5. The prosecution is coming across as hot under the collar. I think he might make a blunder because Mr. Tucker, even though he's animated in his responses and talking over each other and interrupting us, as he has throughout most of this trial, honestly, especially at the beginning more so, he's handling the pressure better. This is just crazy. The prosecutor's drinking Evian water. Evian? I've never had that. Whoa.
All right, so let's pick it back up. You're aware of her trip to California, right?
Yes, I am.
She took pictures with Woody, you said, right?
Yep. I think she takes them pretty much on every trip she goes on.
All right.
Audio's lower. We can see what we can do to boost it here. See if this is any better.
Ever since that order was lifted, you've had pretty steady communication with her. Is that fair to say?
Fairly steady.
If those pictures don't come in,
more, sometimes less.
Tucker won that objection.
Now, you talked about this friend, Big somebody. What's his name again?
Big Scott.
Big Scott.
Yep.
Big Scott was staying at the warehouse with everybody?
No, he was not. He was there that night, yes. But
which night is that, sir?
That would be, I guess that would be the night of the crime. Because, again, you know, like I said, I went go get cigarettes with Travis, come back, and Big Scott is at the door.
And so
Baylor's
Big
doing his
Scott, was
job
he a
again.
friend of yours or an acquaintance? How would you describe him?
Actually, he's a friend, you know, and he was a friend of, I think he was a friend to a couple people there.
And at some point, are you aware of Big Scott telling you and Travis and Rory, I don't know what you guys are plotting, but I want nothing to do with it? Do you remember that comment?
No.
No?
No.
When did you first learn that Mr. Bonnet had been murdered?
I told you that already.
Asked and answered.
I told you that already.
Okay, but you need.
I didn't. Well, actually, I shouldn't say I knew Mr. Bonnet got murdered at that point. At that point, the first time I heard anything about what had happened at the Treehouse, and it wasn't even the Treehouse. Where, you know, they told me somebody got stabbed in the CVS parking lot. That's the first time I heard about it.
So the way you heard about it, the stabbing
Yes.
was alleged to have happened in the CVS parking lot.
Right. The next time I heard about it, I was at the police station.
Is that when you found out it was actually at this Treehouse location?
Yes.
And that's when you were talking to Detective Pitcher, right?
That would be Detective Pitcher, Danielle Malone, and Captain Phelps.
Now, at some point, didn't you tell Detective Pitcher what you told this jury today, that you were not involved and that you were sleeping off, you were drunk and sleeping it off or something?
Yeah, I told him, man, I told him the same thing. I couldn't remember much, man, from the night. And yes, I remember passing out. I remember waking up.
Right.
Because I needed cigarettes, and I went to was it the Tom Thumb, and Travis went with me.
And that's what you told Detective Pitcher, correct?
Yes, it is.
And you even told Detective Pitcher that just ask Travis, he'll back you up, right?
I thought so. I didn't know anything was wrong.
All right. Well, Travis didn't back you up, did he?
No, he didn't.
Travis
there's
came
a good reason
clean
for that.
and gave a statement to the police, didn't he?
Yes, he did. And,
Okay.
you know,
It's just
again,
yes, no?
Okay. Yes,
I
he
need
did.
your commentary on it.
Yes, he did.
Problem is, Tucker needs to be keeping tabs on this and writing down notes.
Do you remember when
So
you
he
saw
can
Paula at McDonald's in this
redirect
whole
himself.
timeline? When did you run into her at McDonald's? The very next day? Was it 2 days later? 3 days later?
It was, let's see, hold on. It would have been, okay, because the raid, suppose, you know, if you want to call it that, whatever you want to call it, that happens on the 21st. Going into the 22nd is when I'm literally being interrogated all night. That day, whatever that day is, that would probably be, that would be the 22nd again, because it ends that morning. So, okay, 22nd, it would be on the 22nd.
Okay. And let me ask you, Mr. Tucker, you were making pretty good money, right? $300 an hour to put these blue tarps up?
Yeah, I was doing all right.
What's the reason you hadn't gotten a place? You know, you were still living in these temporary places.
I lived on a boat before, right? And as I testified, I was trying to save up for a new boat. There are going to be plenty of cheap ones around, but here's the thing: is I don't like paying outrageous rents that are in Key West. I'd rather buy a boat and live on the water.
Now, you said you'd passed out that day drinking these Fireballs, right?
Yes, sir.
What time in that, like what time, take us through that day, the timeline for that day. When were you drinking these Fireballs?
I know, look, it's like I said, I don't really remember the day that well. I remember drinking during the day. I do remember that. I don't even remember all who was there. I know there were other people that came in and out. I know I passed out somewhere along the lines, you know, but that, I mean, asking me specifics, especially 6 years later, I couldn't tell you.
So you started drinking these Red Balls, was the sun still up?
That would be Fireball, sir. And
Fireballs.
Yes, the sun was still up, you know, while I was drinking. That is true.
All right.
Bull,
Do
Fireball.
you remember getting out of bed and going right to the partying phase, or did you do something else before it started that day?
I already testified to that. I told you that.
One gives
Okay,
you
well, I'm
wings, the
asking
other makes
again.
things
Okay.
foggy.
I appreciate you reminding me.
I'm just saying is I went to, okay, I woke up at some point in the time and I went and got cigarettes at the Tom Thumb. And I came back and Travis was with me. And yes, Big Scott was there. I told you what happened after that.
But I'm talking about earlier in the day. When you got out of bed that day, did you go do something, or did you just start drinking?
No, actually, I mean, I'm pretty sure, because if I'm drinking during the day, I had a day off. So, you know, if I'm drinking during the day, I had a day off. So, yeah, I would imagine I had the day off.
And do you remember passing out that day?
Yeah, remember passing out? I don't know if that's a proper term, but no,
Okay.
I don't remember passing out. I remember.
Don't remember passing out?
I remember I
That's not how
passed
passing
out
out
somewhere
works.
along the lines, but yeah, I don't. I guess I'm being too literal here, but I remember. Yes, I went to sleep sometime during the day and night. I don't know.
And do you remember what time you woke up?
No.
Day or night?
Night.
police cars already out and about?
Policing cars were already up there on Laurel Avenue. I could see, because, okay, I could see the lights from the Tom Thumb parking lot. I could see all the lights that were up on Laurel Avenue.
This is absolutely bizarre.
Do you know how many times Mr. Bonner was stabbed?
At this point, yes.
So now, I guess your story is that this is all being pinned on you, right? That you didn't do this.
You would know better than anybody, Mr. Mansfield.
Oh, would I?
Yes.
But I wasn't there. You were. So why did you tell me? Are you telling me this was all pinned on you?
I hate to tell you, again, Mr. Mansfield.
It's very simple,
You
Mr.
just
Tucker.
said
Is
that
your
I was
story
there, and you
today?
have no proof
Is
of
your
that.
story today
Sir.
that you were?
Sir.
This is all being made up, and that you didn't do this.
Yes, this is it. That is my story all day,
Okay.
and I've said it since day one.
So this is just the big Bubba system going after you to pin this on you.
Yeah, and Mr. Mansfield. Again, I can answer that. You know, would you like me to answer it? Or would you like me to tell you how I know that? You said you didn't want to go into that.
Well, you know what? Let's not go into that because I'm pretty sure what your opinion is has no factual basis to it.
Really?
So, in other words, this is your
Object.
theory that this is all being pinned on you by the big Bubba system.
Your Honor, I would object unless he wants to let me go into the things he doesn't want to.
I'll sustain that last question as argumentative.
Move to strike.
I have nothing else.
Move to strike.
Thank you.
So, now
Redirect.
Conduct redirect in the same fashion, but just remember it's within the scope of the cross. We're not, all right?
Oh my
Thank you.
goodness.
I don't even know if I want to read. I don't know.
Well,
what I
you
want
don't
to
have to.
I'm just trying. Let me think about what
All
Mr.
right.
Mansfield just asked me because
All right, take a
I was
moment.
kind of getting blasted there.
If you need a moment, take a moment.
Thank you.
It's not mandatory redirect,
No.
just if you want the opportunity.
Right. Again, yes, again, I think I would like to address that last thing there, but I mean, yes, I do know that I'm being set up I'm being set up for this because I'm here.
He opened the door.
That's an obvious.
Go into this. He opened the door.
I won't go into.
You have
again, the things we're not supposed to be talking about right now.
He opened the door.
But I do. Let's see. As far as everything else, I mean, everything else you just asked me, I'd already talked about. So I don't think there's anything else I need to say.
All right.
Thank you.
Thank you.
The prosecutor opens the door by bringing this up. He literally, the light was shining through. It was not a crack.
Break, folks.
It was wide open.
Till I'm just looking at the clock. 1:55. No, 2:55. 2:55. Same procedures and protocols. If anybody wants to go outside the jury room, let the bailiff know.
Within the scope of what was addressed in cross, the prosecutor brought up his theory that he was being railroaded and that this is all a conspiracy, that it's the Bubba network. He literally wrote the script for him. All he had to do was say, yes, about that last point.
All right.
I'd like to go into that, just within that scope.
Testify now and remain my previous ruling, so that completes the defense case. I don't know if you're going to make a motion, renewed motion now or after the rebuttal.
Renewed motion for directed verdict?
You talking about a renewed motion for acquittal?
That's what I'm talking about.
Yes, I would like to do that. I'd like to do that after the rebuttal, I guess.
All right.
What time is it, Your Honor?
It's, what, 2:38, basically.
Okay, so I don't know how long they plan on doing that.
Well, I mean, I don't know how long this video and the deposition excerpt shouldn't take very long. I don't know how long the video is. It's
about half an hour.
Maybe 10 minutes, Judge.
Okay, so
total half hour.
So that's their rebuttal isn't going to take that long.
And we did agree we're going to play the full first video, right?
Yes.
Yes.
The full first
All
video.
right, well, let's all take a break, and then we'll have the jury, then we'll have the rebuttal, then we'll excuse them, then we'll have the
Argument
Instructions.
for the motion, and I assume that the state's got a proposed set of jury instructions.
We do, Judge.
And I presume you've shared them with the defendant, or will?
I'll give him his copy right now, Judge. Prepared the jury instructions and the verdict forms.
Okay. I guess.
No, I'm going to give you hard copies. Okay, that's fine.
And we'll talk about. All right, we'll be back.
We'll be back.
2:55.
The judge pulls an Arnold move and says, "I'll be back." Wow, you guys! Oh my goodness! Oh my goodness! Oh my goodness! This opportunity that Mr. Tucker, honestly, I'm going to say it. The door was opened for him. He made a couple objections that were timely, that were appropriate, that were sustained. It's funny to see a witness on the stand objecting to a question and the judge sustaining it. It's something we don't see very often, and I love that we got to see that. But the door was opened. Oh my goodness. Everything he wanted to say in this case, everything that has been kept out, everything that has been off limits, the prosecutor opened the door, paved the way, even called it the Bubba Network, the good old Bubba Network. And Mr. Tucker didn't take the chance. Now, on the appeal, which I believe he will have an appeal, he has not been... Ivan, you get 60 seconds. Is that fair?
Call
Hang on
from
a second.
Mr. Ayden.
Hang on 1 second.
To accept, press 1.
Ivan,
Hey,
are you as frustrated as I am?
Well, I'm going to take the contrarian route here. I think, yes, the door was open for him, but the less he talks, the better. And I can't, I was on the team of, please don't testify. Please don't testify. Me and Jules actually agreed. The earth collided. Armageddon happened. Hell froze over. We agreed. But I actually think he held his own on that cross. The DA seemed aggressive. He seemed, he was just unlikable in everything he did. And so I actually think, yes, the door got opened. But I think it's better. Sometimes less is more, okay? And I don't know if he even realized that at the time, but he doesn't want to go down this trail where he has no idea where he's going, and that seems to be how he works. And so I think it's better that he left it at the point of, look, this guy just completely, left the ball hanging.
I hear you, Evan. Let me go off for a little. Let me spin. Let me have my wheels and do donuts on this one. I'm not sure if you want to stay on or not for that, but
let's do it.
You know what he could have gone into? He could have gone into the IA. He could have gone into the detectives that were fired or demoted for their role in this. He could have gone into the officer on the scene. He could have gone to all the corruption. Okay, the parts that look to point to corruption. Say, look, this is dirty. We could go into everything. I'm not happy with how this went down. It should have been handled another way. But these are the facts. Okay, where's the body camera video of that officer? Because there is body camera video of that officer saying that $100 bill. Oh, that's mine. That's my $100 bill.
But he can do all that in his closing. All right, he can do all that in his closing argument, and so he doesn't have to get up there.
But he's got it on redirect. He's got it on redirect, and the state can't do recross. This is a free play. It's a free play.
I understand, but he can pontificate all he wants. If you start standing up there as a defendant who's pro se and start claiming conspiracy or dirty police, you start to look like a madman at some point. You understand what I mean? The jury starts thinking, okay, this guy's just going off on tangents. He thinks the whole world's against him.
Won't it look up the same if he does it in closing?
No, because in closing, everybody knows closing isn't evidence. And
but that's the thing. The jury can't consider that. So if he is relying on closing to convince the jury.
They can't by law. But they always do, R.A. Let's be real.
I don't know. Ivan, thank you for your egg timer ran out. Thank you. You kept it real one more time. Appreciate it, my friend. We'll see you.
Love you.
Bye. Oh, my goodness. So now he's going to do another JOA, the light most favorable to the defense. It's to the light most favorable to the prosecution. But the problem is there's zero chance that
call
There's
from?
zero chance that it would be upheld. Jules, do you still agree with Ayden?
Twice in one day.
Even a broken clock.
I do. I cannot believe I'm actually saying this, but I do agree with Ayden once again. And I also agree with you, Scott. It was a missed opportunity when they opened that door. I understand Ayden says, he can do it during closing, but I'm with you.
Wouldn't it be better to have it as evidence?
It would have been better as evidence.
Evidence on the stand I mean, they would have objected all over the place, but the door was opened. The door is open. You can't. There's no way that. I mean, this would be appeal all over it. It would be like granted appeal if the judge allowed the state to talk about his theory and how wild and everything, but then not let him defend it and say why. That's
yeah. So he did miss that opportunity, but overall, in my opinion, I think he did a great job. I think he did a better job than I expected it to. I thought he was going to go down, no pun intended, but like a fireball. He did great.
Like a blazing fireball or a Red Bull, one of the two. Let me ask you this. Now the thought's gone.
Sure.
What do you think about the judge having changed his demeanor today?
Oh, something's up with that. I think you're right. I think during that breather he took, he may have made a phone call and he or he really sincerely thought about it and felt that, I've got to give this guy some weight. The afternoon went way better than I expected it to, and I'm not quite sure if I was Ayden. I mean Tucker. Sorry, Ayden. That I would go through with that motion to disqualify the judge. Would you at this point? I think he did great this afternoon.
I don't know. He did great, but still, I mean, he has witnesses that didn't get to testify. He has evidence that would go to help.
That's true.
So I think if Tucker had his way, this would go down differently. Already, he would want to redo, but you might have to at least file the motion while you wait and see. He'll have to get it in before tomorrow. It's going to be tomorrow morning. He's got to have that ready.
Yeah, he has to have that ready tomorrow. And in my opinion, I don't feel that the state proved their case beyond a reasonable doubt. And I think Tucker put on enough a reasonable doubt that he should be found not guilty. But then again, you never know what a jury's going to do. So anyway, on that note, I'm going to let you go. You might have other callers. Everybody have a great day.
All right. Thank you, Jules. Appreciate it.
You're
Love
welcome.
You.
All right. Bye-bye.
Bye. Yes. Welcome any other callers you want to call. We'd welcome. This is the phone. It's a burner phone. Anyone who can call. Doesn't have to be the same people all the time. Hey, Amber, how's it going?
I'm good. How are you?
Doing great.
I'm not chastising the chat this time, I promise.
Okay. We're all on pins and needles. We're like, what did we do wrong this time? I've got Blackbird Speaks calling me, so make it quick.
Except for Mrs. R.A. She called herself out.
Yeah.
Correct me if I'm wrong. He can't bring this into evidence or bring this into his closing argument because it wasn't introduced as evidence.
Well,
the opening statement is a theory of the case.
The opening statement
is a wrap up.
The other way around. The opening statement is the map, the roadmap of what you're going to hear. You will hear testimony from this. You'll hear this. The closing really is where he gets to wander, and it's not evidence, and that's why they often do the jury instructions and then the closing, because the jury's like, you've heard everything you need to hear to deliberate, and now they're going to talk for a little bit, and then you get to go deliberate. But just disregard it.
But you have to sum up the evidence that was presented in the case, and the light most favorable to your theory.
You don't have to. You can say pretty much whatever you want. I mean, you could stand up there and read the dictionary. The judge might object.
I think we disagree there. I do not believe he can bring anything in that was not admitted into evidence.
What will happen?
In the trial.
What will happen is he'll bring something in that's not admitted to evidence. The state is going to object and say, "Hey, that's not evidence that was admitted to trial," and the judge will say, "I understand this is closing arguments. The jury's instructed the closing arguments are not testimony. You can continue." That's what's going to happen.
Red Pen, I just saw your comment.
Marianne says the DA knew. He opened the door and quickly sat down. Yep. Okay, I've got Blackbird Speaks calling the phone.
Just point out.
Yeah, go ahead.
Yep, you're fine. The chat agrees with me, so you're wrong. Bye.
Okay, Amber used to be one of our great mods. Amber, no, just kidding. Oh, Blackbird Speaks. I just lost you. I tried to pick it up. Let's see. Okay, we'll let her try one more time. She's been calling over and over. Okay. Amber is correct. Can I phone a lawyer? Amber is correct. Agree with Jules.
Call from.
I'll try one more time. Blackbird Squeaks.
Blackbird Squeaks, how are you doing?
I'm good. First time caller.
Hey. We've texted before, though. How are you doing?
Yeah, we have. Hey, I just wanted to bring an analogy to the game here.
Mm-hmm.
And we're going to talk basketball. The defendant, as annoyed as I have been with him today and his narrative, which didn't include any I says, which Wisconsinites would have understood right away that was, we would have followed it a little bit better. But this guy, he was wide open in the 3-point zone to win the game. And he knows he doesn't have a good 3-point average. And so he didn't take the shot. And I don't blame him for that. So I agree with Ayden and all. But I also think he's going to be kicking himself after today's adrenaline wears off.
Here's what I think. Same analogy. End of the game. You're down by 1. You've got the ball. You're at the 3-point line. 10 seconds left. He just dribbled out the rest of the game.
Yeah.
He didn't shoot. He didn't go for layup. He's like, nah, we're good. I'm pretty sure.
Yeah.
Sure. Being down by 1, I think I've got this in the bag.
Yeah, I almost think that the prosecutor might have hedged a bet. I don't know. The first thought I had was prosecutor hedged a bet. I'm gonna throw this up there, and I bet he doesn't get it. Like I bet he is too hyped up to sink this one.
Blackbird Squeaks, thank you so much. Appreciate that.
Hey, thank you.
Good talking to you.
I'm keeping up with you.
All right, we'll see you. Bye.
All right, bye.
I just barely missed a call. Sorry. So everyone's saying I'm wrong. Correct me if I'm wrong. Can't they wander a little bit in the closing? I realize I'm not saying he's introducing a new theory of defense. He's said this all along. He's not changing that. But in this case, during the testimony portion of the case, during the case in chief, on cross-examination of his testimony, the state brought in this question. The state literally asked these questions. Can he not also address these same questions in his closing? Yes, I think he can. He can't misrepresent evidence. I'm not saying he can misrepresent evidence. The facts not in evidence part, he can't misrepresent. I don't know. Let me think this through.
Call from
Meaty Banana.
Meanie Banana, I'm getting schooled in chat. Are you on my side or are you on their side?
I'm actually on their side.
Okay. Well, thanks for calling. No, just kidding. What's on your mind today?
I just think Tucker just blew it. I think he could have made so much more out of that. He just doesn't have the knowledge, the legal knowledge to. That would have been just icing on the cake. He could have just, won the whole thing. I think.
I think he did win that exchange. You think of all the times, and that basically means I'm wrong again when I say he shouldn't have taken the stand. If he won that exchange, I think it was something he should have done. We'll see what the jury decides. I don't think him taking the stand changed them one way or another, but it was the DA. That's a loss for them. Yeah.
They screwed up. somebody's going to get yelled at. But they're lucky he didn't walk through that door that they left wide open.
Yeah.
But, yep. All right. I'll talk to you later.
Thanks,
See
Nina
you in
Banana.
chat.
We'll see you. Bye.
Okay. Bye.
Amber is adamant. Her last post as a mod says right here, no, you cannot wander. You have to stick to the facts that have been presented during trial and present them in the light most favorable to your theory. I hear that. But I believe there's things he can do within that. I don't know. Okay. I may be completely wrong on this one. I've been wrong before. I'll be wrong again. I'll take that as an L. Chat is 1, RA 0. That's where we are today. All right. Prosecutor should be embarrassed. I think he is. But I'm more interested in what the judge is doing right now, because the judge has now proposed to Mr. Tucker, would you like to renew your motion for a judgment of acquittal? Why is he doing this? Why has he completely changed his tune? He's singing a different song now. This judge is singing a different song and saying, yeah, would you are you going to renew that motion? Are you going to ask me to renew the motion? He hasn't provided that sort of guidance in the past, at least not this blatantly when it wasn't asked for. Is the judge thinking, okay, I'm in deep trouble. I crossed the line. I can fix this by having him renew his judgment of acquittal and grant it. Is that a possibility? No? Amber, thank you. Love you to pieces back. Just let me know if you know of anyone who wants to be a mod to replace you. Just kidding. Just kidding. What's the buffer sound? Let's see. Tish works in a law office. She knows. Tish, do you agree with Amber? Am I wrong as well? The lawyer can only rely on the evidence presented and cannot ask the jury to consider any factors other than what was presented in court. I know this, but Tish, am I right that in closing you have more leeway than an opening, right? Can we agree on this? Everyone's volunteering for mod. I'm joking. I can't get rid of Amber. I can't. Ivan for mod, says Ivan. In all caps. I'm going to go ahead and delete that one. We don't do all caps here. Look at that. Ivan deleted your message. Just kidding. And look, Amber, all caps. We need to remove that one. Remove that message. I'm just being funny. You guys are great. I love my mods. They're absolutely amazing. Okay, here we go. Scott is right on this one. There's more leeway on the closing. No, because the opening of the case wasn't presented. Tammy says, just Google it. Opening statement, closing argument. Okay, all right. We'll let it be. I've taken enough loss today. Yes, I can agree with that, but not that much leeway. All right. Let's see, where are we at? Where are we at time wise? It's 11:58. We're supposed to be going back to court right now, so we're gonna get set right here. Let's see, how about this one? There we go. Oops, we need that guy right there. Let's see. No, the other way around. The opening, you're saying what the evidence will show, and then you show it or not. In closing, you can only say what was introduced in evidence. It's really hard watching a case on the other side of RA. He makes good points. Thank you, Jamie. Apparently, I make some wrong points as well. So I'm admitting my wrongfulness right now. I apologize for leading you all astray. But that's why we have great mods who can straighten me out. So Tish, Amber, thank you very much. All right, we're going to be coming back from court any second now. The break should be over. Boom! It's like I have the judges here.
Okay, so we're all back. So I guess the state has a brief rebuttal case, and so let's bring the jury in, please.
I'll take this call off air. Hang on. My text, my burner phone chat is full of screenshots of basically Googling closing arguments.
Please be seated, members of the jury.
So
Welcome
thank you.
back to court.
I stand corrected, everybody. Thank you very much.
Since this case is completed at this point, the state is going to be given an opportunity to present a case in rebuttal.
Yes, sir. State, thank you, Judge. The state's going to call Officer Danielle Malone.
She's back. She's back.
Yes. Please come forward through the gate, approach the deputy in front of the witness stand.
All right, here we go.
That's good right there. Turn and face the clerk. Raise your right hand.
Do you solemnly swear or affirm that the testimony you will give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Please have a seat on the witness stand.
May I proceed, Judge? Yes. Thank you, sir. Ms. Malone, good afternoon.
Good afternoon.
You're no longer an officer, right? So it's just Ms. Malone?
Yes, sir.
All right. Ms. Malone, I called you back to the stand on our rebuttal case. I want to ask you a few questions. Now, the night of November 17th of 2017, how were you employed at that time?
I was a detective with the Major Crimes Unit.
And were you dispatched to the hospital to conduct an investigation?
Yes, sir.
And what was the purpose in having you go to the hospital that night?
Was to meet with the victim, Paula Belmonte.
And the victim of what?
Of the robbery, murder.
And was this the same night that it had happened?
Yes, sir.
And what hospital did you report to?
Lower Keys Medical Center.
You remember about what time you went there that night?
It's probably around 10-ish.
I mean,
at night.
Clearly nighttime, right?
Yes, sir.
Were you able to make contact with Miss Belmont?
Yes, sir.
And were you able to ask her questions about what had just happened?
Yes, sir.
Judge, at this time, the state's
Christy, welcome to the gallery. It's wonderful to have you as a new member. Vlahakis? Vlahakis? I don't know how to say your last name. Christy, welcome.
Yeah.
Ooh, sidebar. Quick sidebar. This entire time, we've still had the image from Paula's depot up on the screen there. I'm not sure why. Okay. Quick sidebar talking about this. Mr. Tucker wanted to argue this as it came up. We're going to make sure it's played in entirety. I think it's the part after the questioning that he wants played. I wonder if it's just the police talking or something.
You went to the hospital that night. When you went to the hospital that night, did you have your body-worn camera on?
Yes, sir.
Right, and did it produce a video of your conversation with Ms. Belmont?
Yes, sir.
And did you have a chance to watch this video prior to coming to court today?
Yes, sir.
Does this video accurately and fairly depict that conversation?
From what it seems like, yes.
Did it appear to be altered or tampered with in any way?
No, sir.
Judge, at this time I would seek to move in our video here
which has been marked for identification.
Well, that is the video. We've been showing it already,
I don't know if
apparently.
it's been marked.
Something here, thumb drive for Paula Belmonte's Center Hospital.
Yes.
The clerk's like, I don't know what the evidence is.
They would seek to move in what's been marked as uniform into evidence.
Seriously?
Any objection?
What?
No, Your Honor.
Move. Yeah. Thank you.
You would, yes, you may do so. Okay. It's you for identifications admitted into evidence as the state's next in order number 19. It's going to be published. The defendant's going to position himself as he has done previously to be able to get a good vantage point as to it. And we want to be sure that, as always, you can see it and hear it.
Down in front.
Thank you, Judge. May I go ahead and publish?
Go ahead.
Describe the other person. I didn't really get a chance to see the other person.
Wait a minute, stop.
The other person was
Stop
smaller.
it. This is
Okay, slow, little like her. Could he have something real?
Okay.
The smaller guy? Yeah, something didn't look like a
This is the wrong video.
like something long and big.
She's currently getting treated.
So this
for
is
her
not
injury.
the portion or the one that you.
This is just a small segment of the overall video which we're going to.
They had agreed to play the whole thing.
Give us a moment here. Some technical difficulties.
I can't wash my hands because.
That looks like the right.
Hi. Huh? Your friend Todd? Took the notes. He was at the house. He's dead. Come in to see you. Not right now, okay? I know they kept going, nothing but this, that, I don't know. I'm here to talk to you, okay? I'm Danielle, okay? I need you to tell me about the person who did this, or the persons that did this.
Okay, I don't know the one that I do know, the one that was on top of me, the one in 70. He was living in Detroit. Big black guy.
When you say big, what do you mean by big?
Big, like you big. They told him that he was big.
Okay, stocky, muscular, fat?
Stocky, big.
Stocky, and taller than I am?
Yeah, he had
How much taller?
A little bit, but it was like so, yeah, about, yeah.
Okay, so about 6 foot?
He had been at the house earlier, and then we had I was there to play chess or something like that. I don't know, because I was upstairs. He's a friend of his, he play.
Okay.
And they, I kept saying she's going to have somebody come and beat me up, get me up, steal my life. But she kept saying this. She tried to have Kristen Dinklocker do it. She asked Melissa Davis to do it. Matt put 15-day notice on her door yesterday.
Okay.
But it was the one that brought him to the house originally. And last year, they say the same thing. She knows him. All they know is his nickname is Detroit.
His nickname's Detroit.
He's some kind of warehouse.
Okay.
He's a warehouse somewhere on Front Street, underneath.
On Front Street? Okay, is he black, white?
He's black.
How old is he?
In my age group, I'm 53, somewhere in that area.
In his 40s or 50s?
50s, something like that.
In his 50s?
Yeah.
Okay. Any scars, marks, tattoos?
I don't know that well. He's a close friend, not mine.
Okay, but you've seen him. Did you, any scars or tattoos?
Nothing where, no.
Okay. What kind of clothes was he wearing?
Black dark shirts and dark sweatshirt, dark, like this in the dark.
Okay.
So he's had some kind of mask up, but I knew it wasn't maybe because of that. Okay. I didn't see well in the dark. It was not to me. I think you just see him. I mean, I couldn't tell the person was even masked because I was in the dark, but I knew exactly who it was. It was him. Okay. Well, describe the other person. And when he gets a chance to see that person, he was on top of me. The other person was smaller, little, small, little like her. He had something real big in his hand. The smaller guy? Something just looked like that. Big, like something long, big. I had something I don't know. It was about this long. Okay, was he white, black, Hispanic, male or female? Black. And he was all dark on me too. And that was a male? Yes. Okay, so a smaller black male. How old was he? I don't know. But I can tell you that Detroit and then downstairs in Matt's house, and I see his fingerprints out of the window. Okay. Just he hung out there and they put that. Okay, the other person. How old was he? I don't know. He was completely drunk. Like I had a 200-pound man on top of me, and I was just catching glimpses. Roger is the one people would ask about that. Roger left, he doesn't believe somewhere. Roger Luggett. That's the one that. Roger Luggett? Rugged? Rugged. R-U-G-G-I-T-T. He's the one that got beat up by the other guy.
Now, Miss Malone, she said I had a 200-pound man on top of me, and I was catching glimpses. Who was she referring to when she said glimpses?
The second person.
She was only catching glimpses of the second person.
Yes, sir.
Okay. And he lives in the city? Roger lives in the city? He works at T-Bus golf course. And at this time, he's probably staying there. He's the maker. He's the Lord of God. Okay. I know you'll come to me and smoke a cigarette and I'm really like How old's Roger? He's 65. Do you know where Roger would have gone and why he wanted to escape? Well, he was scared to death, like the rest of his work. The other person, another guy named Roosevelt Washington, he ran away. They were all downstairs, the upstairs. Roosevelt, everything's over hangs out with that, and drinks beer, plays tests and stuff. Is Roosevelt white, black, or Hispanic guy? And he said his name's Roosevelt Washington. Where does he live at? Okay.
She's literally having a wound cleaned out while she testifies here.
I honestly, I don't know. Talking with the stairs, he said that he stopped, so he tried to stop the guy, stabbed bed, and I got stabbed in the end. So, where were you when this all started? Upstairs when I stayed upstairs. Okay, where was Matt? The student downstairs. Okay. I can't see him on this house now. He's upstairs and I can't see him. Okay. Upstairs I think he's doing the floor.
So explain to me exactly what happened, okay?
I keep running up the stairs. I could hear something coming up. I turned around and I knew it was coming. Started becoming saying, "Where's your purse? Where's your purse? Where's your purse?"
Okay. Did he get your purse? Okay, describe your purse for me, okay?
Well, I think I would like that too. Then we change the purse. He can't stop doing this.
Okay.
And that is black. And I see the other guy looked up, like I said, I couldn't forget necessarily about this. And then I do the one guy, it's this guy named Dr. Troy. I came in downstairs and I was like, you know, with us.
What about the other guy? Have you ever seen him before?
So that's what I don't know.
I
basically had an asshole. And I could barely see him because I had a 200-pound gorilla on top of me being suit on him. I have no clue about the second guy. None.
I have no clue about the second guy. None.
Say more. This other one kept talking. That's it. Another reason why I would they're going to kill you. You know, he's going to kill you, but you can first.
She said I had a 200-pound gorilla on me. Who was she talking about?
Rory Wilson.
Did that affect her ability to see the other person?
Yeah, she said she could only catch glimpses.
Anything else in there? What about in your backpack?
My wallet, everything. It's got my ID in it, and I was supposed to fly home for Christmas.
Wallet, her ID, and her backpack.
I had some jewelry in my
She was supposed to fly on Christmas. She had some jewelry in there.
The keys, so we found the keys down the road there. You probably told me you got the keys.
Where down the road? Which way down the road? Who found your keys?
I was with my old boyfriend and I called and asked him if he ever tell me. When the people took off in the car, I heard a car start. Heard a car start. You go
Then
back.
where, does Detroit have a car?
Organic meat, everything I can really know about this guy. I don't really know. All that I was used to kidding.
Okay, so you heard a car start. What did the car sound like?
It was so like a car. It just sounded like a car. It wasn't opening down or anything. It just started car start. That was all. It might not even meant nurses. It might have been something coming from CVS. In my mind, it was they went down the steps and then I heard a car.
Might have been the car at CVS, she says.
Okay, I'm going to give you a break, okay? They're going to clean you up and I'm going to be back, okay?
The back, I don't.
Listen.
Okay,
Listen. I know you're upset. But you want us to catch the person who did this to your friend, right? I understand that, and you've been very helpful, okay? Just while they're cleaning you up, just and see if you can think of anything, okay? Okay. We're going to do all of that, but
and it's the egg/egg flame. Those also, no, see, you said before, it is some kind of warehouse.
Okay, and you think it's on Front Street?
I think it's Front Street. But is there any warehouse on Front Street?
Honestly, I haven't worked on South Island in a very long time, so I don't know. Okay? Can you describe it tonight?
It's to me, I think it's only about that long.
Okay.
It was short.
Okay.
Okay, is that pretty much the totality of your discussion with her about her ability to identify the second attacker?
Yes, sir.
fix the audio here.
The state is going to. Ms. Malone, I have nothing further for you, ma'am. Thank you very much.
All right, thank you, sir.
Cross.
Yes, cross-examination.
We're ending the poll on Tucker's believability while he was on the stand.
I move it a little bit this way, Your Honor.
67% say yes, he was believable.
Okay, Ms. Malone, we had a little question and answer before, but I'm going to just ask you a few questions about this video. You said Paula looked upset in that video, didn't you?
Yes, sir.
Okay. And this is directly after the crime, right?
Yes, sir.
Okay, so she's down in the ER, correct?
Yes, sir.
You know if they gave her any medications?
I wouldn't know that, sir.
Okay. So you don't know if she's lucid at this point?
Appeared lucid to me.
Okay. Now, you say she appeared lucid. How many times did she say the name Anthea Clay in that video?
I didn't count.
Okay. Did you testify previously that Anthea Clay was never rise to the level of a suspect?
Correct.
Okay. Did you go and interview Miss Anthea Clay after this?
I did not, no, sir.
Okay. Did anybody?
I believe they did. I don't know who, though.
Okay. Do you remember, again, the first interview video that was done with Anthea Clay?
I wasn't there.
Okay. I think you testified previously that it was how long afterwards?
I believe they met with her that night.
No, the video, the interview video. You said, if I remember correctly, you testified that it was almost 2 years later.
That they conducted a full interview? Yes.
Okay. Was she arrested?
No,
Okay. Why not?
because she never rose to the level of a murder suspect.
Again, Ms. Malone. Paula, what did she say in that video? Did she say over and over again, this was Anthea Clay? She set this up.
I believe she said that once, and then she stated over repeatedly to talk to Anthea Clay because she knew Detroit.
Actually brought Detroit to the Treehouse, correct?
I don't recall them exact words.
We can play it again if we need to.
I just don't recall them exact words.
Okay. And if you wouldn't mind, Your Honor, can I go up and, hit the video for a second? There's a couple things I'd like to clarify.
Okay.
Thank you.
Judge, objection. That's not what she said. She
Yeah,
said she
I will
didn't.
just, wait, okay, I will just sustain the objection as to.
How many times do you think she said it?
Objection asked and answered.
No, I'll overrule that objection.
How many times she said the name Anthea Clay?
No, the Anthea Clay did this. Anthea Clay set this up, something to that effect.
I recall one time.
Now, I want you to listen to this part, if you wouldn't mind. What did she just say there?
She asked me if her friend was dead.
She said her friend's dead, right? Agree? Her friend's dead, right? Now, if you listen to this, tell me what she says in a second.
Who called you? Your friend Todd? Defendant. He was at the house. Okay. Dead. He's dead.
What did she just say there?
He's dead?
Did she just say, my friend Todd, he's at the house, he's dead? What would that make it sound like?
I don't understand.
Well, you watch that little video clip right there. Did she just say, he's at the house, he's my friend, Todd is at the house, he's my friend, he's dead? Something about that.
Yes, sir.
Okay. Would that make it sound like she's saying that Todd is dead at the house?
I didn't believe that at the time, no.
I didn't say I didn't ask you if you believed it, but I said, would it make it sound like it?
Judge, I'm going to object. The video speaks for itself.
Well, I'll overrule the objection. Is that what you heard?
No, sir, that's not what I heard. That's not what I heard.
So let me replay it.
You can replay it, but that's not what I heard.
Let's check it again. Maybe I'm.
Who called you?
My friend Todd.
Your friend Todd?
To the house.
He was at the house? Okay.
He's dead. He's dead.
Yeah. What she just said.
She said that her friend Todd called her and told her that her friend was dead.
Kept on saying he's dead after she said that Todd was at the house, correct?
Yeah, she said Todd was at the house and that he's dead in a form of a question.
I don't know about the form of the question. I wouldn't say that exactly, but okay. Again, we can agree that this could be confusing, correct?
It was not confusing to me.
Asked and answered. We've covered it.
I'm asking if it was confusing to you, right?
Okay, I'll overrule the objection. What's the question?
This is a different judge today.
Got to that part. Okay. And the whole Anthea play. Let's go to this.
Say big one.
You can jump ahead. Jump ahead. Let's not go too far.
Okay, Mr. Tucker, having a hard time hearing you, the court reporter, so let's...
Thank you, sir. Okay. Now, Ms. Malone, at the time you were a homicide detective, correct?
Yes, sir.
Hi. Who called you? Your friend Todd?
To the house.
He was at the house?
He's
Okay.
dead. He's dead. Can I see him?
Never know.
I know they jumped on him and knocked him in his bed. I'm saying they stabbed him too.
I don't know. I'm here to talk to you. Okay? I'm Danielle. Okay? I need you to tell me about the person who did this, or the persons that did this.
Okay, I don't know the one. The one that I do know, the one who's on top of me, the one that's stabbing. He goes living in Detroit. Big black guy.
When you say big, what do you mean by big?
Big, like you, big.
And who's Detroit?
Rory Wilson.
Thank you.
They told him that he was big.
Okay, stocky, muscular, fat?
Stocky, big.
Stocky, and taller than I am?
Yeah, he had
How much taller? All right.
Maybe not this much tall. Yeah, yeah.
Okay, so about 6 foot?
He had been at the house earlier, and he had been downstairs playing chess or something. That I don't know because I'm so scared. He's excited as he play.
Okay.
He had his bed. I kept saying he was going to have somebody come and beat me up, steal my money.
Sorry about that. Having a little trouble here. Okay.
Okay, stop.
What'd she just say there?
She said Anthea Clay, and that Anthea Clay was trying to get somebody to beat her up.
And steal her money.
I believe so, yes.
Okay. And how many times did she say Anthea Clay right there?
The name, I believe, 3 times.
Okay, 3 times.
He's muscular, fat,
stocky,
and taller than I am?
Yeah, he had
How much taller? All right.
maybe not this much tall. Yeah.
Okay, so about 6 foot?
He had been at the house earlier, and he had been downstairs playing chess or something. That I don't know because I was upstairs. He's excited as he play.
Okay.
Yeah, his bed. I kept saying she was going to have somebody come and beat me up, steal my money. She kept saying that she tried to have Crystal Dinklocker do it.
What'd she just say there?
She tried to have Crystal Dinklocker do it.
Okay.
I'm sorry.
Did she just say somebody else? She tried to have somebody else do it?
I believe so. I believe Melissa something.
That with the 15
Judge Omer, can we come sidebar?
Yes.
So, state's not liking this because they're just replaying it all and having her spell through it. But this was their rebuttal testimony. Why would they not want this played again if this is their rebuttal testimony? I will say this judge is different from today. He is different from everything every other time I've seen him on this case. And I would say he's different from when he went to go reflect. Whatever reflection he did, he is a changed man. And I would not put it past him right now to grant a judgment of acquittal. The bailiff is making a charcuterie board for the judge. Little snacks, little finger food, maybe. Keep the energy up. Keep the water flowing. This backfired on the state. Doesn't seem like a thorough investigator. Dr. Sue, this woman was a detective, and she got a letter of recommendation that recommended, not for her success, but recommended that she no longer be a detective. And not because of that, but at the same time as that, she decided to no longer be a detective.
Thank you.
And she went into, I believe she's in dispatch now.
Just said?
April's the one that brought him to the house originally.
Okay.
And April's Anethea Clay. That's her street name.
Tucker won that objection. It was overruled. That's like 5 in a row.
She knows him. All they know is his nickname's Detroit. His nickname's Detroit. He's from the warehouse.
So she just said she knows him, right? She knows Roy Wilson. Detroit.
Yes, she knows Detroit.
Okay.
Okay. Warehouse somewhere on Front Street, I believe.
On Front Street? Okay, is he black, white?
Black.
How old is he?
And my age group, I'm 53, somewhere in that area.
In his 40s or 50s?
Something like that.
In his 50s? Okay. Any scars, marks, tattoos?
Interesting that she's not watching the video. She's looking at the state, the prosecutors.
April Clay again. She just said.
That he's April's friend?
Yeah, April's friend, right?
Yes, sir.
Okay.
Okay, but you've seen him. Did you, any scars or tattoos?
Nothing I'm aware of, no.
Okay. What kind of clothes was he wearing?
Black boots, the top shoes he wearing, and one three yellow shorts, dark shorts and dark sweatshirt, dark, like that, like this in the dark.
Okay.
So he's had some kind of knife, but I didn't know what it was, maybe he came up there.
Okay.
Well, I didn't see well in the dark, that's before he got to me. I think he just, I don't know, because I couldn't tell the person was even masked because I was in the dark, but I know exactly who it was. It was him.
Okay. Well, we'll describe the other person.
Thank you.
I didn't really get a chance to see that person. He was on top of me. The other person was smaller and littler. Okay, smaller and littler like her. He had something real big in his hand.
The smaller guy?
Yeah, something that didn't look like a knife, but it was big, like something long.
Didn't look like a knife. It was real big. The small guy had something in his hand.
No. She testified. I'm sorry. Did she just say that the smaller guy had something big in his hands?
Yes.
And again, we just heard how many times with April, and I lost count. How many times? April and Anethea Clay?
I didn't exactly keep count, but about 5 times she said her name.
Multiple times, right?
Yes.
She knows him. Friend brought him to the treehouse. She set this up. I'm asking. Is that what she said in there?
About Anethea Clay?
Yes.
Yes.
Okay. Again, Ms. Malone, and you say, again, did anybody go and talk to Anethea Clay?
Objection asked and answered.
I'm going to sustain that
Okay.
objection. That's
Okay. Was Anethea Clay ever brought down to the station that night?
Objection asked and answered.
I haven't.
I'll
think I've asked that.
overrule that objection. You can answer the question, ma'am.
To headquarters? Not to my knowledge.
Okay. And again, she says that Anthea Clay is a friend of Rory Wilson. Did you know where Rory Wilson was that night?
At that time?
At that time?
I did not know.
You didn't know. Okay. And again, did you know where Anthea Clay was that night?
Me personally, no, I did not.
Did anybody else?
Somebody talked to her that night, yes.
Somebody talked to her that night. Okay. And, but she wasn't brought down to the station, right?
Not to my knowledge.
Okay. And again, how many times does she mention the name Detroit in this video?
I didn't count, but it was quite a few.
Quite a few, right? Would you say it was more? That she said April Anthea Clay more, or that she said Detroit more?
Probably about equal.
About equal. But Rory Wilson is a suspect at this point, right?
Yes.
Okay. Again, I would ask, with your experiences, that you were experienced homicide detective at this point, correct?
I don't understand what you're asking.
I'm asking, okay. What? You testified earlier, based on your experience and training, that your knowledge of homicide, being a homicide detective, correct?
I believe I stated my training and knowledge of the case.
Okay.
She's saying she's
well,
not
I'm asking you, how
experienced.
long were you a homicide detective for the MCSO?
Judge, objection beyond the scope of my direction.
Yeah, I'm going to sustain that objection.
Again, I will go back. Ms. Malone, again, so Rory Wilson becomes a suspect. Why did you not want to ask Anthea Clay? Why didn't she become a suspect at this point?
Objection, Judge. Asked and answered.
We'll do it one more time. You can answer the question, ma'am.
Rory Wilson was a suspect because Paula identified Rory Wilson as the man that was beating her and held a knife to her throat.
Okay.
That wasn't the question.
I literally, again, she became he became a suspect because she said, I'm just clarifying here, she said that he beat her and put a knife to her throat, right?
Yes, sir.
Got it right. Okay, and did she just say that Anthea Clay did this? She'd been trying to set her up and have her beat up and have her money stolen from her.
Objection. Asked and answered already.
I'll overrule the objection. Didn't she basically say that? You can answer the question.
Yes.
Okay.
Okay, so why would Anthea Clay not rise to the level of a suspect?
Because she was a person of interest and possibly setting this up, nobody else put her in the crime.
Okay. Did anybody else put her in the crime later?
A CI eventually did, yes.
Okay. And do you know when that was?
I'm not certain on the date.
Okay. Anyway, was Miss Anthea Clay ever arrested for this crime?
No.
And if I remember correctly, you said Miss Anthea Clay is deceased at this point, correct?
Yes.
Okay. Do you know what killed her? Well, I shouldn't say. I should rephrase that anyway, because again, do you know how she died?
I do not.
Okay, thank you. I have no further questions, John.
All right. Thank you. Is there any redirect examination?
Ms. Malone, to your knowledge, during this investigation, was there ever enough evidence obtained with which to charge Anthea Clay with being involved in this crime?
No, there was not.
During this investigation, was there enough evidence obtained to charge this defendant with the crime?
Yes, there was.
Nothing further, Judge.
All right. So you may step down, ma'am.
Thank you.
And now we're done. Now the jury gets dismissed. Tomorrow we're going to have closings, where there is a little bit to do here today with outside the presence of the jury.
Anything else?
We're going to handle
Yes,
the
sir.
jury
The
instructions.
state at this point is going to seek to read out to the jury certain portions of a deposition by Paula Belmont given on May 1st of 2019. She was sworn in at that time, swore to tell the truth, and her statements were made under oath to be truthful, and the state has certain portions of that deposition that we feel are relevant for rebuttal.
Just for the jury's understanding, you saw this person's deposition to perpetuate yesterday. Right? That was video and audio tape. This is a separate deposition, but again, it was under oath. There were questions, there was a court reporter, and there was a transcript made. It was under oath. So now counsel's being given an opportunity to read certain portions of that deposition for rebuttal purposes.
Let's hear Howie. Let's hear his reading voice.
This deposition was May of 2019.
He's facing the jury. Like it's closing
Questions
arguments.
being proffered to Paula Belmont, May of 2019. Yeah, in dark clothing, I don't remember. It's been a year and a half at least.
That was an answer.
Question, I understand, but you immediately recognized him when he approached you. Answer, oh yeah. Question, is he the one that stabbed you? Is that right? I won't say stabbed, he cut my neck. Question, he sliced your throat? Yes, my neck. Question, and you're sure it was Rory Wilson? Answer, absolutely, without a doubt. Who else did you see there that night? No one that I can identify. Do you know Ty Tucker? I know him, yes. And you did not see Ty? Not that I can identify. I saw another person, but I can't identify him. Question, can you describe the other person that you saw? Answer, no, because I had Rory Wilson on top of me, pounding the hell out of me. Question, did Rory ever go down the stairs? Answer, they both. The first person went down the stairs and then Rory went right behind him, attacking Matt. The first person was getting Matt from one end, the second person was getting Matt from the other end. Question, and you saw two people, Rory and the other person attacking Matt from behind? Answer, yes, one was in front and one was in the back. Question, and you said initially that you believed that the second person had a billy club. Answer, I think it was Rory. I think it was Rory. Question, you think Rory stabbed Matthew Bonnet? I didn't say that. You just said billy club. That had nothing to do with Rory stabbing Matt Bonnet. Then the question, let me go back. I want to make sure I completely understand your answer. Who had the billy club? Ms. Belmont's answer, I believe it was Rory. Rory had the billy club. Question, did you see any other weapons? Answer, no, I can't. I don't remember. I know at one point a small knife fell. I know at one point that other stick fell, and I believe that is when Roger got it. But you are talking a year and a half ago, and they are memories that I try and hide, so I can't answer that honestly. Question, did you see the second person with any weapons? Answer, I didn't know. I couldn't see the second person until they were going down the steps because I had Rory Wilson on top of me beating the shit out of me. But you said you saw Rory and the second person attacking Matthew Bonnet. Yes.
Mr. Mansfield, I think it would probably be good for the record if we just identified page and lines.
Okay, Judge, that's fine.
So like you started with, you go ahead and
that's fine, Judge. Let me just back up then. So what the state has referred to in the deposition is page 13 and page 14
Page
so far.
13, lines 1 through 25.
Correct. And page 14, lines 1 through 25.
All right. Now what's next?
The next one we're going to go to is page 16, line 13. David, can you give me some water?
Need some more water. I don't have a Butler Baylor to bring me water.
I'm sorry, just page 16, line 13. Do you remember what the second person was wearing? Answer, I couldn't see the second person hardly at all, except he was a littler person. Dark clothing, and it was the second person that said, thank you, David. Dark clothing, and it was the second person that said, I think we killed him.
Thank you, David.
Question, so you heard this second person speak? Yes, I think we killed him is what I heard him say. Now, Judge, I'm going to move to page 18, line 1. Who told you that Ty had something to do with it? Answer, nobody told me. Question, the police didn't tell you that? Answer, no. Well, afterwards, when they arrested him, yes. Okay. Ms. Belmont continues, not when I was having lunch with him at McDonald's, or I would have been nowhere near him. Question, are you sure that he was involved? Answer, what kind of question is that? I had told you I can't identify him. That person was wearing a mask. I wasn't the one who identified him. So the only reason you believe he was involved is because other people have told you that he was, because the police, and she says, answer, because the police arrested him. Okay, are you aware of whether or not any of his physical evidence was found at the scene? Answer, I don't know anything about that. All I know is the police arrested him. Then she goes on to say, actually, he himself told me that when we were at McDonald's, he himself told me, oh, the police had found a knife with blood on it, because I said to him, oh, good, it would be my blood. And he said, no, it's Matt's. This is Paula still speaking, whether that was true or not, I don't know. But he himself told me that while we were sitting at McDonald's, that the knife that the police found had Matt's blood.
This is really improper reading.
Through line 25 on page 18.
Yes, sir, that's correct. The next page I'm referring to is page 19, line 1. And it picks up from where the previous page left off. So he himself told me that while we were sitting at McDonald's, that the knife that the police found had Matt's blood on it. That's what he said. And the question, and you hugged him at McDonald's? Her answer, yes. I was upset, crying because of what Roy did, not knowing, like I said, not knowing that Ty Tucker had anything to do with it, because I can't identify him as being there one way or the other. That was Paula's response. I can't identify him as being there one way or the other. That line 7 on page 19. The next section that I'll be referring to is page 38, Judge, line 2. Paula's answer to a previous question. There was a scuffle between them, and Roger got thrown into a tarp. I don't believe I said he was beating him. I was the one getting beat, but there was a scuffle between those two, the other person and Roger. And the question, and you saw the second person holding a knife to Roger's throat? Answer, no, ma'am. You did not see that? No, ma'am. You were told that? I was told that by Roger. That is why Roger wasn't helping me. And Roger was the one who told you that the other man had a knife to his throat? Yes, ma'am. But you never saw that? No, ma'am. I couldn't see past Rory Wilson because he was on top of me, beating me for the third time, I have told you.
That's through line 25 on
Yes,
that
sir.
page 38.
Next page, page 54, line 14. The second person this is the question. The second person that you can't identify, do you know whether or not that person was white or black? Answer, I couldn't tell you. Question, okay, only that the person was smaller than Rory Wilson? Answer, yes. And you believe it was a male? Answer, it was a male. And you heard his voice? Answer, yes. Question, but the voice did not sound familiar to you? No, but it wasn't Rory Wilson's voice.
That was through line 25 on page 54.
I'm curious how Tucker gets to cross
Page
this
57,
testimony.
line 18. I may have asked you this. The second person that you can't identify that was there, do you remember what that person was wearing? Answer, dark clothing and a mask. Answer, yes. I'm sorry, dark clothing and a mask. Question, did Rory Wilson have on a mask? Answer, yes. Were the masks the same? I don't know. I didn't get to see the second person. That was line 25, page 57. Moving to page 58, line 1. But you said he was wearing a mask. Answer, yeah. Question, did you see the person? Answer, from the back when he was leaving, his darkness. What kind of mask was it? I don't know. It was dark. The mask was dark, like a hoodie mask, the back of it. I can't tell you anything about it other than that. Those are the statements, Judge, from the deposition given on May of 19 that the state published for purposes of rebuttal.
And now, I believe under the law, the person whose testimony you are
Anything further by way of rebuttal?
No, sir.
Rebutting should have the ability
Members
to
of the jury, we've reached one of those points in time where I have to conduct a little bit of business outside of your hearing. If you wouldn't mind going in the jury room for a few minutes, I'd appreciate it.
Now we get a JOA. It's like the judge got a phone call on a break, and the phone call says, "This needs to go away today. This needs to stop. Too many questions." The change I've seen in here is like night and day. Now he's going to suggest to Tucker that it's time for this motion. Let's see if he does that.
All right, they're gone. So, just want to get an idea of how the rest of the day is going to unfold here. It's 3:50, so has Mr. Tucker received a copy of proposed jury instructions?
I have, Your Honor. I haven't had a chance to peruse it yet.
I have a packet for the court as well, if you would like it now.
It's all right. I'll get it, but it doesn't have to be right at the moment.
Just let me know.
I'm just trying to gauge whether we're going to be able to do the charge conference this afternoon, which is what I proposed, and ascertain whether Mr. Tucker is ready to address that.
Well, Your Honor, I thought first that we were going to do a renewed motion to.
Well, we are.
Okay.
We are, but, none of it involves the jury, so I thought I would kind of figure out what time to tell them to be here tomorrow and hopefully be more accurate than I have in the past day or so. So what that I have to calculate is, how long it's going to take to do a charge conference. If it's going to be contested to any great extent, it's going to take longer than if it's fairly agreed to, fairly well agreed to. So
I would like a chance to go ahead and.
I'm sorry. Could you speak up, please?
I'm sorry. Can you do this?
You would like to have a chance?
Yeah, no, I'd like to have a chance to go ahead and review that so I can, get with my advisors and try and figure out what I want to do with that.
So that means to me that you do not want to go to a charge conference.
Not this afternoon, if it's all possible, Your Honor. I would imagine if we could go to it tomorrow, that would be great.
May I see now the proposals, please?
Commissioner Butcher.
Yes.
JOA is coming. I think it's going to be denied. It's been denied once before. But
pretty thick packet.
That's what I felt.
But that doesn't mean it's complicated. But it is a thick packet.
Yeah, just so the court's aware, I know that some judges, every time they reach some type of homicide or some type of manslaughter charge, they like to read the introduction to homicide. I don't know anything about the court would do it. I'll leave that to the court's discretion in this matter. But I did include it various times in there every time we address either manslaughter or second-degree murder or felony murder rules. So that might make
he included the definitions of manslaughter, homicide, everything, every time it's mentioned. Lots of footnotes in this one. We can delete all those duplicate pages.
So again,
Judgment of acquittal. It's where the judge says there's no evidence, we're throwing the case out.
Your Honor, I'm definitely going to need time with this just because, okay, I'm looking at it, and yes, I understand you're trying to explain the concepts of some of these things, but my name is used in it over and over and over again in association with crimes I'm not even charged with.
Well, it's the norm that the defendant's name appears in jury instructions repeatedly. There's nothing extraordinary about that. But I will give you the overnight to review it and prepare. I prefer not to, but I recognize that it's relatively late in the day, and it's in a somewhat complicated.
It looks pretty extensive to you.
Well, most of these are standard jury instructions, but there are, there's various questions. Like lesser includeds. I don't know if you're requesting any lesser includeds. And if the state is, so that's an issue. A lot of this stuff is pretty standard. Now I'm looking at the robbery instruction. It looks like it's almost in a different format than some of the others. I don't know why we've got all these italicized portions in that, but that's stuff we can work through.
Because they copied and pasted.
Challenge is, in my experience, you go through a charge conference and almost inevitably there's changes that have to be made. It's just almost, unless you have an agreed set of instructions, then there's changes that have to be made. So then I'm just curious, and we don't have to answer this question now, but just food for thought here. Okay, and you do have some interrogatory verdict form for with the weapon and the like, so you did address that point. Yes, all right, so we're going to do the charge conference tomorrow, but then we're going to go into closings. I don't like to, have the jurors start deliberating too late in the day. So that means I'd like to, have a focused charge conference. So we can deal with the motion for judgment acquittal this afternoon. So, and presumably, if there's changes, the state has the capability of getting those made fairly expeditiously.
Yeah, sure. I don't know why he's stalling here.
Then in terms of, again, I'm just thinking out loud here, trying to plan.
You heard me.
Closing arguments, I'm not going to hold you to it today. I just want to get an idea so I know what to tell the jurors is how much time would you be thinking both of.
I can't imagine Tucker uses more than an hour.
So I'm guessing like maybe an hour, hour and a half.
That's a pretty broad range. What was your thought?
It's a broad range.
I was thinking around an hour, Your Honor.
There we go. An hour for Tucker.
Well,
it's about how long he testified. He's basically going to rehash that story.
Hour and a half. That's certainly an hour. I mean, an hour and a half. But it's been a long trial. There's a lot of evidence. We can hone it down, but we'll. So that tells me if I tell the jurors to come at 10, that means we have to be here at 9 and ready for business, which I would think an hour for a charge conference should be adequate.
Watch Tucker come with a motion to disqualify tomorrow.
To be here at 10 o'clock and
throws off the whole schedule.
Do your homework tonight. I mean, again, you can review them with whoever you'd like to. I would imagine a lot of these are fairly standard, right out of Florida standard jury instructions, but there could be always questions. So anyway, I'm going to tell them 10 a.m. Please ask them to join us. Yes.
Bring them back out. Bring the jury. Okay, so the judge did a lot of musing out loud there about the schedule. Man, this is... Tucker has an hour for closings. Defense takes an hour, hour and a half for closings. By lunchtime tomorrow, we should be in deliberations. Well, I don't know. Jury instructions might be another half hour, maybe 45 minutes for jury instructions. As long as the charge conference goes quickly, and they can keep that to an hour in the morning.
Thank you. Please be seated. Everybody, welcome back, members of the jury. Again, we all appreciate your flexibility, your patience, your attention, participation. We're going to call it a day for the jurors. We're going to remain here, but there's nothing more for you to do this afternoon. The evidentiary portion of the trial is completed, and tomorrow I would anticipate going into closing arguments and final instructions and deliberations. So we'll probably need to do, myself and lawyers, defendant, some work tomorrow morning. So if you be here at 10 o'clock, that would be great. Continuing to follow the cautionary instructions, and have a good evening, and 10 o'clock tomorrow.
Jurors get out 4 o'clock sharp. As soon as that door closes, the next thing to be handled is the JOA.
All right, so the jurors are gone. So before we have the argument, did you need a few minutes, or are you ready to?
No, I think I could use a few minutes, Your Honor, just a few.
Excuse me?
I could use a few minutes, Your Honor.
Okay. But before we take a break, Ms. Knowles, to her credit, is very meticulous and careful when it comes to the exhibits, and she's concerned, as am I, as to exactly, are there other videos on this last, I don't know if that was the last exhibit for the state. I think it was the video. Are there other, what's the number?
20. Should be 20.
I mean,
I think there are 2 other videos on it, Judge, so we're going to have to transfer that to a single thumb drive in order for it to go in.
well,
that's your job.
That
Can
would
we just
be.
delete the other? Actually, somebody much smarter about these things is sitting right here, and she said she can delete the other files and just leave the video that we played for the jury on that thumb drive.
What? You can delete files off a thumb drive?
It's just that one video.
This
Right,
changes
that's
everything.
What we don't want is, otherwise the only other option we would have, which is not a great option, is to not have it go back into the jury room, and then if they want to see it, tell them they got to come out here while somebody controls it. Whereas if someone who is knowledgeable about these things is able to delete the portions that weren't published, and then the defense can view it, or whatever assurance is necessary, if there is any needed, that it's just what was played, no more, no less. That would solve that concern.
Okay.
So, all right, so what if 4:20, 4:15, what do you want?
4:15 would be fine with me.
All right.
We got a 12-minute break. Judge is up. We are going to do a poll here. I think we're to the point where we can do a poll as far as guilt and innocence goes, because we've heard all the evidence that will be admitted in this case. So as far as the wording on the poll, how would you vote as a juror? Okay, so we're going to have always not guilty comes first, because there's a presumption of innocence, and we'd like to enforce that. Not guilty. Guilty. We're going to treat all these crimes together, because basically if he was there, the law would say he was guilty of all of them. Guilty, not guilty, We're going to put the not proven on here. This is the Scottish form, right? Guilty, and not proven. Is there anything else that we need? I think that's it. All right, polls up. It says, how would you vote as a juror? Not guilt. I spelled it wrong. Not guilt, guilty, and not proven. Yeah, the votes are flying in right now, so we're going to give that just a little bit. Hung jury is a possibility, but each juror is going to vote one way or another. It would be hung by one person saying guilty and the other person saying not guilty, or some combination of that. Okay, a couple of you are saying, I just came in, what did I miss? The whole day is worthy of rewatch. We have not always had days that are worthy of rewatch like that, but this whole day has been spectacular exhibit of how to or how not to conduct court. Scottish version is a mess. Guilt not, that is the question is, says Hank. Yes, that's like a Yoda format. Thanks, Karen. Hell to everyone. Thank you. Appreciate that. That's our new slogan on the channel. If you don't get that joke, you have to watch a couple days ago. It was really funny. Let's see. Close but no cigar. That's not it's not something you can vote. No evidence, in my opinion, says under your scars. Not guilty, says Karen. Y'all have underestimated how slimy the jury finds this defense. A possibility. They might not relate to him at all. The other hand, this is a jury of his peers, Key West. I'm just saying they might also be sitting there still shaking their head saying, I cannot believe this district attorney doesn't know what Fireball is. We could have some people that are like, yeah, this guy's speaking my language. There's a clock, but not on camera in the courtroom. All right, I think we've got enough votes in. I think. Let's see what we've got. We've got 759 votes. If you're not one of them, I'll give you just a minute longer to cast your vote. 768, 769, 770. So what is that? About a fourth of you have voted. 782. It seems like a normal election. I think it's actually a little higher than normal. As soon as we hit about 800, I think we'll be done. 796, 804. Okay, we're good. All right, we're going to close it out right now. Oh, votes are still coming in, so I realize people are in the ballot. The ballot boxes are at the ballot boxes as we speak. Braxton Heap says, I told you there'd be fireworks. Braxton, thank you. Today was definitely a fireworks day for sure. 840 votes. I have to realize there are some people who are behind on the audio, so we'll give them a minute to vote.
Call from.
In the ballot box.
Hey, this is RA, but you've got your volume too loud. I can't hear who this is. Who am I speaking to? Hello?
Hey, it's Pam in Blairsville.
Pam, can you turn off your TV so we can hear? Because it'll be really confusing.
Okay.
There you go. Pam, what is on your mind today?
Hey. Okay, so I'm Vince from your cast, and I'm a big fan of Brandy, and I just want to let you know that you are amazing. And I just got off work.
Hang on. Can I record this? Oh, just kidding. Go ahead.
What?
Keep going.
What? Oh, yes, you can.
It's already it's preserved forever. But
okay, so yeah, been taking care of my mom and dad and working, and I watch your stream and Brandy, and I cried with her last night when she hit 15.
Oh, that was amazing.
So. Yes, I just want to say that you guys rock, and I'm a true crime. I so love these court cases, and I just want to say that I'm so thankful for you.
Well, thanks for the kind words. I don't think they're always deserved, but I appreciate you saying the nice things anyway. I think the community here is what makes this environment so amazing. You can find the content anywhere, but the community is just is unique, and that's because of you.
Yes.
So thank you very much. I appreciate that.
So I do you and Brandy, And Julie, I love her. I watched her from Popcorn Planet with Andy.
All right.
And I followed her to your channel.
Wonderful. That is awesome.
Oh, okay.
Well, thank you
Have
very
a good
much.
night.
Nice talking to you. Thank you very much. We'll see you.
You're welcome.
Bye.
Bye.
Thank you, Braxton, for the super chat. Also, we got one from Under Your Scars. Says, no proof. It's crazy to me. Thanks for your coverage. It is crazy. There's so little evidence. It's not funny that they are literally using the lack of evidence as evidence in this case. They're saying she couldn't identify. So there he was. Could have been him. She couldn't identify who it was. Look, there was an unknown male. There was an unknown profile in the DNA. Could have been anybody. Literally, could have been anybody on Earth. And like that proves that it must have been Tyrone. It's absurd. John Davenport says, I wonder if someone above the judge scolded and talked to the judge. Something happened. Something happened. I'm not sure if just, well, I'm not going to make any speculations, but something happened, and this judge is a different person today. Britt Bottoms, thank you for the super chat. Thank you for being a member. Love that Blue Courthouse by your name. Appreciate that. Thank you for your support. Let's see. We have, I think the judge got a call from higher ups about his behavior. There's got to be something. Britt Bottoms, by the way, that is your first ever super chat on a live stream. Thank you. I appreciate that. And your hair reminds me of Emily D. Baker. I just thought I'd say that as well, which is a good thing. That's a compliment. She's amazing. Lack of evidence equals reasonable doubt. Let's see. AES says, yeah, I left this morning, came back like an hour ago. It was like the judge was a whole new judge. It was very different. Very, very different. Wow. It was, if you look at all the other days, the judge was frustrated, and he was almost like yelling, angry at Tucker. Every time something happened, he's like, well, if you had a lawyer, this is what I told you this was going to happen. And he's threatened to write a warrant for him to get him there on time. He's cut him off here and there. I don't want to hear it. We've heard all sorts of this. And then Tucker this morning, and this is what I'm going to attribute it to. This morning Tucker says he'd even reached out to the Chief Justice about this motion to disqualify. And the judge, minutes after that, says, well, I'm going to take a minute to do some reflecting. He goes in and comes back after his reflection. And we've had more objections by Mr. Tucker ruled on in his favor than the rest of the trial combined today. We've had a very cordial judge. We've had a very patient judge. We've had, it's like night and day. He went back to his little reflecting pool. Whatever he saw when he looked in that pool, it changed him. He's a different man. Susan Besturk, welcome to the gallery as a new member. Thank you very much. Is that a bunny? That looks like a bunny. It looks like a bunny to me. We used to raise bunnies, but we also used to eat them. So we won't talk about that because I think that's a pet. Steve N., after reading chat during this whole trial, the poll results really amaze me. Well, let me show the poll results, Steve. Just 1 second. And by the way, thanks for 4 months of support, Steve. Thank you very much for that. We're going to close the poll out. We have how many poll? We've got 1,071 votes. So a good third of you have voted. And the votes come in like this. Not proven, 44%. Not guilty, 39%. Guilty is only 15%. Only 15%. It's got to be a worry about an appeal. EDB has all the cursey words. She does. She has the cursey words. It's been nonstop all day in court. We have not even taken a break. I ate my lunch in this very seat. I have not taken a break. You guys, well, you wouldn't know this because I was off camera briefly, but I did not even get up from this chair. This trial is sponsored by Depends. No, just kidding. It's been a long day, and it's not quite over as we've got a little bit more of court with this JOA. Then we're going to have a break. In the morning, we'll start again at 9 a.m. It's going to be quite interesting. So we're not over. This JOA, we're going to have a ruling on that tonight. There's no way the judge is going to say, well, I'm going to take this under advisement, and I'll talk to you in the morning. It's going to be ruling right away. I think it is going to be denied. But it's interesting the way the judge offered this up again to Mr. Tucker. Okay, Corey Hill, member for 1 month, says, I've been here all day long too. Same chair. Thank you very much, Corey Hill. Appreciate that. Congratulations on that Blue Courthouse. BG just gifted 5 memberships. They went to Tammy Dunlap, Lacey McColgan, Melody Shuckas, Sandra Oliver and someone without a name. Someone without a name. It just says blank was gifted a membership by BG. I don't know how you do that. How do you have no name? Are you like in the witness protection program of YouTube? Christy says, I'm gobsmacked. They have no physical evidence of tying him to the crime. How can they get this far with the case? The irony shows through, and it's the question that wasn't asked with this last witness. There's a rebuttal witness, as Mr. Tucker is trying to say, why didn't you charge April? Why? I mean, she's been named 5 times, at least as much as Rory, as setting this whole thing up. And the same witness that named me, or no, you just have one person naming me, and you charge me in the crime. And you have a couple, I think it's a couple witnesses that named April, and you didn't charge her or even arrest her or even look into it at all. So that's interesting as well. SF in Texas gifted 1 membership as well. SF, that one went to a well-deserving person named Marianne R. Congratulations, Marianne R. Apple Treasure, witness protection of YouTube. It's a thing. I think it's a thing. Let's see. We did not proven. They're proposing to remove it as an option. That would make it easier for us if we just have a guilty and not guilty instead of having to include this Scottish thing. But it's an interesting concept. All right. This is a wild trial. Lady Draconis. Yes, it is. Lady Draconis, if you don't know, she's a moderator on Law and Lumber, one of our great friends of the channel. Rob up there is amazing, just incredible. He is in LawTube because he is a full-time lawyer, and he does LawTube videos on the side. It's amazing. If you haven't caught up with Rob and Law and Lumber, it's well worth it. He has some very insightful streams. And I imagine with I think Ian Runkle is coming back from Las Vegas, so I imagine they're going to be doing something together here soon as well, maybe on Friday. It's worth watching. It's a lot of fun. Let's see. I agree a JOA would save the state. Fell asleep. What are we waiting for? Karen, we are waiting for them to come back from court, or come back to court. Let me show you. Right here. Mr. Tucker is preparing his thoughts for making a JOA. A JOA is a judgment of acquittal motion. This is where he says, Your Honor, I'm renewing my motion for a JOA, which is that the judge at this point look at everything that's happened in the case, look at all the evidence in total in the light most favorable to the state, and determine that the state has not met its burden and that they have not proved the elements of the case, and thus you're going to enter and spare the jury the time, because legally they can't reach that conclusion because the state hasn't met its burden. And so spare the jury the time and just go ahead and say I'm not guilty right now, and then it's done. And we walk out of here. So he's going to make that motion. He's done it once before. The judge denied that. But I think he's going to do it one more time. Let's see. Let me cut to this really quickly. Oh, not that one. We want to go here. I was going to give you an update on JHatch. JHatch numbers. We keep a running clock here. I've got a server that is dedicated just to this. $208,657,921, $922, and counting. This is the amount that JHatch owes the Kowalski family in this settlement. The actual amount might be a little bit different, but this is close enough. I talked to, for those who are asking, I talked to my son about it, and he went through and calculated this based on the judge's order specifically, and he said that it compounds yearly. It'll start compounding at the new year. So it's a daily amount until the new year, and then it starts compounding. JOA equals judgment of acquittal. Acquittal. It's also referred to as a directed verdict. And there's actually a third way you can sort of get to the same sort of result, which is after the jury comes back with a verdict, there's a motion you can make then, which is a judgment notwithstanding a verdict, where you're saying, okay, Judge, I realize the jury just came back and said I'm guilty, but go back and look at all the evidence, realize that legally they couldn't have come to that conclusion because the evidence wasn't there, and then overturn it. A judgment notwithstanding the verdict the jury returned. So there are many, many options to get there. Sandra Oliver, woohoo, 8 months. That is awesome. Thank you very much, Sandra. Looks like Judge is here. So we have to Move forward with the JOA.
All right, we're back on the record. So is there a motion from the defense?
Yes, a renewed motion for judicial acquittal.
Any further argument, or you're going to rely on your...
I'm actually going to make a slightly further argument, just because there's been new evidence entered in, I guess.
Talk to the mic. Please be at the mic. Please, please, please. There we go.
So move it over a little bit just so the prosecutors can see it. Okay. Your Honor, if I remember correctly, it was a prima facie case is what we're looking at here.
No, actually, that was from the close of the state's case. It's actually the state has to meet a higher burden for when all the evidence is closed. So,
well, I would submit that again, if there's a higher burden, I didn't think there was enough. I mean, there was definitely enough for a prima facie case. I would not have challenged your ruling there, sir. But if there's a higher standard, if you're talking about the jury having no doubt, or at least no reasonable doubt, I would submit that there's no way that the state has presented a case that comes close to anywhere close to beyond a reasonable doubt. I would say that because still we've got my testimony, we've got Ms. Belmont's testimony. Now, again, we've kind of discussed Ms. Belmont's testimony today, and yes, at different times there were different things she said because of different things. I mean, again, this one in the hospital, yes, she was definitely right out of the crime, I guess, and yeah, she was definitely upset. We don't know if she was on medication. We don't know if any of that stuff was because of that. Yes, Danielle Malone can testify to what she said, but she can't testify what her state of mind was. Same thing with, again, when we went through the deposition. Now, that one, I happen to know her state of mind at the time, just because, again, of reviewing videos and everything else. But, yes, there was reasons for that, too, and I'll address those in my close if I have to. The thing is but the state, again, now I just went and testified too, and I don't remember anything in Mr. Mansfield's cross where he tied me into the crime or tied me to a piece of evidence or even impeached any of my testimony. So, I mean, I would imagine my testimony probably weighs as heavily as anybody else's. So with that said, I mean, we go back to the first ones. There was no evidence presented against me from any of the other witnesses except for Travis Johnson. Now, Travis Johnson, again, not only did he change his story when he was on the stand within those 2 days. I remember a couple questions just offhand. I remember, when we asked him if he was not telling the truth about some of his statements, and we went through the whole vacillating thing. And the very next day, he comes in here and completely different answer. He actually says, yes, I wasn't telling the truth. Between the 2 days, again, I would imagine, I haven't had a chance to ask him, but I mean, it definitely seemed like he had a discussion with the state about some of his answers. Now, even the vacillating, again, I had to look that up. I have been to college. I'm fairly well educated, and I had to look it up. I didn't know what vacillating even meant at that point. But yet Mr. Mansfield and Travis Johnson both used this word back and forth like it was a common word. I would, again, submit that, Mr. Johnson probably had a little bit of help with his testimony. Even so, his testimony doesn't match the evidence, and there's some serious inconsistencies in here. Because one of the things that Ms. Paul Belmont says is that Rory Wilson was wearing the same clothes that day that he was wearing that night. Travis Johnson, if I remember correctly, his story was that we go upstairs, change into dark clothes, come downstairs brandishing weapons. So
this is what I mean.
If that's true,
when he tells the story,
then why does Ms. Belmont say she saw and could recognize Rory Wilson because he was wearing the same exact clothes he wore that day. Another one is, again, the inconsistencies in the weapons. Again, the state is trying to put the murder weapon in my hand, what we assume is the murder weapon. We always assume that, I guess. Mr. Wilson's already been convicted on that murder weapon. Rightfully so. His DNA is on the handle of it. You have both victims' DNA and blood on the weapon. I'm not saying, again, that because again, I understand the principle behind felony murder, but they also haven't they haven't given any evidence other than Travis Johnson's word that I was there. And so far, Travis doesn't seem to have had, he doesn't seem to be very truthful, Your Honor, or credible, if I would say.
That was a better word.
So if he's the only thing that's putting me there, then you'd have to wonder if the jury is going to believe him. Now, again, Mr. Mansfield had a chance with me. He could have went ahead and tried to impeach anything I said up there. He didn't. Not one thing.
The judge is about to
that's debatable. I mean, this is real life.
It's
not like a Perry Mason type thing.
No, I get it. I mean, it's not. I'm not trying to be. It's not a showboat or anything like that.
I know that. I'm just saying that. He's not most likely. Mr. Mansfield or any other lawyer isn't going to somehow or other get you to break down on the witness stand.
No, I didn't expect that. But you would expect if they have all this evidence, enough evidence that they're going to bring me to trial and they're going to go ahead and try and put me on trial for murder, you would expect that he would have at least one thing that he could take from the murder and make me a liar in my story. One. I mean, at least one.
Well, who knows what he might be arguing about.
Well, I mean.
Look,
I gave a story up there that, yes, this is what happened to me. And I've never been asked it before until today, as far as, my entire story. Again, in this entire story, to be honest, I mean, even with when the investigators asked me questions, I know we didn't testify to that, but I've never in this entire story, nothing I've ever said has been proven to be untrue. Nothing. And yet here I am. Now, Mr. Johnson, again, there's plenty of things that are inconsistencies. Again, there's nothing that says he's the getaway driver. We went ahead and had Captain Phelps, we played that tape, and look, at great risk to me, I put that tape up there because I also knew that the statements, the incriminating statements, weren't true. And I'm going to have to address that with the jury in the close if that's what indeed happens. But yes, the only thing the only thing that ever said John Travis Johnson was the getaway driver was Captain Phelps. It came right from her. Now, Mr. Mansfield did try and say that Travis offered her, my name without any help from Phelps, and that's completely untrue too. Again, if you want to talk about testimony and going over testimony, I guess, or rehearsing testimony, I don't know. But the thing is yes, when he did that, he asked him, he's like, okay, did she offer, did you offer her Tyrone Tucker's name without being asked by Captain Phelps? No, Captain Phelps, on the other hand, said, we know who the asshole is here. And his answer was, is it Tyrone? That's not exactly saying, hey, Ty did this. That is literally leading a witness into, or leading a suspect into saying it's somebody else. Again, as far as all the evidence goes, there's no evidence other than that. I let the state put in almost every piece of evidence they wanted to. Almost everything they wanted, right? Not one of those pieces of evidence has been tied to me, not a single one. The jury's going to be back there looking at all these pictures, nothing in there. There's not a single piece of evidence that Mr. Mansfield actually put to me, not one. So okay, there's that. And then okay, I haven't made very many objections, but that's also because, again, there's nothing to object. I mean, they can say their story, I've heard it before. And same thing, the inconsistencies are still there. With John Travis Johnson, his stories are inconsistent at best, right? And again, Now we have Miss Belmont. Miss Belmont, yes, we had a few different things, and yes, I'd hoped to have a few more witnesses here. I did, and I'm not going to. That's okay. At this point, I'm not even necessarily sure I need them. Miss Belmont, yes, she went through different periods of time. Apparently, Mr. Mansfield wasn't made aware of the motion that Your Honor granted, letting us talk and letting us become friends. But other than that, it's like, I could tell you the different reasons why she felt different ways at different times and why different things happened with Miss Belmont. There's videos of that too. We discussed putting them on, but again, it wasn't necessary apparently. But there's nothing else, Your Honor. I mean, literally, it comes back down to Travis Johnson. You're talking about one man's word versus another. And at this point, I think I'm much more credible than Travis Johnson. So, I mean, unless the state's got something else that they can bring out, something else that they can show the jury to even suggest the story's true.
There's no more evidence.
Okay, well then...
That's the evidence is...
Then I would suggest, Your Honor, that there is no way that a jury could look at this case the state put on, and that they could come up beyond a reasonable doubt that I actually did this crime. And whether it be felony murder, whether it be robbery, whether it be any of it. Because again, you can't even put me there, other than Travis Johnson. So, I mean, I guess at this point I would defer to the state. I mean, the state, I'm sure, wants to go ahead and be heard.
All right, well, thank you.
Good argument, especially on the end.
Reasonable minds could evaluate this evidence, and if they believe Travis Johnson, they find him credible, then they would convict this defendant. Now, the defendant says, I'm much more credible than Travis Johnson. Well, that's his opinion on his own testimony, but I submit to the court that the corroborating evidence the state introduced to corroborate Travis Johnson is compelling. And if a juror believes that evidence, they can render a verdict of guilty. As far as him letting us move in evidence, he could have objected if he didn't want to. The evidence that we moved in is the evidence we moved in. At the end of the day, the court and the jury has received good and competent evidence from Travis Johnson and from Danielle Malone and from the DNA analyst and from Dr. Steckbauer, and together the elements of these charges have been proven through these witnesses. Now, the defendant put on the testimony of Paula Belmont, and I submit to the court that testimony has been fairly impeached extensively as to her knowledge of that second assailant who would be this defendant. He says nobody puts him at the scene of the crime, but that's not true. Travis Johnson watches the videos and articulates who is who in these videos that we saw. At the end of the day, we have the defendant, all he's put on is the testimony of Paula Belmont and his own testimony. And then there's obviously the jury instruction that's catered specifically to how to evaluate testimony, and if that testimony, if the person giving it has something to gain from it, certainly the defendant has something to gain from his testimony, and so would Travis Johnson for that regard. But Travis Johnson has been consistent in his statement from the beginning until now, albeit a couple of minor, I guess, changes or inconsistencies. The sum and substance of his story has been consistent from the date of the arrest in 2017.
From when he was given it.
To the date of his proffer in April of 22, to the date of this trial and Rory Wilson's trial. And because of that, Judge, the state would request that you deny the motion for judgment of acquittal.
Watch the judge mull over this.
Yes.
Okay, thank you. In addressing Mr. Mansfield's claims here, again, we can go back to he wants to say that Travis Johnson is credible and that he hasn't changed his story. That is not true. Travis Johnson has changed his story many times. Again, if we were looking at the videos, he changed his story numerous times. As a matter of fact, he even admitted that instead of vacillating, he was lying when he first told his story, right? Then he goes ahead and oh, wait a second, Captain Phelps comes by, tells him exactly every single detail and every single part of his story, and yet that's the story that the state still presents. But unfortunately, it still doesn't match the other witnesses or the evidence. The evidence does not put the knife in my hand. The DNA puts the knife in Roy Wilson's hand, contrary to John Travis Johnson's story.
The way he talks about that,
if you want to go again, even to the other witnesses, Roger Ruggett, 2 skull masks, even Paula Belmont. You want to talk about her and her testimony wavering or vacillating. Yes, she does, but she never says, not a single witness in this case has ever said a neck gaiter with Jägermeister all over it, which you would think is fairly recognizable. They want to talk about a beard being recognizable? Well, guess what? So is a Jägermeister neck gaiter, I would imagine, would be too. Again, I don't see anything in here where John Travis Johnson, and I'll tell you what, even his behavior up on the stand, he played really well with the whole innocent getaway driver thing for a little while. But, when he gets upset, it shows. And the other thing is, he also says that in 2017 he was sober. But then he also goes ahead and says, wait a second, I'm doing all this dope, I'm smoking crack, I'm doing all this other stuff. That doesn't sound sober. Then you also have, beyond that, okay, not sober, and then you talk about his story, again, core to his story. How many times did he say, I did it for $50 worth of gas money? $50 worth of gas money. Now, again, comes back on stand, and this is in the same, by the way, in the same cross, he goes ahead and says, at first it's $50 of gas money, now it's because, and I would imagine this is true, because he wants to get high. That's different. So Mr. Mansfield, he wants to say that he hasn't materially changed his story. He has materially changed his story, but he also doesn't match the other witnesses. He doesn't match the other evidence. Roger Ruggett says 2 knives. Okay? That doesn't match John Travis Johnson's story. Now, Paula, again, she has varying stories, and I would submit there's reasons for that, but again, it doesn't match John Travis Johnson's story. Now, John Travis Johnson, sure, he could come up with all that other stuff. He could drive you. He could literally draw you a map, man, for the route. He can literally go ahead and map out I would imagine he could probably map out the whole crime. That would be easy to do if you were actually there. I don't see where John Travis Johnson would have a problem doing that. He's admitted he was there. He's admitted to his deal. Yes, he's getting, you talk about a sweetheart deal. 5 years?
Judge, we're going beyond an argument for judgment of acquittal here.
Well, yeah, to some extent. I think Mr. Tucker, you're probably tipping your hand for your closing argument. But,
not necessarily.
I guess that's not not a mystery what some of the things in the closing.
He's going to go into these things in the closing.
Thank you, sir.
You're getting into quite a bit of detail here.
I'll address one other thing. He challenges my story, right? And he says because I have interests in this. I didn't take a deal, Your Honor. I could have. I didn't take one. John Travis Johnson did.
Yeah, I'm aware.
You talk about what I have to gain.
Decisions.
Well, what I have to gain from this. That's what Mr. Mansfield.
Well, yeah, of course, that's one of the things that any witness is. One of the considerations is what do they have to gain, what's at stake.
Yes, and what do I have to lose, Your Honor? I have a lot to lose.
Your freedom.
I do, and for the rest of my life, Your Honor.
Yes,
not just for a little while, less of my life.
But that's making that point.
That's what he has to gain.
I didn't have to do this.
That's what's at stake.
But I am. And the reason I have my personal reasons for doing this, but it has nothing to do with, I want to gain this. If it was, again, some kind of payment or something like that, I could understand. But no, I'm doing this because I have my own moral reasons for doing this. But again, that's what I submit. Again, you want to talk about who's more credible, who's not. It boils down to, at this point, whether or not you believe me, whether or not you believe John Travis Johnson, whether or not you believe Paula. But there is no physical evidence, and he brought in. And this is one thing I do need to address. He brought in Dr. Steckbauer, which I don't know how that proves the state's case because in
a homicide case.
It proves it was a homicide, but it doesn't.
You're going to have the medical exam.
No, I get that, but okay, how does that tie me into the case? How is that proof against me?
You know, there's an old saying in the law that every hit doesn't have to be a home run. It takes many bricks to build a wall. So
I've heard that too.
That certainly wasn't a home run, but it's all part of a case that's put together that may or may not succeed ultimately.
Well, no, I understand, Your Honor.
You've got to be able to look at that basic process.
I understand, Your Honor, but there's also an old legal term that I've heard before,
tell
too.
me, what is it?
Oh, he's schooling the judge.
A brick is not a wall.
Okay.
A brick is not a wall.
Right.
Okay, they have a brick. They don't have a wall. And again, so...
Flips on
yes,
the judge.
okay, yes, Dr. Steckbauer is part of the case. I would never deny that. And his testimony is definitely valid towards the case. It's valid to say somebody got murdered, this is how they got killed. I don't debate that at all. Same thing with the DNA analyst. Now, the DNA analysts, we covered the whole inconclusive results and how I said they were being used as a positive by the state. That is not the same thing as positive results. And even in that testimony, things that they were trying to use as inconclusive as positives weren't even things that weren't put into evidence. You're talking about the gloves, you're talking about the sweatshirt. That stuff, man, wasn't even found at the crime scene, had nothing to do with the crime, at least that we know of.
We are running out of time.
But anyway, the point is, Your Honor, yes, I understand why they're important to the investigation. I understand that. But I want to know how that proves that I had something to do with their charges. How does that prove their case?
Well, I'm not going to make their closing argument for them, and I'm not going to make your closing argument for you.
I expect you would.
I used to be a trial lawyer for many years. I've tried many a criminal case and homicide cases, so I know a lot of your questions are rhetorical in nature, but as I sit here, I have my understanding and ideas. So in any event, thank you.
No, thank you, Your Honor.
And?
So it is a different standard for this motion. So we discussed quite a bit
oh my goodness.
For the close of the state's case, prima facie case. Okay. Now it's analysis of the entire evidentiary record, the totality of the evidence, and the judge has to ask himself or herself, does that or can that support a verdict of guilt beyond a reasonable doubt by a reasonable juror?
You guys, this might be history in the making.
Is it so devoid of convincing, persuasive evidence that no reasonable juror could find the defendant guilty? And if that's the case, then the judge would rule as a matter of law that there's an acquittal right here and now. So, Mr. Tucker, you're obviously very, very knowledgeable about this case. Very conversant, very knowledgeable. As we kind of alluded to during your argument in the States, and I'm going to look at just one of these jury instructions because you and the state mentioned it. It's 3.94, and the actual verbiage is, did the witness have some interest in how the case should be decided? So, did Mr. Johnson? Yes. Do you? Yes. I mean, and that's the point. The jurors can consider that along with a lot of other things, but that's one of the factors.
He's just he's teasing us out here.
Another jury instruction, again, part of 3.9, weighing the evidence. And it came up in jury selection, interestingly enough. Whether the state has met its burden of proof does not depend upon the number of witnesses it is called or upon the number of exhibits it is offered, but instead upon the nature and quality of the evidence presented. So you obviously feel that the nature and quality of the evidence is weak, shaky, whatever adjective you want to use, and state has a different take on it. I will readily acknowledge you have a lot to argue. You touched upon some of those things in your argument here, and I'm not going to sit here and say that you don't have a lot of things to argue, but I believe that ultimately the evidentiary record is such that I couldn't and wouldn't and be mistaken to rule as a matter of law that it should be taken from the jury's hands, because I believe, depending upon the credibility determinations that they make, that there could be a guilty verdict, and is and would be supported by the evidence. Again, I'm not saying that's what's going to happen. I readily acknowledge your arguments, but I am going to deny the motion based upon the finding that I've made. So we go forward.
Wow. He teased
again, please study these jury instructions. If you have any objections or specials or additionals, that's the kind of thing that we do in a charge conference. I basically work from my Florida standard jury instructions here, as well as the proposals. Some of these, I assume a lot of them come right from the Supreme Court's website. And
they all do, Judge.
They all, okay. So that means there's standard jury instructions. That doesn't mean that
it can still be changed and modified
in
a charge conference.
Proposals or objections. All I'm saying is that's kind of the starting point. So you do need to be prepared to, if there are any objections or additions or the verdict form you find to be objectionable or in need of change, those are the things that we talk about during charge conference. So I think we have ample time, and if there's changes, then they can be made, and actually I think the arguments could start even while the changes are being made. But having said that, I mentioned the length for closing. We're still somewhere between hour and a half. And I guess, unless there's, I give each side an hour and a half. It doesn't mean you have to use it all, but what I don't want to happen is to say, get to an hour and have someone look up to me, either defendant, defense counsel, or the state, and say, Judge, I need more time. I'd much prefer to be a little liberal at the beginning, so we know that when the time is up, that's it. So, hour and a half, but that's the max. The state gets to go first and last. Total amount of time is the same, but the defendant's sandwiched in between. You get the same amount of time. They're going to make a rebuttal argument. The total time has to be equal. I mean, you don't have to use it all, but the maximum is equal. So, unless there's something else, we'll be here at 9 and hopefully have a smooth charge conference.
Thank you.
Thank you.
All right, so they are going to go back. What judges? Hang on. Nope, nothing's happening. All right. The judge had me. The judge had me on that one. Wow, he was so close. He teased it a lot like Judge Carroll did before making a judgment. He teased a little bit and then made his ruling the other way. So, but I'll say once again, this is a different judge than we've seen the other days of this trial. The previous week in trial, this judge has been almost hostile to Mr. Tucker. Very, very upset, visibly and audibly frustrated with everything that was happening that Mr. Tucker was doing, with the arguments he was making, with the emotions he was making. It was something very frustrating. Hey, Mrs. R.A., how are you doing? Are you ready to talk about this case?
Yeah,
Did you?
Did he get a directed verdict?
No. It was close, though. It was close. He thought about it. He mulled it over, and he acknowledged that he had some valid points. Oh, my goodness. Mrs. R.A., I haven't had a break yet today.
I know. How's your bladder?
She says, how's your bladder? It's healthy, doing well, doing its job. let's see. So Mrs. R.A. is back. Do you want to talk? No, she doesn't.
Well, I have a question.
Wait, she has a question. Which means you have to use my stinky mic.
Oh, okay. Okay, I have a question, and I will just be very open. I just walked in the door. I haven't followed this case very much at all, so I'm kind of useless that way. So I just represent the jury if the jury just woke up and started listening today. So that's where I'm coming from.
I'm going to move for a mistrial if that's the case.
So here's the thing that I was wondering in watching. Help me out. Paula, is that her name? The old lady who was attacked.
Yes.
Okay. So watching
Don't call
her
old lady. She was 57. I'm not that far off.
I know. Well, she looks.
I'm
like
young.
life had been really hard for her.
She's had a hard life.
Yeah.
She's had some hard things, some major health concerns.
Yeah. So in listening to her speak right after, and I had so many thoughts as I watched that. I was like, what is wrong with us? I love watching period dramas, and I love how the officer will come in and talk to the people, and he's very polite, and he will give them time, and if you're having a hard time, maybe I can come back in a week or something. And these guys are like mid-stitch. They're interviewing him. I'm like, this is insane.
They're brushing dirt out of the wound. She's wincing from the pain, and they're like, tell us, give me a description again. Did you know the guy? Had you seen him before?
So crazy. So what really struck me was that when we have a traumatic experience, we often do not understand what we have experienced right after it happens, right? So I going to give an example. I'm hoping that I don't get in trouble for this. But one time we were at a bouncy castle place with our kids, and one of my children did a dumb, and he bounced off the side of the bouncy castle, and he fell on the ground, and all I saw was him disappear over the edge. And I was like, oh my gosh, that was a really long drop, and I'm really worried about him.
It's like 6 feet concrete floor.
Yeah, it was bad. So I start running, and as I'm running to go see if he's okay, there's this guy standing in my way. And I remember thinking, dude, either help or get out of the way. And then I got to my child, and he's okay. And
what happened to the guy?
No.
I'm curious, what happened to the guy?
I'm getting to that.
Okay.
So then I decide that I'm done. I can't handle this anymore. We get in the car, we drive away, and I have this picture in my head of this guy's face, which is like shocked and a little bit scared, actually. And it's just taking up the whole picture in my mind, that his face is like taking up all of the space. So I must have been like really, really close to him. And I was asking Scott, I was like, what is this guy's face that's in my mind? I don't understand this. What am I seeing? Who is this guy? And he was like, well, could be the guy you body slammed.
Just plowed through. Linebacker, just boom, leveled him. It's Mama Bear going to get the cub.
Yeah,
and you don't stand in the middle.
Legit.
Yeah, she took him out.
I don't remember it at all. Not at all. I don't remember touching the guy. I remember thinking...
He doesn't remember either, thankfully. Because it was wham.
But I mean, in the moment, all I remember thinking is, either help or get out of the way. But I don't remember the details. And Scott, having observed it, remembered. He was like, you hit that guy. And so I'm just saying that sometimes when we're in a very traumatic situation, we don't remember everything. And here she is, having just had this really traumatic situation, and they're asking her details, and she's doing the best she can. But I feel like, come on, who can give an accurate recital of what's going on when you just went through it?
Someone with more experience.
I am experienced. I can body slam people all the time. Get out of my way.
Yeah, it's interesting. I'll have to keep her up to. I'll have to update Mrs. R.A. Let me update all you at the same time for those that missed some of the day. The way this began, we were expecting Tucker to file a motion a motion to disqualify the judge this morning. He had said he was going to do that. Why?
Because he's the guy.
Because he's the guy. Thank you, Krista. That was perfect timing. No, he was gonna get rid of the judge, and he wanted to have the judge dismissed because he said, I can't have a fair trial because of how you're treating me, because you're saying you won't listen to me and everything. And the judge, honestly,
is that legit?
Yes.
Because I didn't watch the first
I think
part.
there was probably more credibility to that claim than there was to his JOA.
Really?
Okay, and there's some stuff to his JOA. So we're expecting that. Instead, he shows up and he's filed a motion of continuance, meaning I'm going to, we want the judge to put everything on hold, the jury who's waiting in the hall, send them home, wait for 10 days because I have to write this motion to disqualify.
Okay,
so,
I call BS right there. 10 days. It does not take that long. What was he trying to do?
The judge has 20 days from when the motion is turned in, the motion to disqualify, to respond. So he said, we want half of that to write it. And it's a hard motion. The motion requires stamps, dates, facts, figures, receipts, a lot of work. It's a very difficult motion. It's very complex.
Okay.
So he says, we want the time. The judge says, denied. We're moving forward. Well, Mr. Tucker, anticipating that this would put everything on hold.
How does he do that?
He had called all his witnesses and said, hey, you don't need to be here today because this whole case is being on hold because we're doing a motion of continuance. We're doing a motion to dismiss. It's going to be over. And so all the witnesses gone. And the judge says, I ordered you to have the witnesses here. Now you don't have any. We're going to move forward. We're going straight to the rebuttal case.
So he had witnesses called?
Yeah. There's a whole issue there. The judge never talked to him about testifying in his own defense.
Subject matter jurisdiction.
There's no colloquy about testifying in his own defense, and then it went to rebuttal. They argued the rebuttal issues before the judge outside the presence of the jury. Then during the very end of that, Mr. Tucker sees
that. Oh, that was terrible. I apologize.
Thank you, Ricky. Mr. Tucker sees that one of the things addresses him that they're going to. You guys are catch it. My mods, my own mods are playing sound effects over my soliloquy. One of the arguments that's going to be brought up in the rebuttal phase talks about something he said to Paula, and Paula's recounting to them, and he's like, wait, I should be able to cross that. You can't just make a statement about what I said and not have me be able to respond. Well, the argument actually should have been Paula should be able to cross that and say and explain why there was this inconsistency, which she was not allowed to do.
Why?
They didn't call her. She's, they used her initially live from the hospital. She's in the hospital. Then they switched to their deposition, and then they're impeaching her with this material that she cannot.
Somebody just sent me a video of roaches fighting. I don't know who won.
EJF, intolerant. I'm going to turn the sounds down just a little bit. I thought I could trust you. Can Mrs. R.A. get some screen time too if she wants some?
Mrs. R.A. is still in her exercise outfit because she hasn't started exercising.
I think she looks great.
It's been kind of a late day.
Anyway, so Mr. Tucker, he gets fixated on, I should be able to testify. And as soon as he says that, the judge has this aha moment in his head. He's like, wait. You should. I thought you weren't going to. That's why we didn't do the colloquy.
Wait, so his logic, the judge's logic was not, oh yeah, you're right, because of Paula, but he was like, oh dear.
The judge was, oh crap, I just shut down the defense without giving him an opportunity to testify in his own defense. And so he's like, okay, wait. We've already told the jury that Amber's on the phone. We're going to wait, Amber. We can turn it down. You made a sound effect during Amber.
You're in time out.
So he says, I've already told the jury that the defense is done with their case. We're going to bring him back. I'll say, wait, sorry, one more thing. He's going to testify in his own defense, and he does. And during the course of this, especially first thing this morning, I missed this part. First thing this morning,
the jury,
when they're arguing about this motion to disqualify and the motion of continuance, Mr. Tucker says the magic words. He says, I even consulted the Chief Justice.
Dun,
basically
dun, dun.
I went to your boss, right?
We had a nice chat.
I went to your boss, and he says, and I've got, he said something, he had some feedback or something from that. And shortly after that, minutes after that, the judge says, I'm going to go, reflect on this a little bit. And he went back to his reflecting pool and he gazed into the water and he saw a vision or something. I don't know what happened, but it has been a different judge since that moment. He has suddenly become kind. He's become thoughtful. He's become patient. Really? He's helped Mr. Tucker. He's presented. It is like there's night and day. The name tag is the same. The face, it looks like the same guy, but it's a different person inside the body. It's like he's been abducted by aliens and swapped out. How's that for a conspiracy theory? Swapped out with somebody else who cares.
Because
the first one didn't give a dang. Didn't give him. Amber's calling again.
Somebody warned him. Somebody said, "Hey, you are on thin ice."
Either he made a phone call and somebody's like, "Yeah, about that. Be careful." I don't know what happened, but this is a different judge, and the rulings have been very different. And we saw that in the way he handled the JOA. Maybe he had a lot of Fireball. A little bit of cinnamon helps everything, but yeah, it's been incredible. So we have the Mr. Tucker testified in his own defense. I think he did a a good job. It was spicy. I've never seen before a pro se defendant making objections from the witness stand under cross-examination and winning.
Yeah.
And those happened a couple times. That was incredible.
How do you think he did? As somebody whose life is on the line and it all stops here, how do you think he presented himself?
I would say my biggest argument against how he did is that his story was not fluid, that it did not flow, didn't tell the story. He never said the magic words, I wasn't there, I didn't do it, it wasn't me. He instead gets up there and says, you can't prove it. And that doesn't carry the same weight with the jury. It's like bring it, prove it. You know, you say I did it, prove it.
So it could be that he's guilty and that he's sort of walking that line, or it could be that he's just been swimming in this for so long he can't remember what questions people really want to hear answered right at the beginning, the first time that they've heard the information.
Yeah. Anyway, did I give a synopsis on everything? He testified. We had the rebuttal. He handled that pretty well. I left right when they were doing. They were reading the deposition. The prosecution was reading the deposition, and as I was leaving, I was like, "What is why?" The emphasis that the prosecution put on the deposition is the sort of emphasis that I've been putting on Sarah Boone's letters, which is fine for my channel, but not okay for court. As he's stressing, he's like, no, this is still Paula's here talking to, and adding, interjecting, and thanks, David, for the drink and everything else. It was just not a professional reading of the deposition, which I think we could have seen much better. We saw better in the skier case with Gwyneth Paltrow, where we had those two attorneys that I think they started dating after the experience, that were reading the parts back and forth to each other. This guy has no future in audiobook recording. Yeah, he's probably not going to read your next John Grisham. So anyway, where we're at now, we're over. The case is over. The judge, he weighed that JOA. Alex stole it. I would say that's the first ruling that I've heard from the judge where he has provided that level of depth of thought. And honestly, I think he made the prosecution sweat just a little bit. I think if they checked their armpits, they'd be like, yeah. Aren't you glad you used dial? Yes. Need a little more deodorant or something. But it was... Do you think this is enough? Like, obviously, he should have done the colloquy. Colloquy? Colloquy. Yes, I believe that alone is grounds for an appeal. Okay, but he's got to be the judge has to be feeling like he's got grounds for an appeal, so I need to change my ways and become the repentant, amazing judge. Somebody just sent me a video of roaches fighting. I don't know who won. I don't know if it's enough. But it's going to go to the jury now after the judge has ruled about this. Ask Mrs. Ari about closing arguments. Did they have them? No, they're tomorrow. What closing arguments? Did Amber send you something about closing arguments? I don't know. She hasn't read her email if you did. All right. Anyway, it was almost granted. It was close. The judge gave it some thought, some hard thought. Oh, I know what she's talking about. That you feel that in closing arguments they can read a dictionary, and everybody says no, it has to be based on what has already come before. Yeah, and I realize they can't read a dictionary. I realize they can't stand up there and pontificate on why Pluto should be included as a planet. Hey, Pluto's got a fair hearing on that. I'm not talking about that, but there's leeway. There's some give and take. There's a little bit of flexibility there. I think at least this is my take. At the beginning, I think that it can be a lot more focused on drama. Like a little bit of acting, a little bit of emotion can be brought into it that really they don't want to hear that during the case. Although, can I just say, guys, I was so bugged when Paula was giving her statement or whatever. She's in the hospital. Sent me a video of roaches fighting. I don't know who won. and they're cleaning out her wound, and she starts crying. And all of the professionals in the room are like, oh, look the other way. I'm going to ask my question, and I'm going to keep fixing her up. And I was like, well, for crying out loud, can somebody find their humanity and just give that woman a hug? Goodness. Yeah. It was... Now you guys are all talking about Pluto. And this is why you can't talk about Pluto in closing arguments, because you get sidetracked. No, but I do think that the closing arguments need to be confined to the information that they have presented. Otherwise, they could just come out and say... well, this is my alternative thing. Like he was trying to say, he was like, what about this other lady? Why didn't you follow up on her? I'm like, you can't do that. You can't put somebody else on trial halfway through your trial. But is it not true that the prosecution presented through evidence through questions and answers from Mr. Tucker, information about Mr. Tucker's beliefs about this investigation.
I don't know. I didn't hear that
They
part.
did. They asked him. And Amber, you're banned, by the way.
24-hour time out.
Take the day off.
I also called somebody a name. I didn't even realize that I had done it. I was just like, what a little putz. And then I was like, oh, shoot.
Language.
Name.
This is a family show.
Sorry. Sorry.
All right. Anyway, we're excited. Tomorrow morning, they're going to do a charge conference first. The judge is not going to call the jury there until 10 o'clock. So we've got about an hour of charge conference. This is where the two sides are going to get together. And yeah, she's talking about golf putts, just for the record.
No, I think I called him a jerk.
Okay. You can't say that on the air, says Vermillionaire. I'm not even sure if you know what it means. Don't talk about it.
I must not.
Yeah.
I don't know why I'm getting this kind of a reaction. I thought it just meant jerk.
No.
Okay, sorry.
Anyway, so first thing in the morning, they're going to talk about the charges. They're going to talk about the instructions to the jury, the verdict form, and everything else, and how they're going to fight with that. It sounds like the state has just copy pasted everything that the Supreme Court has in the template and the template ones. We'll add beeps in post just to sketch it. Get your work cut out for you now. It's a different spelling, but the pronunciation is the same, so you don't know which one she said. Anyway, so that's going to happen first. After that, we're going to go to closing arguments. It's going to go to the state first. They get the first crack at it because they have the burden of proof. Then Mr. Tucker goes, he responds, and then the state closes. And when the state closes, then it's done. I think probably before the closings, we'll have jury instructions. Some judges read them after, some read them before. I've seen it both ways. But either way, tomorrow we should be in verdict watch, barring, say, Mr. Tucker walking into court with a judgment to disqualify the judge, or a motion to disqualify the judge. If that happens,
does he have to do that soon in order to get it, or can he?
Well, he has to do it during trial, or else it's over.
Gotcha.
So he's got tomorrow or not at all. Ricky C says, thanks so much for today, RA, and going all day. Thank you, Ricky. It's been a pleasure. It's been absolutely gripping. We've had great people. Once again, we had Tucker's wife with us, Lauren. Thank you for the information. She was able to call in and talk to us a little bit today. Let us know it was a surprise to her that he was going to testify in his own defense as well. She's like, I'm finding out just as you are.
Isn't it awesome being married? Oh, that's fun.
Yeah, it's good. Let's see. We have. I want to show one more thing. We've got to the thumbnail. We've made a couple updates. I think I have to add a couple more as well.
I'm curious. Have you done any sort of a feedback from the chat? How people are feeling about this case? If they feel like he's guilty or not guilty, or flat out
like a poll.
Yeah.
Yeah, we did a poll. Like what was it? 15% say he's guilty. The rest say either not guilty or not proven.
Okay.
60, right around 65% of chat believed Mr. Tucker on the stand, said he was credible.
Okay.
So we've done a few polls throughout. I think that the possibility of a hung jury is very high on this one, because there's no middle ground. Honestly, there's no middle ground with the way the ruling goes. I know they've talked about lesser includeds, and you can watch the video about the candy bars about lesser includeds and how that works. But
I think lesser includeds is cheating.
If he was there, they're gonna pin him with all this, and if they can prove he was there. So if you believe he was there, he's guilty of all this. Because there's a dead guy on the floor. At the end of the day, there's a dead guy on the floor. Matt lost his life over this.
I know.
And
So
if
sad.
Mr. Tucker was involved, the jury should convict him. That's the way the law's written. And convict him for the robbery, convict him for the assault, for everything.
So just like if he just witnessed it.
Yeah, if he was a willing participant, if he was going along with it, if he was just a witness. I mean, Roger was a witness and he's not charged because he was a victim as well. But the way the law's written, I don't see them going to lesser included and saying, yeah, we'll just go with manslaughter. No, you can't. You can't do that. I don't think that would happen. Anyway, we've got the thumbnail up here. Let me show you what we have. Sorry, I made my face go away, but we have added. Oh, that's not the latest and greatest. I've got a new one.
What?
Hold tight.
Is
Mrs. R.A. Mrs. R.A. Hang on. Download this.
This is a thumbnail. Thumbnails are tiny. Can you guys even see these details when you're looking at it?
Yeah, don't listen to her, guys. Let's see.
It's SVC. Isn't it supposed to be CVS?
Well, no, because CBS would sue us if we put their name on there.
Oh, good call.
Okay,
Good call. Mirror
here's the
mapping.
update. We've added a brick. So there's a brick. There's a brick by the butler. A brick is not a wall. This was Mr. Tucker schooled the judge. The judge said, "There's just there are these sayings about takes bricks to build a wall, whatever, or something like that." And Mr. Tucker said, "Yeah, but there's another saying in the law." And the judge was like, "Oh yeah, what's that?" He said, "A brick is not a wall." The judge was like, "You're right." So we have a brick.
Wow.
But that's our thumbnail. I think was there anything else we had to put on there? We have the circus tents in the background. We have the butler.
I hesitate to ask, but what is
everything
with the
on there
circus
has
tent?
a reason. This whole trial has been a circus. Everything on there has a reason.
I must say that I am quite impressed with him. I was just summarizing it for our son as we were driving, and we were late. That was my bad. And so I was telling what I knew about this case, and I thought, he's having to play.
We do need a fireball. Hang on, I'll do that right now.
He's having to play a lot of different roles in this. He's having to be the attorney. He's having to be the main witness, the defendant. No, he's not the main witness, but he's the defendant. And he's also having to play the outside game where he's having to keep track of the media because he feels like that's a pertinent and integral part of this case. That's why he decided to go pro se. So I just think there's a lot going on. This guy probably has ADHD or something to be able to keep track of all of it. It's just crazy.
Why can't I spell fireball?
It's hard and it's late.
I pushed B one time and it did like B B B B B.
It's your B key.
It is. Okay, we need a fireball. This one. This is it.
I think that's a video.
It's a photo.
Is it?
It's a photo. So watch. If we edit the photo and remove the background. Just like that. I tell you, Photoshop is easy, guys. Here we go. This is going to be our fireball.
Nice.
Let's move it somewhere where
Tilt
I can
it,
see what's happening.
And we are Sodom and Gomorrah. That's awesome.
Okay, there we go. No, that was salt, I think. Okay,
no, she was salt.
Oh, okay. It was lava. Okay. We're going to have it. I think it should be in the sky, like heading towards the circus tent. So I'm thinking like right up here. There's the fireball.
Nice color contrast. That's nice.
Hey, it's boom. Fireball's here. All right. So we've got that. This is going to be our thumbnail for tomorrow. I think that's Woody the Cowboy. I can't. Pixar and Disney would sue me. They would be all over this.
Yeah, they're not nice.
Because look at the options. If I don't know, if I type Woody in here, I'm not sure.
Yeah, I am sure. Don't do that.
Cowboy. Pixar
Just,
Cowboy.
Yeah, say Pixar. But I think you have to actually highlight the search bar.
I'm doing it on the wrong video. Hang on 1 second. Let's do it up here. I was doing it on I've got it open on multiple windows. Pixar.
Where's his motive?
Cowboy.
Yeah, I just showed up today, so I don't really know. There doesn't seem to be a motive for me. Also, his life is so sad. I listen to how they're living, and they're like, well, this person was just beating up that person, and they punched him in the nose, and this, that, and the other thing. I'm like, oh my goodness, it's a rough life you're living.
Okay, this is me Googling what Woody looks like. Oh, okay. All right, so we've got that. This hat's going to have to be good enough for Woody.
A reflecting pond.
Reflecting pond. Oh, that's a good one. Okay, you guys, I was going to be done with this.
You want to put the hat on the butler?
Hat's going to be over here. We're going to flip it around. Image flip horizontally like that. So it's sitting on top of it's sitting on top over there. It's got to be a little smaller because it has to fit on somebody's head.
This trial needs to end soon because there is no more room on this thing.
We've got half the screen left. We're fine. We're fine. Okay, so what was the last one I just said we needed?
Reflecting pool.
Reflecting pool. It's got to be a graphic of a reflecting pool. These are awful.
Yeah, I don't think... Does nobody have a reflecting pool anymore? What is this?
What's another word for what we're looking for? I mean, it's like a crystal ball type thing, but
Yeah.
The water cooler for the judge. We have the butler.
Oh, is that who he is? This is the bailiff butler?
Bailiff butler.
Nice.
Okay. You need a finish line and then cancel it.
And move the finish line.
A for rent, $350. at $350, or was it 300? I forget. For rent.
It did sound like, I don't know, it sounds like a book that I would pick up and read for entertainment, that you've got all these different characters, and, well, I knew that guy, but I just, in passing, because I was going to rent from him, and that's the last time I heard of him, and I knew that lady because, you know, we're sort of in the same area, and we interact with each other, but not a lot. We don't really hang out, and I really don't like this person, but we do party together. I'm like, this sounds like something that I would read in Miss Marple.
That's a bad one. I need a better one than that.
My kids were absolutely appalled.
There's snow on this one. That's no good. Hang on.
When I got to the part of the story where I said, and they put him in jail, and he was there for 2 years, and they're like, what? Without a trial? And I thought, yeah, that's how that went.
We need for rent. I need a sign where I can put $350 on it.
These are big decisions.
Okay, well, I'll weigh that option. We'll leave it right now as is. This is going to be...
Maybe a pond? A clear pond instead of a reflecting pool?
Just a regular little pond.
Is there anybody still watching? Is it just us trying to find the right pictures?
I can tell you. There's 2,141 of us looking for the right picture for this.
And this is the best choice you guys can make with your time right now.
This is time well spent. This is really good. Okay, we're gonna see if we can put a little reflecting pond in here for the judge. There we go.
Well, you have the judge up there in the truck.
Yeah, but he's looking towards the reflecting pond.
It'll work.
Okay, we have a little pond. All right. That's it. We're no more ads right now. No more ads. I see you guys. You've got Zen Garden, pond, gazing ball, reflective mirror. All good ideas. All good ideas. Everyone's saying a gazing pool. I'll type gazing pool in here, but I didn't know that's a thing.
Don't shame me. I cannot stay away from this unwatchable case. No shame. We are all here with you.
Who said that?
Dinah Cox said that.
Oh, that's funny. That's really funny. All right. Hey, Diet Coke Mama.
Hey, lady.
All right. I think that's it, guys. We're gonna jump back here because not there, like this. There we go. Because it's been a long day. We need Big Scott. Big Scott needs a big break. Is what we need. I think we're done. Tomorrow we're going to pick this up where we left off, and we're gonna. It's called scrying. The scrying was done. Somebody did some scrying on a video. I'm not sure who it was. I think that was on Brandy's channel. There was it was on Judge Boyd's channel. One of the prosecutors had like a little chain with a weight on the end. She's like swinging it around.
Are you kidding me?
I think it was like a pocket watch.
Like finding the water?
I don't know. It was like dowsing for something, dowsing for a victory. But
well, that just inspires faith in the whole process.
What time tomorrow? They're going to start at 9:00, which means we're going to start at 8:45.
Why do you people hate me?
You just have to exercise sooner. I'm
just going to exercise tonight and have it count for tomorrow.
Deal. All right, so we're going to start at 8:45 tomorrow. Once again, you'll be looking for that new Treehouse with the fireball thumbnail. It's getting a little crowded, but that's where we're going to go. And we'll be back tomorrow to see how this one ends, because I think it will be ending tomorrow. I don't anticipating the deliberations on this one going for days. I think it will be a short deliberation. We should have a verdict by tomorrow night. And it's hump day tomorrow, so we get that as well. First person in chat tomorrow also has the privilege, the honor, nay, the responsibility of being responsible for the internet and everything connected to it worldwide. So if you'd like that to be you, all you have to do is click the subscribe button and ring the bell, and then just be the first person to successfully enter any sort of comment or letter or command or emoji in chat, and you can win. So this is the first time Mrs. Ari's been on headphones with me.
I know.
For the
I
outro.
hear music. So don't try to talk over it.
Yeah, don't talk over it. That doesn't work. We're trying to finish here.
I know.
we were on together, and I was playing music on the podcast. She could not hear it, and she just kept talking and talking. And I was like recycling the podcast music because she's like, and another thing.
I had things to share, you guys.
Yeah, it's fun. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. It will be at 8:45 tomorrow morning. Bring a friend tomorrow. It's Hump Day. Bring a friend who won't be scared off by the Hump Day yell that happens right like first thing, like 2 minutes into it. That's going to happen. So be prepared for that. Whoever ran the internet today was slacking in my neck of the woods. So speak lifeguard. I'm sorry. All right. Thank you all. You guys be good to each other. We will see you tomorrow. And wait. I have to get the picture ready. I screw this up. There we go. Right picture's ready. Everything's set. All right. Now we can go. Have a good night. Is there somebody we need to raid? Is anybody? Any suggestions really quickly? Because we're almost out of time. Let's see.
I was kicked back, taking it easy.
We could raid Melanie Little. Let's do that. Let's raid attorney Melanie Little. She's talking about Karen Reed. We're going to go over there. Make sure you click the like button when we land. Thanks, everybody. Have a good evening. We'll see you.
See you guys.
Bye.
For the record, I didn't consent to that night.